Good morning. We're on the record in case number 2022-00402, electronic joint application of Kentucky Utilities Company and Louisville Gas and Electric Company for certificates of public convenience and necessity and site compatibility certificates and approval of a demand-side management plan and approval of fossil fuel-fired generating unit retirements. My name is Kent Chandler. I'm chairman of the commission. Joining me today to my right is Vice Chair Angie Hatton, and to my left, Commissioner Mary Pat Regan. I would ask anyone in the hearing room today to please turn your cell phones to silent or turn them off. And I would ask any of our witnesses that are attending remotely to please ensure that they are muted and their microphone is off until it is time for them to participate. The purpose of our hearing today is to take evidence in this case. Before we get started and before we take public comments, we'll have an injured appearance counsel. So first, for the applicant, I'd ask that as counsel introduces themselves, they go ahead and identify the witnesses that they'll have with them today. So, for Louisville Gas and Electric and KU.
Yeah, Your Honor, Kendrick Riggs with my colleagues at Stahl, Keenan, and Ogden, Mr. Ingram, Ms. Wimberly, and Mr. Crosby. Also appearing with us today are the in-house counsel, Allison Sturgeon, Vice President, and Deputy General Counsel, and Ms. Sarah Judd, Senior Counsel.
Thank you, Mr. Riggs. And then for your witnesses.
Our witnesses are 10, Your Honor. Mr. Crockett, Mr. Beller, Mr. Wilson, Mr. Jones, Mr. Schramm, Mr. Ember, Mr. Sinclair, Mr. Bevington, Ms. Isaacson, and Mr. Conroy.
How about Mr. Garrett?
Mr. Garrett did not file testimony. He is available. He submitted data responses.
I just wanted to make sure because
Yes,
there were a number of data requests. So.
There are, and he is present, Your Honor.
All right, thank you. All right, for the Office of the Attorney General.
Morning, Chairman. On behalf of the Attorney General, I'm Lawrence Cook.
Just you today, Mr. Cook?
Just me today, and during the course of the hearing, other attorneys from our office may be present.
Okay.
We have no witnesses, Your Honor.
Thank you, Mr. Cook. And for the Kentucky Industrial Utility customers?
Morning, Your Honors. Mike Kurtz, Jody Kyler Cohn for KIUC. We have one witness, Lane Collin. He'll be arriving around lunchtime on Thursday.
All right, thank you. You don't think we'll be done by then, Mr. Kurtz? And then for the Kentucky Coal Association?
Good morning, Mr. Chairman. Matt Malone with the Kentucky Coal Association, and Emily Medina is here as our expert witness, but she'll go ahead and speak.
All right, thank you. And Mr. Malone, I have an individual logged in under you. Is this for preparation for cross-examination?
It is.
All right, thank you. Just wanted to make sure you weren't somebody wasn't pretending to be you, Mr. Malone. And for the joint interveners, Metropolitan Housing Coalition, Kentuckians for the Commonwealth, Kentucky Solar Energy Society, and the Mountain Association?
Morning, Chairman. Byron Gary on behalf of Joint Interveners. With us today, Tom Fitzgerald, Cass McCrae, Tom Samar, Cass McCrae, Tom Samar, Gilbert Zelaya, and one witness, Andy McDonald.
Okay. And you'll have
the rest of our witnesses available in the coming days.
that's witness Grevitt, Wilson, and Summer. Is that right? Okay. All right. Thank you, Mr. Gary. And we'll talk about process here in a minute about making our way to the table. For the Sierra Club.
Good morning, Your Honor. Joe Childers from Sierra Club. I have with me Kate Huddleston, Tony Mendoza, and Joshua Smith. We have two witnesses, Mr. Levitt and Mr. Guy.
All right. Thank you, Mr. Childers. For the Lexington-Fayette Urban County Government.
Good morning, Mr. Chairman. Todd Osterloh on behalf of Lexington Fayette Urban County Government, as well as Louisville Metro Government. Along with me, Jim Gardner, with the same firm representing both entities, as well as representing Louisville Metro Assistant County Attorney Quan Nguyen, and for Lexington with their Department of Law, Dave Barber. He's not currently present, but may be here participating in the hearing later.
All right. Thank you, Mr. Osterloh. And then that's witness Levitt for both.
Yes, Your Honor.
Both entities. Okay. Along with the Sierra Club. Is that correct?
Correct.
Okay. Mercer County Fiscal Court.
Good morning, Mr. Chairman, Commissioners. Dennis Howard with Howard Law PLLC. I have with me today Sarah Still, who is the Mercer County Judge Executive, as my witness.
All right. Thank you, Mr. Howard. For Walmart.
Good morning, Your Honors. I'm Megan Mullins, with my colleague Carrie Grumman. We're with the law firm Spillman, Thomas & Battle, and we're here on behalf of Walmart. We do not have any witnesses in this proceeding.
All right. Thank you very much, Ms. Mullins. Welcome. And finally, for commission staff.
Nancy Vinsel, Ben Bellamy, and Jurgen Funsale. for commission staff.
Great. I reviewed the record, and public notice had been given, reviewed the actual tear sheet, that it accurately reflects what the order required. I noticed, council, that there was a motion for deviation for the Williamstown Grant County News that
Correct, Your Honor.
ran it on the 17th, which would be, sorry, my math is bad this morning already, 5 days ahead of the hearing as opposed to the required 7 of the notice. We'll address that motion through an order, but we're going to go ahead and continue with the hearing today, given that it ran in the other 88
The two
counties
largest
that the
newspapers in the
utilities serve.
state, the Courier and the Herald Leader, published the notice correctly.
Okay, thank you. Other than petitions for confidentiality and the motion for a deviation from the publication, are there any motions or petitions that we need to take up?
Your Honor, I have one motion, and that is a motion for leave to admit into the record of evidence the stipulation between the companies in Mercer County.
That'll be fine.
Filed earlier last week.
Grant that from the bench. And we'll take that up after public comments as well, because I suspect it may be easier to deal with that at the outset of the hearing as opposed to waiting a bit. I know the judge would probably has better things to do. So, all right, we will take up that motion, or I'll grant the motion, and we'll take up the stipulation after providing for public comments this
The
morning.
motion is unopposed.
What's that?
The motion is unopposed.
All right. Pursuant to the public comment that was provided in the newspapers of general circulation, anyone interested in providing public comments today virtually could do so by following the instructions on the commission's website. Those instructions were posted all day yesterday. As of about 9 a.m. this morning, only 2 individuals had indicated their interest in providing public comment. We will take the virtual public comments first this morning and then move to those comments in the room, just so that we can reduce the number of virtual computer things that can go wrong. So the first public comment, well, given the number of public comments that we expect this morning, we're going to limit public comments at this meeting to 5 minutes apiece. We'll go and give each one of the 2 call-in public comments 5 minutes, and then we'll provide people an opportunity 5 minutes apiece in the room. So first, the first individual to indicate their interest in providing virtual public comments is Maria Stark.
Hi, are you able to hear me?
We can hear you. Please provide your name and the city that you live in, and then after you start your public comments, we will start the clock at 5 minutes, and then when it gets close to time, I'll give you a heads up, and at 5 minutes, I will let you know when you've run out of time.
Okay, thank you. Hi, good morning to the members of the PSC and staff. My name is Maria Stark, and I live in Louisville. As stated in the previous public meeting presentations before this hearing, every utility shall furnish adequate, efficient, and reasonable service at a fair, just, and reasonable rate. I believe that the current request before the PSC in this case to replace retired generation plants with polluting natural gas plants is not the most reasonable way to meet our needs as ratepayers. Based on what I've learned, LG&E and KU have a lot of room to invest in energy efficiency, but it remains missing from this replacement proposal for the retirement of fossil fuel generated plants. As a customer, I need to be able to afford my bills now and in the future. This plan is not offering savings to the ratepayers like it could with more investment in energy efficiency. Both the Lawrence Berkeley National Laboratory and the American Council for an Energy Efficient Economy have found that the savings weighted average levelized cost of saved energy, or LCSE, is approximately 2 to 3 cents per kilowatt hour for energy efficiency. This is lower than the levelized cost of energy of other least cost generation resources like wind and utility scale solar, and beats combined cycle natural gas costs. which run between 4 to 7 cents per kilowatt hour, according to their research. Energy efficiency remains among the least expensive ways for utilities to meet the demands of customers like me. This is a prudent investment in mine and other ratepayers' money and is very reasonable. Also, like many customers, I am concerned about the long-term costs to ratepayers of climate change. That includes the cost of maintaining grid reliability and resiliency in the face of extreme weather, which is now more common than ever. ACEEE's research has found that energy efficiency can help support reliability and resilience through reducing demand and providing predictable long-term capacity relief. As a ratepayer, I want a least cost infrastructure plan that includes energy efficiency as an essential component. The current proposal is not it. In fact, the current proposal seeking new gas plants is news to most of us because it was not included in the 15-year plan presented to this body and the public. They want us to make a 40-year investment, accepting the financial costs as ratepayers to our bills, our environment, and our health. Over a period of 10 years, between 2009 and 2019, the cost of wind and solar, which unlike fossil fuels, do not externalize pollution costs back to me as the customer, fell 70 to 90%, attributable to factors like improvements in technology. And more advancements are clearly on the horizon in battery storage alone. So as a customer, I don't want to be stuck paying for less efficient, more costly, and more dangerous energy generation facilities when other sources will be better for our bills and our livelihoods. The utilities industry would like us to believe that 40 more years of natural gas pollution will not increase the threats posed by climate change to the reliability of our energy grid. We as customers, we're not buying it. We need an energy transition now, and energy efficiency should be a key component of any replacement plan for dirty coal firing plants. We want less energy use, better savings as consumers, and safer, a cleaner future for energy generation. Thank you.
Thank you. The other individual that signed up to provide public comments this morning virtually is Furwa Ini Axelom. Furwa Ini, are you there? Furwa Ini, can you please speak if you can hear us? Dropped out.
This is Maria again. There's no one else on here that I can
Okay.
see.
Thank you, Maria. Yeah, he dropped out of the room. So what we'll do is we'll move to comments in the room and then come back to virtual comments. All right. If there's anybody that would like to provide virtual comment or in-person comments, I'd ask that you come to the microphone here. It should be turned on. State your name, city that you're from, and provide your public comments. Again, given the number of comments that we expect. Furwa Ini, can you hear me?
I think they were just muting the microphone.
Okay, muting the microphone. Great. All right, so if anybody would like to provide public comments, please come to the microphone and do so. Ask that you limit your comments to 5 minutes, and then at 4 minutes, I will raise a piece of paper to indicate that there is 1 minute remaining in the comments that you provide. Again, please make sure you mention your name, the city that you're from, and I won't start the clock until you actually start providing substantive comments. So please proceed.
Good morning.
We'll turn it up. It'll
Thank
catch
you.
up. Yes.
Thank you. Good morning. I'm State Representative Kim King. I live in Harrodsburg, Kentucky, and I have the honor of representing, pardon me, Jessamine, Mercer, and Washington counties in the Kentucky General Assembly. Earlier this summer, I submitted my official remarks into the database online, so you had those official remarks. Today, I just wanted to mention the solidarity that I have seen locally. In this day and age, it's very rare to see everyone in a community completely on board and in total agreement with any kind of policy issues. But that's exactly what we've seen with this issue facing us in Mercer County. Our local, state, federal delegations, our local communities, nonprofits, everyone is on board. So I totally support Judge Executive Sarah Steele and her position before you today. I appreciate your service and thank you for the opportunity to briefly add my comments today. Thank you. God bless.
Is there anybody else that would like to provide public comments this morning?
Good morning. My name is Alexandria Vibert. I live in Bullitt County. I'm also here with some of my members that are affected by these rates increases as well. Today I stand before you to express my strong objection to the proposed utility rate increase put forth by Louisville Gas and Electric Kentucky Utilities. While we understand that the utility companies must address operational costs and investments, it is imperative that we critically examine the justification for such an increase, especially in light of the compensation figures of top executives and recent financial decisions made by this company. First and foremost, let's consider the compensation packages of Louisville Gas and Electric's leadership team. Mr. Vincent Sorgi, the president and CEO, receives a $9.1 staggering million. Mr. Gregory Dudkin, the COO, got 3.6. Joseph Bergerstein Jr., the CFO, received $3 million. Wendy Stark, the CLO, received 2.4. And Mr. John Crockett received 1.7. These figures are not only eye-watering, but they also raise questions about the company's priorities. When working customers are asked to bear the burden of the rate increase, it is crucial to ensure the financial burden is distributed equitably, and that the sacrifices demanded of customers are reflected in responsible executive compensation practices. Furthermore, let's not forget the compensation of their board members. Craig Rogerson, a board member, $462,000. Phoebe Wood, another board member, $305,000. Keith Williams, another board member, $285,000. These figures further emphasize the disparity between those that are making decisions and the people whose lives are affected by them. What particularly is perplexing is that LG&E, while proposing a rate increase, authorized the repurchase of $3 billion of its own common stock shares, purchasing roughly $1 billion in a single year in buyback. This seems to indicate that the company has the means to allocate significant funds to boost stock prices and benefit shareholders, yet they expect everyday customers to shoulder the financial burden of rate increases. It is also worth noting that the PPL stock price for the last 52 weeks, which is the parent company of Louisville Gas and Electric Kentucky Utilities, for the last 52 weeks has been 27.78 and a 52-week high of 33.71. This company stock has performed well with a 34% increase over the current share price. These numbers cast doubt on the necessity of a raise increase when the company seems to be thriving in the stock market. In conclusion, I urge you, the regulatory body and decision makers, to critically assess the reasons for this proposed rate increase. Is it truly necessary, or is it a result of misplaced priorities and skewed compensation practices? The burden should not fall solely on the shoulders of hardworking customers when it appears that the company has the means to explore alternative solutions. Let us demand accountability, fairness, and a just distribution of financial responsibility, not just to its customers.
Thank you.
Hi, I am Holly Covington. Thank you for allowing me to have my comments on record. I am with a company called Bioproducts. We're in Louisville, Kentucky at 1401 Locust Street. Our company makes a sustainable, renewable, drop-in replacement for coal. The way we do that is we convert biomass into a biocoal. We use biomass such as wood waste, agriculture waste, sugarcane waste, and in Louisville right now, we are using stillage from the distilleries, the mash waste. So it's helpful both to the distilleries and to the state. And let me make myself clear, we are not cutting down trees to make our products. We are using many types of waste. We pride ourselves in having an environmentally responsible biomass sourcing philosophy. The U.S. has about 1 billion tons of biomass waste each year, and about half of that goes unused. Again, I say our product is renewable, sustainable, reliable, it's carbon neutral, and it's relatively low on SOx and NOx. Our product uses existing coal plant infrastructures, and it can be blended with coal if needed. So before LG&E retires their coal plants, LG&E and Kentucky Utilities needs to take a look at other sustainable alternatives like ours. Why pay millions of dollars on just solar when there are other renewable fuels that can be used in existing assets? LG&E ratepayers have paid millions of dollars for these coal plants. So before they are retired, please consider options. As the commission slides at the public hearings referenced, we do meet their criteria. Our fuel is dispatchable, it is reliable, and you can store reserves. So when the commission asks themselves, is the utility demonstrating that alternatives have been analyzed? We believe the answer is no. So please encourage LG&E Kentucky Utilities to analyze our biocoal. It is a clean, sustainable fuel, and we are bioproductsllc.com. Thank you very much.
Hello, my name is Chris Abbott. I live in Bedford, Kentucky. Ladies and gentlemen, I stand before you today to express my vehement objection to the proposed utility rate increase put forth by Louisville Gas and Electric. My objection is rooted in serious concerns regarding the company's track record of occupational safety and health administration violations. While utility rates may need to be adjusted to account for operational costs, it's essential to address and rectify these OSHA violations before considering imposing further financial burdens on consumers. Number one, employee safety. The foremost responsibility of any company is to ensure the safety and the well-being of its employees. It's deeply troubling that PPL Corporation has a history of OSHA violations, indicating a failure to provide a safe working environment for its workers. A rate increase should not be considered until these violations are thoroughly investigated and resolved. Number two, lack of compliance. OSHA violations are not isolated incidents. They often reflect systemic issues within a company. The presence of multiple violations suggests a lack of commitment to proper safety protocols and procedures. Consumers should not be asked to pay more for services provided by a company that has not prioritized the safety of its own employees. Three, misplaced priorities. A utility rate increase would provide the company with additional revenue, yet there is an ethical concern about whether this money might be used to address the company's financial needs rather than investing and in rectifying the OSHA violations. Consumers should not be made to fund a company that has not demonstrated adequate concern for its employees' safety. And number 4, accountability and transparency. It is essential for the company to address the OSHA violations transparently and take necessary actions to prevent such incidents in the future. Consumers have the right to know what measures the company is taking to rectify the situation and prevent recurrence before they're asked to shoulder an increased financial burden. And number 5, value for money. As consumers, we expect to receive value for the services we pay for. It's unjustifiable to increase rates without ensuring that the company is fully compliant with safety regulations and that employees are working in safe conditions at all times. The money consumers pay should contribute to both reliable services and the well-being of the workers who provide them. In conclusion, I urge the regulatory body to prioritize the safety of the employees and the compliance with OSHA regulations before considering any utility rate increase. It is our collective responsibility to hold companies accountable for their actions and ensure that the financial burdens placed on consumers are both justified and necessary. Thank you for your attention.
Good morning. My name is Dylan Mitchell. I live in LaGrange, Kentucky. Ladies and gentlemen, I'm here today to voice my strong objection to the proposed utility rate increase that is being presented by Louisville Gas and Electric. I believe that this rate increase is unjustified and will place an undue burden on consumers. Many households are already struggling to meet their basic needs, and this rate increase will only exacerbate their financial challenges. For those on fixed incomes or low wages, the added cost burden could result in difficult choices between paying utility bills and meeting other essential expenses like health care and food. To support this rate increase, the utility company must present a compelling case that demonstrates how customers will benefit directly from the additional revenue. Clear evidence of imposed services, enhanced reliability, or significant infrastructure investments is necessary to justify imposing higher costs on consumers. In conclusion, I implore the regulatory body to carefully scrutinize the reasons for this proposed rate increase. It's essential to consider the impact on consumers, especially those who are financially vulnerable, and to ensure that the burden is shared fairly across all stakeholders. Let's prioritize transparency, affordability, and the well-being of the communities that rely on these essential services. Thank you for your attention.
I'm going to read a comment that I sent in to you already, just so that I get over my nervousness and frustration. I'm Sue. I'm from Mount Sterling, Kentucky, and this is what I have to say in my comments. This application is nothing short of irresponsible mismanagement of resources entrusted to be used efficiently and cost-effectively. Coal is and has proven to be the most effective and efficient source of reliable energy to power equipment. Converting to gas that is subject to temperature-related pressure drops is both stupid and dangerous, as demonstrated in last year's freeze event. A utility that plays itself against its consumers can only be regarded as irresponsible and out of control. Deny this application 2022-00402. I'd like to add that I'm appalled at the levels of salaries that have been overlooked in an approach to finding more funds for its company as opposed to using trickle-down economics to nail its consumers who have no choice but to use their product. If there were another choice, people would use it. You can be assured that they will start to do that if this continues. This is an absolute abuse of financial fraud. Thank you.
Stephen Savano, LaGrange, Kentucky. I'm here to formally object to the proposed rate increased by Louisville Gas and Electric and present my concerns regarding their practices of wasteful spending through the use of union-busting tactics and their actions that discourage employees' NLRA Section 7 rights. It is my belief that rate increases should be thoroughly justified and in the best interest of both the consumers and the workforce. In the case of LG&E, there are serious concerns about the allocations of resources and the impact to the community. First, I object to LG&E's allocation of funds towards union-busting tactics. Such actions not only contradict the principles of fair labor practices, but also raise questions about responsible financial management. I believe that LG&E should focus on building positive relationships with its employees rather than pursuing practices that undermine their rights and job security. Secondly, discouraging employees from exercising their NLRA Section 7 rights is a matter of great concern. Every worker has the right to engage in concerted activities for the purposes of collective bargaining and other mutual aid or protection. LG&E's reported actions to discourage these rights are detrimental not only to its employees but also to the overall work environment and the quality of services provided to the consumers. In conclusion, I urge the Kentucky Public Service Commission to thoroughly investigate LG&E's spending practices and their impact on employees' NLRA Section 7 rights before considering any rate increase. It is essential that any rate increase request is scrutinized in light of these concerns to ensure that the best interest of both consumers and employees are protected. Thank you for your time in considering my objection.
My name is Dallas Waterfield. I'm from Mercer County. My farm is at the back of the land that has been acquired by BPL, and I am strictly against this thing. But there's four things that I want to mention to you that sustains life: air, water, food, and fire. At the 18 and 1900s, we all depended on air, water, food. They were taking this prime land and they won't put panels on it, which is an eyesore. What do you do with the batteries if they go bad? Do they put them in a landfill? Is it meet EPA regulations to put them in a landfill? What about the toxic waste of them? There was a program on Fox News, how detrimental the solar panels was to the environment. My farm backs up to this land. I can see them from where I live at, pass by them every day. And it's just terrible to take, just think how many loaves of bread, the amber waves of grain were growing there this year. Beautiful, beautiful. Think how many loaves of bread that's essential to life that we should have to live. That's one of the four essential things for life. I don't know anything about the rate increases or anything like that. All I'm fighting for is Mercer County and what's there. Taking some of the best farmland in the state of Kentucky or in the nation and putting solar panels on it. That's a crying shame. That is a crying shame. You better think about life to come. I'm worried about something to eat. And the way LG&E and PPL went about acquiring this land was underhanded. I don't know whether you know that, but our county judge knows, because she told me. The underhanded way they went about acquiring this land. LG&E and KU are a mute issue. Who's going to be calling the shots is PP&L. These people here that represent LG&E, they're a mute issue. PP&L is going to be calling all the shots. I know what it's like to work at a power company. I put the wooden sails around the cooling towers at 3 Mile Island in 1972 and 73. I put them in there myself, me and a bunch of carpenters. And I know what it's like to work at a power plant. I worked at all of them. Mitchell Power in West Virginia. Worked all over the company. I worked for Marley Cooling Tower Company. Built cooling towers all over the world, all over the country. But they come into Mercer County, and to have PP&L up in Pittsburgh come to Mercer County and tell us what we can and can't do, that is absolutely out of the question and wrong. They're in their lawyers and all that kind of stuff. We're country people. We don't take kindly to other big lawyers and come and telling us what we can and can't do. That's a crock of crap. So, that's it.
Is there anyone else that would like to provide public comments this morning? Our individual that wanted to provide them virtually did not come back on to provide them virtually. So anybody that's here or watching this in real time or watching the recording of this prior to submission of the case, I just want to remind everybody that public comments can be provided at any time prior to the submission of the case. The two primary ways to provide public comments are either to mail them or email them to the Public Service Commission. You can mail them to the Public Service Commission at 211 Sower, S-O-W-E-R, Boulevard, Frankfort, Kentucky 40602, or you can email them to the Public Service Commission. We have a dedicated email address, psc.comment@ky.gov. And again, we always ask that folks provide their name and address and identify the case number so that your public comments get into the case for our consideration. Again, the case number in this matter is 2022-00402. So that is it for our public comment portion. We'll move forward. Mr. Riggs, Mr. Howard, would you all like to take up the tendered stipulation before we get started in earnest?
Yes, Your Honor.
Okay. Do you all have anything for the commission's consideration on that, Mr. Howard?
No, I think that Mr. Riggs has already offered the motion up for the stipulation. It has been duly executed by the fiscal court. We even submitted that the court itself has signed off on it. So
Okay.
we've seen a lot of cases over the years where the council can recommend, but then they have to take it back to the city council. We've already accomplished that.
It's not contingent on anything, is what
No.
you're saying? Well, it's contingent on things, but not upon regulatory,
No.
local regulatory approval, I understand. All right, is everybody who participated in the settlement here today in person?
Yes, Your Honor. Mr.
How about-
Crockett for the company.
For the companies, Mr. Howard, is that the case for the fiscal court?
Yes, I
Okay.
have the judge executive.
Okay, so as we have in the past with stipulations or settlement agreements, we'll do the in-person admonishments for everybody that participated in the settlement agreement. And then we will, as long as there are no objections from any of the parties, and I assume you all have talked about this.
There are none.
We're happy to let the judge executive be excused for the remainder of the hearing.
Thank you.
Okay, so if everybody who participated in the stipulation and settlement agreement regarding, or that was entered into between and tendered to the commission between LG&E and KU and the Mercer County Fiscal Court, please stand. I'd ask all of you to please raise your right hand and answer each of the questions. Were you aware of and did you have an opportunity to participate in all of the negotiations that resulted in the settlement agreement?
I did.
Yes.
Did you voluntarily sign the settlement agreement, and do you fully support each and every provision contained therein?
Yes.
Yes.
Are there any provisions in the settlement agreement that you do not understand, object to, or take issue with?
No.
Was any consideration of any kind offered, or were any promises made, other than what is expressly set forth in the settlement agreement, to induce you to negotiate and sign the settlement agreement?
No.
No.
Are you aware of any reason why the commission should not adopt and approve the settlement agreement in its entirety?
No.
All right, thank you all. Would you like to?
Now, at this point in time, I excuse the judge executive.
Yes, Judge Steele can be excused from the remainder of the hearing.
Okay, thank you, sir.
Thank you, Mr. Howard. Mr. Howard, just for my purposes, do you intend on participating in any of the remaining portion of the hearing?
I believe that it is incumbent, and when I filed the motion to intervene, indicated that Mercer County would participate throughout.
Okay.
So I feel that in case something pops up, I would be remiss not to be here to participate in saying.
That'd be fine. I just want to make sure that I turn to you when it's your opportunity to conduct cross-examination, should you feel the need to do so.
Thank you.
Thanks. All right. I'd like to, at this time, talk about how we're going to process the remainder of the hearing. Mr. Riggs, I took that all of the witnesses, from the 10 witnesses plus Mr. Garrett, we'll just call Mr. Garrett a witness for the time being. All 11 witnesses from the company are here already today. Is that right?
Yes, Your Honor.
Okay. And I know from a couple of the statements this morning that a couple of the witnesses from, I know like Mr. Collin, for instance, and folks like that are waiting to come in on Thursday. Have the parties had any discussion about how to move counsel to move back and forth between the table to conduct cross-examination, or an order that you all prefer to conduct cross-examination? Okay.
So, I believe it's going to be the AG first and KCA. And I know that there was an order thereafter with respect to how we were going to kind of take care of the engineers.
That'd be fine. I just want to know if there's an agreement amongst the parties. Okay. So that, I just need to know for my purposes. So the AG would go first and then KCA, is that?
Yes.
Okay. So just somebody holler out, what's your all's agreement? I just want to make sure it's clear so that if somebody doesn't agree with it, they can stand up and say, we don't agree, that's the order that we want to go through.
Your Honor, I have the list in front of me. A number of the parties discussed this, so I don't think there are any objections to it. After KCA, it would be Louisville and Lexington, then Sierra Club, then Joint Interveners, then Walmart, then KIUC, and then Mercer County. They would slot in at the end if that was for you.
That's 8. Company makes 9. So that's 9. Okay. Any objections to that order? All right. So Mr. Cook will first, and then Mr. Malone, you can move forward. At the time that Mr. Malone moves forward, we'll take a short break to allow the same time that Mr. Malone comes forward, if Louisville and Lexington would like to go ahead and take the other seat in anticipation. That way, Louisville and Lexington can go immediately after Mr. Malone. I would ask if KCA would stay until Louisville and Lexington are done with the cross-examination of each witness, and then we'll actually rotate both seats at the exact same time. Sierra Club, you're fine having one at a time. You don't need you won't need both seats to talk back and forth. So at that point, then my request is that the Sierra Club and the Council for Joint Interveners relevant to that witness come up at the same time and take both seats. Same thing, after Sierra Club is done conducting cross-examination, I ask that you all would stay until the Joint Interveners are done with theirs, and then we'll transition again to Walmart and Mercer County.
Your Honor, as we sit here
today, it is entirely possible that Walmart will have no cross for any witness.
That'd be fine.
I'm certainly happy to circulate in and out of the chairs, but to the extent we have any cross, I expect it to be very limited and would be happy to do it from the microphone if that makes anything easier in terms of the musical chairs.
Yeah, and so it doesn't, thank you, but it doesn't necessarily matter for Walmart because you're going to be the last group anyways. So if you choose not to come up, I just assume you don't have, I'll still call out, ask if you have questions.
Correct.
But if you choose not to come up, that's perfectly fine. I just want to make sure everybody has an opportunity to conduct cross-examination from a somewhat comfortable position and spread out and have their documents in front of them.
Is it okay with you then, if I am comfortable with the microphone in terms of not coming up and moving?
That'll be fine.
Perfect, thank
That'd
you.
be fine. And then same thing, Mr. Howard. So if KIUC obviously has a static position, so if either Walmart or you would like to come up after the Joint Intervenors Sierra Club are done, that'd be fine. If not, and neither of you have cross-examination, we'll move on to having redirect. And once the witness cycle is out after redirect, then KCA and then Louisville and or Lexington will have an opportunity to come up and fill those 2 seats as the witness cycles through. Is that fine with everyone?
Thank you, Mr. Chairman.
All right, second thing is, we will take our first recess this morning at 10:30. I'm not a particularly punctual person, but I'm going to hope that my 2 other commissioners help me out this week to be a bit more punctual. We're going to attempt to keep our breaks limited, mid-morning and mid-afternoon breaks limited to 15 minutes. We also anticipate taking a full hour for lunch today at 12 o'clock or maybe a little bit before 12 o'clock. On Wednesday, Thursday, and Friday of this week, we will be taking a 30-minute lunch, and we will be taking it right at 12. That way, if you want to send somebody out to grab something or have something delivered, whatever it may be, we're going to be pretty strict about a 30-minute lunch for the remainder of the week. And then for dinner, we're going to take a break tonight at 5 o'clock for dinner. We'll take about a 40-minute break for dinner, so please make plans for that. And then we will go until about 7:30 this evening. We'll plan on doing that for at least Tuesday night, Wednesday night, and Thursday night. We will break this week at 5 o'clock on Friday. If we're not done, then I'll see you all bright and early on Monday morning, but we're not going to go late on a Friday night. The other thing that I would like to, those are not suggestions, so that's just the case. There is one thing that I would like to get feedback from council from the parties. Does anybody have an objection to starting the hearing on Wednesday, Thursday, and Friday at 8:30 a.m.?
No objection.
Okay, so we will start the hearing on Wednesday, Thursday, and Friday of this case at 8:30 a.m. We will try and go each night to about 7:30. I promise we will not go past 8 on Wednesday, Thursday, and Friday, but we may push up against it on a couple of occasions. We will try to take breaks in the afternoon. I know it's not going to perfectly line up, but we'll try to take a 15-minute break every hour and a half of the hearing. And if something should happen or whatever, we will take a recess as necessary as requested. Anything else on that front in terms of processing? Okay. So given that we're going to be late, and given that most everybody, and I'm only going to say this once, so everybody from the company is here, but for those folks that are not here from the interveners, I'm telling counsel for the interveners so that I depend on you telling your witnesses and individuals from your organizations this. Do not prop the front doors open. It is a security issue. It's a safety problem. Make arrangements after 5 o'clock for somebody to let you in should you go out the front doors. Absolutely do not prop the front doors open. If we see it, we're going to say something about it. But we cannot have our automatic locking front doors kept open. If somebody needs to let you in, please request that someone let you in. All right. I have an order, Mr. Riggs, I think is the order in which you intend to call your witnesses. Can I run through those real quickly, or do you mind to run through them? But I have witnesses Crockett, Beller, Conroy, Ember, Sinclair, Schramm, Wilson, Jones, Bevington, Isaacson, and then Mr. Garrett, should he be needed to be called. Is that?
No.
Okay, please tell me your order.
Maybe I misheard, but let me give you the order, please. Mr. Crockett, Mr. Beller, Mr. Wilson, Mr. Jones, Mr. Schramm, Mr. Ember, Mr. Sinclair, Mr. Bevington, Ms. Isaacson, and then Mr. Conroy.
Okay.
And if it please, Mr. Garrett's available if there's any
That'd be
questions.
fine.
for his
And you're
response.
of course entitled to call your witnesses however you like. It just is helpful to have an appreciation for the order in which you intend to call them. Okay.
Your Honor, I believe the interveners have resolved the order of their witnesses as well.
Okay. Okay. The other thing, just because we do have more members of the public at this meeting than we normally have, there are a number of items in the record that are either already granted confidential status or are pending motions for confidentiality under the Kentucky Open Records Act. Insofar as questions are asked about those documents or cross-examination is conducted regarding the information in those records, we will have to go on to the confidential record. At that point, we will have to empty the hearing room while that conversation on those confidential documents are being conducted. And then once we're done with that portion of the confidential record, then we'll allow everybody to come back in. But I just want to give everybody a fair heads up that that may occur during the hearing insofar as anyone is here while that occurs. All right. If there's nothing else, Mr. Riggs, would you like to call your first witness?
Yes, you please. Call Mr. Crockett.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat. State your name and address for the record.
My name is John Crockett. I'm at 182 Bow Lane in Louisville.
Mr. Riggs, you may ask.
Thank you. Mr. Crockett, what is your business address?
220 West Main Street, Louisville, Kentucky.
Mr. Crockett, did you cause to be prepared and file with the commission direct testimony on December 15th, 2022?
I did.
And did you further cause to be prepared and file with the commission on August 9th, 2023, rebuttal testimony?
Yes, I did.
If I were to ask you the questions in your direct and your rebuttal testimony today, would your answers be the same?
They would be.
Do you adopt and affirm those as your testimony this morning?
I do.
Mr. Crockett's now available for any cross-examination, Your Honor.
Okay. Mr. Cook?
No questions, Chairman.
So, no, that's fine. I just, Mr. Malone was, I think, surprised. So he's getting his things together. We'll take just a second. You all come forward.
Mr. Chairman, I'll advise the commission it's likely that we won't have questions from any witnesses. We'll see how this goes, but it may be that we can speed up the process by having another attorney for certain witnesses come approach at this time.
The only issue with that is we won't know which witnesses that's the case for, so we'll probably just stick with it, and if you choose not to come forward, that's perfectly fine.
Understood.
While I'm sitting down, Mr. Chairman, Crystal from my office, I'm passing out the 5 exhibits, or 4 or 5 exhibits that we had, that we sent out yesterday.
That'd be fine. Mr. Riggs, while we're getting ready here, do you want to walk us through, just for the record, what you all usually do with the computer?
Mr. Lovecamp is available, and per our practice, he will be providing on the laptop, to the extent that the witnesses use a laptop, their testimony and their data responses. He will only share with them what information is already in the record. And that laptop is available for anyone to look at any time.
And does he have, does Mr. Lovecamp have available to him the records of 2023, 122, and 2020, 60, and 61? I think those are the ECR cases that were, I think that was the ECR.
2020 ECR cases?
Yeah.
I don't know. I'll have to
Okay.
inquire.
Okay.
And I'm sorry, the third case was that the Senate Bill 4 case?
It was the application
Yeah,
that got included by reference, and I think there was a request in that case to include the record of the ECR case.
Yes, there was.
Okay.
Yes, there was. So,
And it wasn't both cases, I'm sorry, it was only
the LG&E
61,
case.
the LG&E, because of Mill Creek.
Yes.
Okay.
Yes. The Mill Creek 1 was the subject of the 2020 LG&E ECR case. Correct.
And then a new addition, just for everybody's processing while Mr. Malone's getting things ready here, the other screen up here is the screens that used to be at council's table that we've effectively, I know you got more room, maybe you didn't notice, but you got lots of room now. So the screens that used to be at council's table really were duplicated the screens on the back wall, the larger ones. We removed those from council's table, but put one up so that the witness wouldn't have to strain themselves looking at the larger screen. That's the other screen there, so I just want to make sure everybody was aware. Mr. Malone, are you?
I think we're good.
Okay. Would you like to mark these at the outset, or would you like to mark them as you discuss them?
I think I'll just mark them as we discuss them.
That'd be fine. Ready whenever you are, Mr. Malone.
Thank you, Mr. Chandler. Mr. Crockett, Matt Malone for KCA. If you could, do you have your rebuttal testimony in front of you?
I have it on the screen.
Okay. In broad terms, I looked at your rebuttal testimony, and on page 3, lines 10 through 13, you indicated that providing affordable, reliable, and safe investment for our customers based on least cost considerations is the fundamental key for success of our business. And I'm asking you just kind of a softball here, but you obviously believe that CPCN is in the best interest of the ratepayers, right?
I do.
Okay. Why did you all not perform a residential rate impact analysis?
Well, I will defer some of those questions to Mr. Conroy and others, but this is not a rate case. This is a case to evaluate the justification for retiring units and replacing them with replacement generation.
How do you know the cost to the ratepayers going forward?
The cost to the ratepayers will be evaluated in future rate cases.
Okay. You agree that this case is both a CPCN, but it also involves Senate Bill 4?
There are two separate cases, yes, but technically both issues are here to be debated this week.
And I understand, obviously, with respect to the CPCN, you all did a net present value as opposed to a residential rate analysis. Is that fair?
Generally, that's fair, yes.
Okay. Do you agree that with respect to, I'm going to refer to it as Senate Bill 4, but it's, I don't want to keep saying KRS 278, 264 for simplicity purposes, but with one of the standards required by Senate Bill 4 requires that the companies demonstrate that shutting down a coal plant will not harm the utilities ratepayers by producing stranded costs to be paid by the ratepayers that could be avoided by continuing to operate the coal plant. And I know I'm beating a little bit of a dead horse here, but how did you determine no harm to the ratepayers without doing a rate study?
We have evaluated Senate Bill 4. We believe that the retirements that we have proposed satisfy the criteria of Senate Bill 4.
Well, that's, in all fairness, that's a generalization, and I understand. I can appreciate the answer, but I'm trying to figure out is, for the residential customers going forward for the next 10 years, you agree that the rates are going to be higher, correct?
They may be.
In response to a data request, the companies to KCA 3-29, I believe there was an acknowledgement by the companies that there's going to be increased cost as a result of the stranded cost plus the cost of these gas plants. So do you agree that that's going to impact the ratepayers in a negative fashion going forward from a price standpoint?
We believe that the portfolio that we have proposed is in the ratepayers, the customer's best interest. We have evaluated it in the context of least reasonable cost to deliver reliability to the customers. The portfolio that we have proposed is least cost to the customer across a wide range of scenarios, and we believe it's the optimal generation portfolio for our customers.
With respect to Senate Bill 4, just as a generalization, there is a rebuttable presumption against the retirement of a fossil fuel-fired electric generating unit. What does that mean to you?
I believe that it means that we must demonstrate that the retirement of units satisfies the criteria set forth in Senate Bill 4.
I think more so about the presumption. What does the presumption mean to you?
Your Honor, that calls for a legal opinion.
Generalized speaking, I just wanted to see what he thought that the presumption meant, but if I can move on. Generally speaking, if this CPCN is granted, you're going to incur costs to shut down the coal plants described in the CPCN, correct?
There will be costs associated with retiring coal plants, and there are costs associated with not retiring coal plants.
Well, you're requesting to shut them down, correct?
We're requesting to retire them on the schedule set forth in our filing, yes.
Okay. And if that were to happen, you're going to incur costs.
There will be costs that are incurred.
And who's going to pay those costs?
Ultimately, those costs will flow through to the customers.
Okay. If you also get the gas plants approved, it's true that the customers are then going to be paying for both shutting down the coal plants and the gas plants, correct?
Well, you're talking about coal plants that are 50-plus years of age, are reaching the end of their useful economic life, and there are costs associated with building and constructing and operating replacement generation. That is true.
There's undepreciated costs that the ratepayers are going to pay, correct?
There will be some.
Okay. Do you know what they are?
I have a general sense, but I would refer you to Mr. Beller and Mr. Sinclair.
Fair enough. Thinking of Senate Bill 4 and just trying to think through this, I'm curious, how are the ratepayers benefiting by, well, let me strike that. The ratepayer is going to be paying for both the stranded costs associated with shutting down the coal plants and the cost of the new gas plants if this is approved. So how does this demonstrate cost savings to customers?
I would refer you to the 16, 17, 18 different scenarios that our team has run and provided to this body for an analysis of the cost-benefit analysis for customers.
Well,
across nearly all of those, the customer is better off from a cost perspective with our portfolio.
Here's the thing. You do agree that the first 10 years under this plan that the companies have proposed, it's going to result in higher cost to the customers?
There will be some increased costs, sure.
Okay. Same question. How does this demonstrate cost savings to the customers for the next 10 years?
there is a cost savings to customers over the life of the assets.
But how does that help someone that, for example, on a fixed income that's elderly, that's may not live more than 10 years?
Mr. Malone, I don't know how to speculate about that particular question. For details with regard to the costs associated, I'd refer you to Mr. Beller and Mr. Sinclair.
Fair enough. If the companies continue to operate the coal plants that they're asking to shut down in the CPCN with or without SCRs, the companies could avoid much or most, if not all, of the stranded costs associated with shutting down these coal plants, correct?
I don't necessarily agree with the several parts of that statement in question. The with or without SCRs, that it's hard to look at it in a with or without SCRs. These units will ultimately require SCRs. Mill Creek 1, 2, and Gent 2 will require SCRs to comply with the Good Neighbor Plan.
The Good Neighbor Plan. So, yeah, tell me about the Good Neighbor Plan. Where are we at with that?
Well, the rule is final from the EPA. There are several states that have challenged it, and it is working its way through the court system.
So right now, it's stayed, correct?
For the time being.
Okay. And we don't know, as we sit here today, what's going to happen with the Good Neighbor Plan.
We don't know with certainty, but I believe that the Good Neighbor Plan or something very similar to it is going to become law.
Based on what?
Based on the fact that the EPA has a lot of latitude in advancing the agenda that it seeks to advance. And we are beholden to that.
Just from a timing standpoint, though, back to my prior question, which we kind of talked around, to the extent that the coal plants continue to run, there are going to be less, and I'm calling sunk cost, stranded cost, associated with shutting them down, correct?
I'm not sure I can agree with that statement.
There will be less undepreciated capital, correct?
Yeah, there will come a point in time when, in order to run those units, they will have to have SCRs and other technology.
Okay. The SCRs are a lot more, well, I should say, they're a lot more economical cost-wise to put the SCR on, as opposed to the gas plants, correct?
I wouldn't agree with that characterization. I don't think that you can look at it in a vacuum. I think you have to look at the entirety of the proposal.
The cost of an SCR is less than the cost of gas plants.
The cost of one SCR is less than the cost of one natural gas combined cycle plant, yes.
Did you review the letter filed by the Kentucky Senate President, Robert Stivers, in the record?
I read it.
Okay. Do you agree he has any valid concerns?
I don't agree with much of the substance of President Stivers' letter.
Do you agree that he has any valid concerns?
I believe that there are valid concerns expressed by witnesses throughout this hearing, including President Stivers.
I believe something that he mentioned in there had to do with concerns about reliability. You don't agree with that?
I do not agree that this portfolio presents a reliability risk.
Looking back at Senate Bill 4, one of the requirements, as I read the statute, is that the company is supposed to identify indirect costs of shutting down the coal plants in the record in this case. Can you identify where the companies have done that?
I'll refer you to Mr. Beller in that regard.
Had there not been a good neighbor rule proposed, would the companies have filed the CPCN?
It would not look the same as it was filed.
How would it have changed?
Question calls for speculation.
Yeah, I don't.
Sorry, I didn't gather. Was it his own objection or yours, Mr. Riggs?
Objection, Your Honor. The question calls for speculation.
fine. I can move on.
Withdraw the question?
Sure. Is this, Mr. Crockett, is this CPCN consistent with PPL's net zero policy of 2050?
It happens to align with it, but it was not an output of PPL's net zero 2050. It was an independent evaluation on our part at LKE to determine what's the appropriate generation portfolio to replace retiring generation.
How did the depreciation schedules match up?
You will have to ask someone else about that. I don't know that information sitting here right now.
Okay, because I think it would go way beyond the 2050, correct, for the net zero?
Sorry, I don't understand your question.
One second. Yeah, the 40 years for 2028 with the gas plants, we're putting it at 2068 as opposed to 2050. So I'm trying to figure out how to reconcile those issues with the depreciation schedule on the gas plants.
You're asking me to get into details that I'm
Fair
just
enough.
not prepared to do.
Hey, did you have any part, did you recall the 2021 IRP?
I do.
Okay. I'm trying to figure out, in the 2021 IRP, you agree that carbon capture analysis was part of the analysis involving the combined cycle plants?
It was.
Okay. Then the 2022 resource assessment came forth. Why was there no mention of carbon capture analysis anymore?
I'll refer you to Mr. Sinclair or Mr. Wilson in that regard.
Okay. So I should ask all the resource assessment questions of Mr. Sinclair?
I think that would be wise.
Okay, fair enough. Okay. All right. All right. Just a second. I know that the exhibits that are just. Can you go ahead and just start cycle, put one up, and we'll go through it.
Did you tender copies of these exhibits?
Yes.
Paper?
Yes. I don't trust technology. That's okay.
It's better than having to get clear versions of these and putting them on an Elmo and putting them up on the wall behind us. So.
But I always bring paper copies because I don't trust technology as well. So.
I'll tell you what, just because given the break, let's go ahead and take our mid-morning 15-minute recess, give you an opportunity to, give you an opportunity to get this going, and then we'll come back at 10:35 from a short recess.
Sounds good. Thank you.
Should be our motto here at the Public Service Commission. Mr. Malone, just gonna roll it out and see what we get. All right. All right, great. We're back on the record at case number 2022-00402. Mr. Malone, would you like to continue your cross-examination?
I would, Mr. Chandler, thank you. Mr. Crockett, let's start with the news release. Headline, obviously,
Sorry. You mind, as you
I will.
start discussing something, go ahead and let us know how you'd like them marked?
Let's go ahead and mark it as KCA Exhibit 1 with
Okay.
respect to the news release involving AEP.
It's the August 16 news release. Okay, so mark.
Thank you, Mr. Chandler. Mr. Crockett, could you address why, in your mind, AEP would be spinning off their unregulated renewable assets?
I do not know what this decision resulted from. I'm not privy to AEP's business evaluations.
Well, if I may, there's a quote. This sales part of our strategy to streamline and de-risk the business and focus on our regulated operations. What's that mean to you?
I can't attribute any meaning to it other than what the words say. I don't know. It's not my quote.
Well, obviously, I mean, in all fairness, you all make a rate of return on your regulated assets and not on your unregulated, correct?
That is correct.
Okay. So by spinning it off, I take that to mean that they are looking to focus on where they're getting a guaranteed rate of return. Is that fair?
I don't know if it's
Objection.
fair or
This
not.
is not his statement. He's testified he doesn't know why AEP did this. He has no
That's fine.
knowledge of this.
We'll move on to the next document.
This matter.
We'll just move to introduce and admit Exhibit 1 of KCA.
No
Mr. Rich?
objection.
KCA Exhibit 1.
Okay, perfect, okay. And this is the Executive Compensation Program. This is from a PPO 2023 proxy statement. We pre-marked this as a KCA Exhibit 2.
Okay.
Mr. Parker, are you familiar with this document?
I am.
Okay. As I look at this, I'm going to read this off. It appears that executives at PPL are now receiving performance units based on TSR, EG, and ESG. What does that mean to you?
It means what the document says.
Well, what does that mean? What are you getting compensated for?
Total shareholder return, earnings growth, and ESG,
What's ESG stand for?
environmental, social, and governance.
Okay. And as I read this document, it appears that 80% of your long-term equity incentives include being paid for the closure of Mill Creek 1. In other words, closing a coal plant results in you receiving incentive pay. Is that accurate?
There is a small piece of incentive pay that relates to Mill Creek 1. Mill Creek 1, our analysis has been clear for several years now regarding our beliefs about Mill Creek 1, whether it was a 2020 ECR, the 2020 rate case, the 2021 IRP. That's not news.
Well, are you going to be compensated based on the closures of Brown 3 or Mill Creek 2 or the coal plants listed in the CPCN that are Gent?
Not to my knowledge.
Not to your knowledge. Well, why are you compensated for Mill Creek 1 but not the other ones?
It is an aspect of this particular compensation piece. Mill Creek 1 has all sorts of operational issues, and we have discussed it with this body for 3 years now.
Let me ask you this. When I reviewed the proxy statements, it appears that your compensation changed in 2022. Is that accurate?
there were a number of changes.
Such as?
Amount and particular targets and compensation changes every year.
What were the target changes?
I can't articulate as we sit here today, I'm sorry.
So did you, your compensation, as I look at this document, as you look at the top, it looks like 80%, I should say 72% is performance-based compensation, which includes ESG, which you already mentioned ESG, so climate-related measures. So how would you not be, I don't understand why you would be compensated for, I'm beating a little bit of a dead horse, but I don't understand why you'd be compensated for closing Mill Creek 1, but not if you get what you're asking for in this case, to close these other coal plants. Why is that different?
Well, the climate-related measures in this are specifically designated in that paragraph. There are 3 of them.
Let me ask you this too. How do you all, as PPL, how do you achieve earnings growth other than investing in new capital?
Our earnings are dependent on a number of things. Investing in new capital, investments through our shareholder base.
Does PPL...
Sorry, before you ask your next question, just help me out here. As a function, as a result, I guess, of the, somebody the other day called it a dunking booth, but the protective plexiglass around the stand. I get that when you've been cross-examined for a little while, you get a little comfortable, you lean forward. I'd ask you, and I hope all the other witnesses hear it, however loud you think you need to speak, it probably needs to be about 25 or 30% louder. We do have the speaker over you, so it should be a little easier for you to hear the questions that are asked. But just by virtue of the setup in the room, just make sure you speak up a little bit because it is hard to hear some of your responses. Thank you. Mr. Malone.
Thank you. How else do you get earnings growth if it's not through new capital investments?
Our earnings can grow through rate base.
All right. Just to answer my curiosity, does PPL have any generating assets outside of Kentucky?
Not presently.
Say again?
Not presently.
Okay. So PPL Corporation is going to benefit by the capitalization requested in the CPCN. Otherwise, it's purely transmission?
We believe that the portfolio that we have proposed is in the best interest of customers. And when it's in the best interest of customers, it is by extension in the best interest of investors. So yes, we believe that the company will succeed with this portfolio because it is what is in our customers' best interest. And we're proud of it.
In all fairness, the customers' rates are going to go up at least for the next 10 years. Would it also not be that it's in the company's best interest as opposed to the ratepayers?
Compared to all of the scenarios that we have run as part of this portfolio, customer rates will be impacted less by this from a reliability perspective than all others.
Okay. Let's move on from that exhibit, but we would move to introduce that as KCA Exhibit 2.
Mr. Riggs?
No objection.
Okay. The next document that's up is the executive compensation tables. If you could, as I look at this.
KCA Exhibit 3.
Yes, Mr. Chairman. There is a summary compensation table. How much of your compensation was based on closing Mill Creek 1? Can you identify that?
I cannot as I sit here right now. No.
Why did PPL shift their targets with respect to incentive compensation in 2022?
I would be speculating to some extent, but compensation targets adjust every year. There's a compensation committee at the corporate level. Compensation adjusts every year in publicly traded corporations.
What are the ESG goals of PPL?
There are ESG goals that are articulated in our climate assessment report. I would rather not pick and choose from among those.
Such as?
We have a goal of net zero by 2050.
Speaking of, and I just want to make it clear, so if the gas plant comes online in 2028 and there's a 40-year depreciation, that would push it out to 2068. So how do those reconcile?
The goal is net zero, and there are many ways to achieve net targets. We would be the first to tell you that we and others in the industry still have to identify ways for that to come to pass into the future, technology and otherwise.
If you get what you're asking for, there's no way to get to net zero, is there?
We believe there is.
How?
This is the next time that we are asking for replacement generation. It will not be the last time, and there are 35 years between now and then.
That would be, yep, thank you. And we'd move to introduce KCA Exhibit 3, and then this is pre-marked as 4.
No objection.
This is the second quarter investor update that you'd like marked as 4?
Yes.
Okay.
Should we go to page 5, Kristen? Okay. Are you there, Mr. Crockett?
I am.
Okay, great. For simplicity purposes, I like this slide because it demonstrates in color kind of the point I'm trying to make. Senate Bill 4, as I understand it, requires that there be capacity that matches the closure of, for example, the coal plants. And that's going to be the green and the black on the screen. How do you reconcile closing that much in coal-fired power and not replacing it with capacity that meets those amounts from megawatt per hour?
Objection. Calls for legal conclusion. Council's offering an interpretation of the statute.
Well, just in all fairness, it's just numbers when we're looking at the screen. I don't. How do you reconcile the green versus the black?
Well, what I can tell you is that we believe that the total portfolio that we've presented does satisfy Senate Bill 4 for the reasons that are contained in Mr. Beller and Mr. Wilson's testimony. They've addressed that issue in detail, and I'd refer you to them for specificity.
Well, look, I may be beating the drum here, but it looks to me that the gas consists of 621 times 2, which is roughly 1240, and then the black or gray for the coal is more than that.
I think you're oversimplifying it, and you should talk to Mr. Sinclair about that.
Okay. Let's go to page 13. Okay. This is the PP&L investment highlights from the second quarter. Last line, 9% to 11% total return proposition. De-risked plan does not require base rate cases to achieve. So back to the question I had previously. Outside of new capitalization, how is PPL going to create earnings growth?
I can't answer it any better than I already did.
Doesn't it allude to the fact that it's going to come out of new capitalization as opposed to base race growth?
There will be some of both.
Sure. But the statement says de-risk plan does not require base rate cases to achieve.
That is correct.
So it's, PP&L is viewing this as the capitalization is going to create their earnings growth.
You have to appreciate, Mr. Malone, that PPL is the parent to 3 separate companies, so everything that is contained in this document is not a Kentucky reference.
Well, that's fair, but the point is also that Kentucky's the only one with any generating assets.
That is true.
Okay. If we could go to page 14. What does this sheet mean to you, Mr. Crockett?
I'm not sure how to answer your question. What does it mean to me? It means to me what it says.
Yeah, the projected earnings per share, is PPL predicting that the earnings per share is going to increase to 6 to 8% by 2026?
That is what it's projecting.
Okay. And how is that going to happen?
Well, it's going to happen for the reasons that are expressed elsewhere in this document.
Yeah, but for example, outside of, we've already expressed, outside of capitalization, in other words, the request in this case, for example, the CPCN, PP&L is expecting the money to come from the ratepayers, essentially, correct?
I think we've covered this.
Okay. All right. I've just moved to introduce that as Exhibit 4. Or, I think it's 4.
It is. Mr. Riggs?
No objection, Your Honor.
No more questions, Your Honor.
Thanks, Mr. Malone. We'll give Mr. Malone an opportunity to take his, get back to his spot. Mr. Osterloh, do you have questions for Mr. Crockett?
Just one follow-up question.
Please just take your time. If you all could, Counsel for Sierra Club. Okay, do you want to come up now? You have no questions for this witness. How about joint interveners? Mr. Fitzgerald, if you'll come forward while we're all doing our transition here. Just an aside, so we'll take our lunch at about 11:50 since we took an earlier break, and we'll take a full hour then.
11:50 to 12:50, Your Honor?
That's right. Stand, sit, whatever you'd like. Mr. Osterloh, do you have questions for Mr. Crockett?
Just one question, I guess it'll be short. Mr. Crockett, you were responding to questions from the Kentucky Coal Association regarding ESG goals, is that
Yes.
correct?
Yes.
Can you describe on a very high level why PPL has ESG goals?
We have ESG goals for a number of reasons. Number one, we believe in them. We think they're the right thing to do. ESG goals are important to our investors, the investors in our company, which capitalize investments that we make in generating assets, transmission, and distribution in this state.
Thank you. That's all the questions I have.
Mr. Fitzgerald?
Thank you, Mr. Chairman. Members of the Commission, Tom Fitzgerald representing the joint interveners. Good morning, Mr. Crockett. Mr.
Fitzgerald.
If I ask any questions that are indecipherable, just do not try to guess at what I'm asking, just ask me to repeat the question. And I appreciate the fact that you are the first one up. The last time that we were here in this room with LG&E, it was Mr. Crockett actually it was Mr. Conroy will answer that question. So feel free to say Mr. Beller or Mr. Conroy will answer that question for anything that you don't want to talk about.
I shall.
First of all, let me just get clear for the record. The LG&E and KU, which I'll call the companies, they are subsidiaries, are they of PPL Corporation?
That is correct.
Okay. Are they in any fashion related to AEP?
We are not.
Okay. In your direct testimony at page 1, do you have the testimony handy?
I do now.
You let me know when you're ready. At page 1, you indicated that you were providing an overview of the demand and supply side proposals and that the proposals had been, quote, carefully analyzed and, quote, represented what the companies believed to be, quote, safe, reliable, and low-cost service for customers across a wide range of possible future scenarios, end quote. Did you see it there?
I do, yes.
Okay, and you also indicated the proposal would reduce carbon and other emissions, but that the proposals were consistent with the corporate CO2 reduction goals, but those goals were not considered as an objective function in the company's analysis. Did you see that also?
Yes, that is
Okay.
correct.
I'd like to deconstruct that a little bit. First of all, when you say that it is consistent with the corporate CO2 reduction goals, is that LG&E we're talking about, or the service company, or PPL, or all three?
Really all three, but specifically we're talking about PPL.
Okay, and does PPL have any other generating assets other than those that are in the LG&E and KU portfolio?
It does not any longer.
Okay, so fair to say that any CO2 reductions that would be credited towards that corporate goal would have to come, in terms of generation, would have to come from LG&E and KU?
In terms of generation caveat, yes.
Okay, because they have other things like they're changing their vehicles to be electric vehicles, those sorts of things?
That is correct.
Fair to say the lion's share of any reductions towards that 2050 goal would have to come from changes in your generation mix?
I think that's fair.
Okay, and as I understand, the supply side proposals are retiring Brown 3, Mill Creek 2, and Gent 2, and replacing them with two 621 rated, megawatt rated natural gas combined cycle units. Is that correct?
In addition to a combination of solar,
Right.
6 different arrays, and a 125 megawatt battery.
Okay,
on the
so
supply side.
right, I should have mentioned that, the batteries, the solar PPAs, the 2 solar units, the 120 meg units that you're proposing, and then the DSM and EE measures. Right.
That is correct, on the demand side.
Would replacing these agent coal units with supply and demand strategies that did not rely, or which relied less on replacing the coal with another fossil fuel generating unit, be more aligned with the CO2 reduction goals?
Could you repeat that? I'm just not sure I followed it.
My question is, because LG&E and KU is the source for the company achieving those 2050 goals, largely, the lion's share will have to come from LG&E and KU. Would it not get you towards those goals more quickly to look at non-fossil fuel replacement capacity?
First of all, getting to those goals was not the purpose of this exercise, not the purpose of this proposal for generation replacement.
Okay.
If the basic question is, would something other than coal and gas get you to net zero objectives more quickly? I think it's fair to say that, but it's not fair to say that it would do so reliably and at least reasonable cost.
Okay. And I would look, that's a great opening, because I want to get back to the cost in just a second. How confident are you, because you did mention in your rebuttal testimony at page 2, lines 6 through 9, that the portfolio that's being offered would serve customers, I think, well into the next decade, providing greater certainty with regard to retail rates. And as you probably know, the joint interveners represent an amalgam of interests with several of the organizations, particularly focused on meeting the needs of those ratepayers who have fixed and low incomes. So we're particularly sensitive to and appreciate the concern regarding retail rates. And in your rebuttal, you also stressed at pages 2 and 3, lines 22, and then going over to line 2 on page 3, the principles of affordability, reliability, and safety. And I would be remiss if I didn't express the appreciation of joint interveners for the recognition that affordability is a core principle. How confident is the company that the 2 gas units represent the lowest reasonable cost option?
Extremely comfortable.
Okay. As I understand the testimony from the company, the current cost estimates are in a AACE Class 3, which has a range of potentially underestimating the cost by some 30%. Is that your understanding?
I'm going to have to punt that one to Mr. Sinclair.
Okay. Assuming for the moment that to be the case, who bears the financial risk if those estimates are wrong?
Ultimately, the customer and the company share that risk.
Okay, and that was exactly where I was going to go next. What commitment is the company willing to make regarding that risk sharing going forward? Let's assume that the price of natural gas continues to be as volatile as it was during the last year, that the costs of the units when you do the final pricing is 30% higher? Is that, or when you say the company shares the risk, are the ratepayers going to be met by shareholders assuming a percentage of that risk?
I'd answer your question this way, Mr. Fitzgerald. We ran this portfolio among 16, 17, 18 different portfolios. We ran them against all sorts of different scenarios with high coal prices, low coal prices, et cetera. This is the portfolio that is in customers' best interest on the math coming out of that. With regard to the specifics of that, the risk of one thing happening episodically versus another, I'm hesitant to predict that, but perhaps those questions could be answered a little more completely by Mr. Beller or Mr. Sinclair.
Okay, well, before we leave it, because you did indicate your position would be that the risks would be shared, and I guess I'm just trying to put a finer point on that. You're aware that when there are off-system sales from assets within the LG&E and KU system, that those revenues are shared 75%, 25%. 75% going to ratepayers, 25% going to the shareholders?
I am.
Okay. Is the company prepared to commit to any percentage of that sort of risk sharing for these unanticipated costs?
Not at this point. I'd have to discuss that with the team.
Okay. I don't have that much more, and I appreciate your patience with me. You mentioned in your testimony at pages 5 and 6, you mentioned that this proposal, quote, optimally blends lower carbon and zero carbon technologies to diversify the company's generating portfolio. After assuming the retirement of the coal units that has been proposed and the construction of the 2 natural gas units, what percentage of the company's portfolio will remain coal-fired in terms of generation assets?
Assuming the portfolio that we propose is adopted in full, it would be about 49% coal, about 42% natural gas, and the remainder combination of renewables.
Okay, so in terms of...
I'm sorry, Mr. Fitzgerald. Can I ask a clarifying question? Is that on a megawatt basis or an energy basis?
A megawatt basis.
Sorry, Mr. Fitzgerald.
Okay, no, thanks. So then, and I was a new math kid, and it ruined me for math. That would be 91% of the portfolio would remain fossil fuel fired, assuming that this entire array were were approved?
Approximately, yes.
Okay. And then how much of the remaining 9% would be renewable solar? Do you know?
We have 140 megawatts of hydro. The rest of it would be solar.
Yeah, I was going to ask you about the hydro net, so I appreciate you're making my job easier. So you have 140 megs of hydro. Are you planning any expansions in terms of new hydro projects?
Not presently.
Okay. And have you put any RFPs out for hydro projects?
I don't believe so, and I don't believe that we had any hydro bids in our last RFP.
Okay, so that 9% that remains, how much of that is expected to be met through energy efficiency or DSM measures? Do you know?
I'm not sure I can parse it that way.
Okay.
You might ask others that question, but
So is it fair to say that with the proposed portfolio that would remain 91% fired with fossil fuels, that the company doesn't have a bias against coal and natural gas?
we are agnostic when it comes to our fuel or our technology.
Okay. And would it also be fair to suggest that there's room for more diversity in the fuel mix when 91% of it is still fossil fuel fired?
We believe that that would present a pretty diversified set of generating assets. It would, ironically enough, if we have 7 to 8% solar, that's exactly what Arizona is right now.
And PPL doesn't have any operations in Arizona, do they?
They do not.
Okay. If for whatever reason, now part of that 8 or 9% of the diverse portfolio would be the 637 megawatts of solar capacity that's represented by those 4 purchase power agreements?
Yes.
Is the company willing to commit that if for whatever reason some or all of those 637 megawatts do not come to fruition, that they will replace that like percentage of portfolio on a megawatt basis with other renewables?
I'm not willing to make that commitment sitting here today in a vacuum. We would have to analyze that.
Well, assuming that that it met all of the, the net present value and all of the other, was comparably priced.
Maybe.
Okay.
Sorry, I can't do any better.
That's okay. That's okay. Last couple of questions I had dealt with the DSM and the E portfolio. Assuming the approval of and full deployment of the DSM and EE measures that have been proposed, what percentage of the company's investments would that represent relative to the other investments that are being proposed here? Do you know? Okay.
I do not know.
Who do you think among the witnesses might be able to address that?
You might address that with Mr. Beller, for starters.
Okay. Do you know what percentage of reduction in energy sales would be achieved by implementing all of the array of DSM and EE measures?
Again, I'd refer you to Mr. Beller.
Mr. Beller, okay. Your direct testimony characterized the portfolio as a robust plan for cost-effectively and reliably serving customers for decades to come in a highly dynamic economic and regulatory environment at this time. How far in the future has the company projected the energy needs of customers?
Our last IRP was 2021, 15 years.
Okay. And in that if my memory serves me, in that 2021 RFP, neither of these proposed gas plants were included. Is that correct?
That is correct. It was a snapshot in time at that point.
Okay. And at that snapshot in time, the company did not project the sort of growth that is projections that are contained in your direct testimony, did they?
In 2021, we would not have predicted precisely the growth that we actually have achieved and see now.
Okay. How far, no, never mind. The last thing I wanted to ask you about was actually the last thing in your testimony. You ended with a brief mention of the workforce during the transition from coal-fired plants that are proposed to be retired. And in your testimony said at the appropriate time that the company would work with the affected employees and the unions. And my mother used to say that there's no time like the present, and I was wondering if you could tell me what proposals the company is considering regarding assuring that the workforce that is currently involved with the management of those plants would be retrained, would be reassigned, what sort of efforts are being proposed? Because obviously, as we heard today, there are concerns, and I think legitimate concerns from the workforce. And so I'm wondering what plans are being proposed and whether those plans would be brought back before the commission for review.
There are any number of things that we are considering and evaluating if our experience at Cane Run 7 is a good benchmark. We would expect that some of the workforce attrition will occur between now and whatever time these come into service, and we would also expect to retrain our workforce from operating coal-fired plants to operating combined cycle natural gas plants. We believe they're more than equipped to do that really well.
Okay. All right. And does the company have any sort of a commitment or preference regarding the construction of the deconstruction of the coal plants and the construction of the gas plants in terms of labor commitments within the Commonwealth? The reason I asked for this is one of the issues that you talked about was economic development. And I'm curious about whether there are commitments that the company makes regarding minority firms or regarding union firms, regarding local firms that would apply to the deconstruction and construction that's being proposed.
I would expect us to apply to those particular tasks the exact same filters and metrics that we apply across our workforce, across our contracting base. Very proud of many tens of millions of dollars that go to diverse workforce, diverse contractors.
All right, I appreciate that. That's all the questions I had. Thank you. It's good to see you. Mr. Chairman, thank you for your indulgence. Members of the commission.
Any questions from Walmart? Kurt?
No questions, Your Honor.
Mr. Howard?
No questions, Mr. Chairman.
Yes, staff just has one question. Good morning. Yes, good morning, Mr. Crockett.
Ms. Menzel, how are you?
I'm doing well, and you?
Good.
I want to follow up on one of Mr. Fitzgerald's questions about the risk, particularly if the NGCC units come in at a significantly higher capital cost than estimated. Other than the risk of the commission disallowing recovery of those capital costs in a future rate case, what other risks do shareholders bear in regard to the cost of the NGCC unit?
Well, I mean, the shareholders bear a risk of non-completion of those projects, and it would not be out of the question for us to evaluate a project several years from now that the circumstances have changed, and perhaps it means that we make a different decision about whether to go forward with a project. We've, I think, demonstrated that a number of times over the years. Green River would be one example. A number of years ago, we had a certificate for a unit at Green River that ultimately circumstances changed, and we ended up not constructing that.
Just to help me refresh my memory, what is the proposed construction schedule? When will construction begin if the NGCC units are approved?
I'll try, but others can be more specific. It will be in the 2025 to 27 timeframe. Lonnie Beller will we'll have the specifics better at hand.
Commission staff have no further questions.
Thank you. Good morning, Mr. Crockett. How are you?
Vice Chair Hatton, how are you?
I'm okay.
Good.
So a number of people at the public hearing wanted to know why the current plan is so drastically different from the IRP. And you addressed that a little bit with Mr. Fitzgerald's questions, but could you give us a fulsome explanation of that?
Well, I can give you a partial explanation, but would refer you to Mr. Beller and Mr. Sinclair, and Mr. Wilson. They can all address this more specifically. But the IRP in '21 was a snapshot in time of what things appeared to be. We have had the Good Neighbor Plan, which has become finalized. And then when we go out to the market with an RFP, that's the point in time at which the market actually tells us what is available at what cost, with what technology, with what fuels. And so this proposal is based upon the actual responses that we received to the proposals, the pricing around those. And so that's generally the way I would explain the difference between the 21 IRP and the end of 22 filing.
A number of people who came to the public hearings in Harlan and Madisonville were concerned about retirement of coal plants. What is the current ratio of coal and gas and renewables?
Currently, it is about 79% coal and 19%, 17% gas, I believe are the numbers. It would be 49 and 42.
Okay. By the end of the 40 years? Or?
At the completion of the construction of these new assets.
And do you know what percentage of the coal is Kentucky coal?
I don't, as I sit here today. Much of it is, though.
Do you know, who would know?
Mr. Beller.
Beller?
Yes.
Okay, thank you. And another public comment question. We had, I'm sure you know, we had robust public comment. We had people crowding every facility that we held public comments in across the state. And the biofuel has come up a couple of times as something that could use existing coal infrastructure and be mixed with coal to perhaps make a cleaner emissions. How fully did you consider that? Is it available now?
At scale, I don't believe it is, but those would be questions that you could perhaps ask of Mr. Beller. What I can say, Vice Chair, is that we have right now more than 140 different research and development projects underway. We are looking at all sorts of different technologies in an effort to try to find new solutions for the future. And we are more than happy to look at anything that has potential. Your reference to the hearings in Harlan and in Madisonville, it's been a very interesting part of this whole procedure because we've got such very different views on all sides of this. We've got those who want all coal and no retirements. We've got those who want no coal and all retirements. We've got others who want no coal, no gas, and all renewables. And so there's no shortage of opinions on either side of this. And I believe, frankly, that as it turns out, the proposal and the portfolio that we have proposed here is kind of falls in the middle, and we think it's the responsible place for us to be on behalf of our customers.
So a lot of the testimony was from your customers. There were those who love coal. There were those who love renewables. I didn't hear anybody who loved gas.
Well, there are a lot of people who love gas,
Okay.
and it happens to be the next best thing in terms of dispatchable generation for the future.
A lot of people were concerned about the reliability of gas, and especially in cold weather. How have you addressed that?
We do not have a concern about the reliability. We clearly had an impact with Winter Storm Elliott in December. That was a consequence of some equipment failure at a compressor station down in western Kentucky. We believe that that issue has been addressed fully by Texas Gas and are mindful that we're taking steps to prevent that from happening in the future.
And then finally, this plan, as expressed through both cases, the CPCN as well as the retirement case, will cause your company to lose an awful lot of employees. Do you know a total number?
To lose a lot of employees? I'm not sure that's fair to say necessarily. I really don't. I don't expect that we are going to have a lot of employee turnover as a consequence of these transitions in generation.
Do you know how many you'll need to reduce?
I don't know, but I don't expect it to be meaningful. I mean, that's not a fair way to say it, but I don't expect it to be significant.
Who would be the best person to answer that question specifically?
Probably Mr. Beller. You can get the broadest lens there from him.
Thank you.
You're welcome.
Good morning, Mr. Crockett.
Mr. Regan.
Just to follow up on the Vice Chair's question, is it your view or thought that these employees would be retrained?
Yes.
And that you would be providing programs to retrain those
Yes.
employees? Okay. I'd like to go back to just the Exhibit 2 from KCA on executive compensation. And I may be missing something, but is there anything in the compensation or goals based on customer satisfaction or customer, response times or things like that? Is there anything built into that?
Yes, we have short-term goals with regard to customer satisfaction
Okay.
that may not be reflected in here.
Okay.
Yes.
Normally they do, so I was just double checking. And then, from your perspective, based on the portfolio that you're talking about, do you believe that natural gas replacement is a safe investment? Or do you believe that it's safe for the environment, or both, or neither?
I believe that it is a safe investment, and I believe that it is safe for the environment. Natural gas, our plants would be 65% less carbon intensive than our coal plants are. So it is better they are better from a carbon perspective.
And that is, the portfolio was what LG&E felt was the best alternative?
Yes,
Okay. Do you believe that?
I believe that wholeheartedly.
Thank you.
Well,
Morning, Mr. Crockett.
Mr. Chairman?
I've learned not to take risks in these cases, Mr. Crockett, that if you have somebody in front of you, ask them the question. If they kick it to somebody else, which most of the CEOs do, so be it. But I'm not going to miss the opportunity for somebody else to say you should have asked Mr. Crockett that. So, do you know why LG&E and KU chose 1x1 natural gas combined cycles as opposed to 1x2?
In terms of the engineering decision with that, specifically, I don't know. You should ask Mr. Beller, but what I can tell you is that we did consider other alternatives to 1x1, including 2x1.
So does that mean that the other side of LG&E and KU's business submitted 1x2s in addition to 1x1s in response to the RFP?
No, again, you can confirm with Mr. Beller, but I believe that our project engineering group considered 2x1, but ultimately decided to submit a proposal that was 1x1.
Okay. You're generally aware that you mentioned earlier that the utilities filed an integrated resource plan in 2021. Is that right?
Yes.
You aware that the commission held a hearing on that integrated resource plan?
I am.
Okay. And the commission held a hearing in the 2020 rate cases? You're aware of that?
I am.
How about the 2020 environmental surcharge cases, the ECR cases we were talking about earlier?
Yes.
Okay, so that's 2020, 60, and 61. Throughout those, well, taking a step back, you're aware that the company put an RFP out related to this procurement. Is that right?
Yes, I am.
Okay. Are you generally aware of the questions that the commission has asked on cross-examination and other hearings about the timing of that RFP in relation to the generation interconnection queue submission by LG and EKU for combined cycle plants?
I have some familiarity with that, but not total.
Yeah, I mean, just at a high level, that the submission by one side of the business for 2 combined cycle plants was made to the independent transmission operator, the person that controls your all's
Yes.
queue, a day before or prior to the publication of the request for proposal. Are you generally aware of that timing?
I am.
Okay. So, I'm trying to ask this directly as possible. Given that you're aware of that timing, are you not concerned by that timing?
I am not. There was nothing about that timing that I believe to have been inappropriate or improper. With regard to the timing itself, you might explore those questions with maybe Mr. Bello or Sinclair, but my understanding is just an effort to try to get in the queue.
Well, and I can appreciate that, but it was submitted in response to an RFP that had not been issued. Is that your understanding?
I don't have an understanding of that one way or another.
Okay, well, let me ask, you were general counsel for the companies prior to taking your current role, is that right?
I was.
Okay. Do any rules, either at the state or federal level, require that there be walls between certain parts of LG and EKU's businesses?
Yes, certainly, as it relates to transmission especially.
Okay, so is it your understanding that the folks that send out the RFP and the folks that submitted those combined cycles in the queue are supposed to be separated by a wall when it comes to certain discussions and issues?
It's my understanding that whatever walls are required to be constructed and observed have been constructed and observed.
Yeah, and I appreciate that. Why are you confident of that, given the circumstances that we just discussed?
I believe we have methods in place that protect us from doing things that we should not be doing from that perspective.
So are those supposed to protect, so let me just ask, are those supposed to keep the procurement group from discussing with the generation planning group whether they're going to go to market for an RFP for additional generation?
I'm not sure I can answer that. As I sit here right now, I don't know the answer to that, Chairman.
Okay, but you have I'm trying to find out why you're so confident everything is fine if you haven't asked the questions specific to that issue. That's not a question, it's more of a statement, but could you tell me why you're so confident? Why everything is fine even though that was the situation?
Well, I'm confident in the procedures that we have in place as a company. And it is at our instruction, our direction, that those procedures are followed when it relates to communications that should or should not be had.
Yeah, and the procedures are great, but I'm asking why you have confidence that the procedures were followed.
Because those who actually participate in the procedures and implement them are honest and full of integrity and professional, and I have not had any experience to question that in my past.
Have you inquired specifically to that issue?
Not on this specific issue that you're raising.
Have you directed anybody to inquire about the timing issue?
I don't believe I have.
Has anybody reported to you about the timing issue?
Yes, the question arose at some point in time about the timing of it, and there was a point in time at which someone would have shared with me the background, the reasons for it. I don't recall those as I sit here right now, but I do recall a conversation.
Do you know who you would have had that conversation with?
I don't.
Do you have I'm just asked, do you think it's a bad look for the companies that the 2 units that you ultimately chose to provide the majority of the energy in the proposed plan, the genesis of those were a submission in the interconnection queue prior to the RFP ever being issued?
Not necessarily. They happen to be the only proposals that were submitted as part of the RFP.
Yeah, let me ask you, if you were, I'm making up companies, but Hitachi or GE or I don't know who actually, some competitive entity that wanted to build a combined cycle and do an RFP for you all or do a biomass facility, do you think you would be a competitive offer when the utility's self-build proposal was entered prior to the RFP even being issued?
I'm not sure I can answer that necessarily. I think that there are advantages that we possess as the utility because of the property that we hold, our contiguous location next to transmission, and all sorts of things that result from the fact that we are in this business and have this property.
Right, so you all had 2 submissions, they got withdrawn and then resubmitted, I guess with small changes and maybe even withdrawn and resubmitted again. But you all submitted, the one side of the business submitted a response with 2 combined cycles prior to the RFP was issued. And to your point, there's testimony on this in the case. You all know your system well. You know where the generation would need to go. You already have land control. And contrary to every other entity in the state, you all have eminent domain as a utility, right? Those are all facts.
All of those things are true.
Okay. Are intermittent renewable resources dispatchable?
They are not.
Okay. That is supported by your direct testimony where you say that as a dispatchable energy resource, hydrogen can enable more intermittent renewable resources to the energy system. Is that correct?
I think that is a fair statement, yes.
Okay.
I would add perhaps that I think there are still plenty of challenges associated with utility scale hydrogen blending, as with many other technologies.
In the application, it discusses a comprehensive approach to addressing unprecedented change. And it specifically notes that on page 6 of the application, it discusses under current and reasonably foreseeable regulatory and economic circumstances, being, supporting the need, the purported need for the application. I know you're an attorney. I'm not necessarily asking you for a legal opinion. I want to know from your seat as CEO, where you see the threshold being between possible, probable, whatever term you may want to use, and reasonably foreseeable when you're making your decisions.
I'm not sure how to answer that. Let me try it this way and start me again.
And I'm sorry, and just to be clear, I'm asking from the perspective of the regulatory and economic circumstances.
Yeah, and that's kind of where I was going to go, using, for example, the Good Neighbor Plan or the Greenhouse Gas Rules 111. My belief is that the Good Neighbor Plan is currently final. The Kentucky's execution of it is in limbo at this point. My belief is that the Good Neighbor Plan or something that looks a lot like it is going to be with us for the future. That's my belief. With regard to the greenhouse gas rules, 111D, that is a set of proposed rules subject to comment from any number of places, ourselves included, that will now be finalized for a year. I believe that those will look different a year from now, and I am certain that those will be subject to significant litigation.
Okay, so taking a big step back, when you all filed this case, the Good Neighbor Plan, there's like a half a dozen things that we can call it, but we'll just call it the Good Neighbor Rule, okay? The good neighbor rule was a pending rule, is that right?
That is correct.
Okay. Was it in the same stage, roughly, in terms of proposed, pending, expected, finalized, whatever? Was it in the same stage when you filed this application as the new source performance standard or the GHG Rule 111 rule is now?
I think it was more mature at the time as a proposed rule. I think it was significantly more narrow as a rule than the greenhouse gas rules, but it was still in proposed state. We expected it to become final, and it did.
Okay. And when you say a different stage, was it post-comment when you all filed this application or pre-comment? Do you know?
I think it was post-comment.
Okay. And now we're post-comment, the 111 or GHG rule, right? New source performance standard, whatever we want to call it, right?
We are.
Okay. Your comment about the good neighbor rule and your confidence, do you have an independent basis for that position, or is that in large part a result of your conversations with folks at LG&EKU, in particular Mr. Ember?
It is a combination of all of those things. It is my independent opinion, but it's also informed by discussions with many at the company.
Okay, because we have testimony from Mr. Ember that explains something similar to your assertion. So can you explain why it's your independent expectation that either the good neighbor rule, I can't even say as implemented because it's not, but the good neighbor rule as finalized or as implemented by the FIP is either going to stick around in that form or one form or another?
Well, I mentioned earlier in response to Mr. Fitzgerald, I think that the EPA has expressed its very determined intent to enact rules like the good neighbor rule, like the greenhouse gas rule. I believe that with regard to the good neighbor rule, that there aren't going to be any meaningful modifications to it when it's all said and done. That's just my belief. I think that there's so much more to be evaluated as it relates to the greenhouse gas rules, that those are just going to look significantly different. I also happen to think that they will be litigated for much longer than the good neighbor plan.
Have you had a chance in all of your off time to review Mr. Sinclair's rebuttal testimony in this case?
I have.
Mr. Sinclair's rebuttal testimony specifically discusses I think it's Mr. Sinclair's rebuttal testimony, but one second. Different question. Have you had a chance to review Mr. Ember's rebuttal testimony in this case?
I have.
Okay. Mr. Ember specifically discusses and if you have Mr. Ember's rebuttal testimony available to you.
Yes, we do.
I see head nodding. So on page 5, Mr. Ember's testimony, he specifically references testimony that was provided and arguments provided at the U.S. Court of Appeals for the Sixth Circuit. Now that's the Court of Appeals circuit for the Commonwealth of Kentucky. That includes the Commonwealth of Kentucky, correct?
Correct.
Okay. On page 5, Mr. Ember includes some quotes. And do you see the first bullet point starting on line 12 with the quote?
I do.
All right, so tell me if I had this quote incorrect, or at least the portion that's provided. The good neighbor provision addresses the serious problem of upwind states' emissions significantly contributing to downwind air quality problems. Though its emissions impact multiple downwind states, Kentucky proposed to do nothing to limit its emissions, end quote, beyond controls already in place. And you see the citation there is to EPA's, the footnote, EPA's consolidated response in opposition to petitioner's motion for a stay pending review.
Yes.
Okay, so does that do you understand that to be, or the argument to be that the EPA made, is that the SIP effectively would not require NOx controls, and that's part of the reason that the EPA decided to deny the SIP and implement the FIP for the Good Neighbor Rule?
I do not understand all of the nuances around that denial.
Okay.
But what I do understand is that the SIP denial was largely based upon some procedural differences as it relates to the percentages. And I think Mr. Beller can talk to you about this more completely than I can.
Well, and that's fine, but again, I gotta ask you so that if Mr. Ember can't answer it, then we get to call you back so that you can answer it based on, it's a whole thing. I just want to make sure I have an appreciation, because Mr. Ember's testimony basically says, and it sounds like your own testimony, and I'm, council can object, but this is how I read Mr. Ember's testimony. One way or the other, the EPA is going to have some rule that impacts or requires Mill Creek 1, Mill Creek 2, and Gent 2 with regards to NOx. Is that effectively your testimony or your expectation as well?
In a general way, that is a fair characterization of my testimony. It would not be entirely complete, though, because Mill Creek 1 and Mill Creek 2 are impacted by things beyond just the Good Neighbor Plan, including Jefferson County attainment.
That's NACS, right?
Yes,
Yeah.
correct.
Okay. And we might get another roll on that next year, so. All right, so do you know, are you aware of whether the company has modeled, whether under the state implementation plan for the Good Neighbor Rule, whether it would have required, if EPA had approved it, NOx controls or SCRs at Mill Creek 1, Mill Creek 2, withdrawal of Mill Creek 1, Mill Creek 2, and Gent 2?
Could you repeat that question, please?
Do you know whether the company has, withdraw that. Do you have personal knowledge of whether the company has modeled, whether if the EPA had approved the SIP for the Good Neighbor Rule, whether it would have required SCR at Mill Creek 2 and Gent 2?
I do not know whether we have modeled that specific question. But Mr. Beller, Mr. Ember will know.
Okay. But so just so I have an appreciation, if EPA would have approved the SIP, okay, and I take this testimony at face value that Kentucky, quote, Kentucky proposed to do nothing to limit its emissions, does it not seem like the expectation here in this testimony is that SCRs would not have been installed?
Your Honor, that's a highly speculative question.
If he can't answer the question, that he's fine, but that's not an objection.
I do not know. I'm sorry.
Okay, that's fine. And do you have an expectation that Mr. Ember knows?
I would start with Mr. Beller. Sorry, Lonnie.
Do you think that that's an important consideration? What I just asked.
I don't believe that the EPA believes that this pause in its implementation here in this state will ultimately keep it from going into effect. I believe that the impact of it is here to stay.
Yeah, and let me ask a different question, because I want to fully understand the perspective you're providing in relation to, especially because you had independent expectation, or independent, you formed your opinion independently and in consultation with Mr. Ember, sounds like. Is it your expectation that even if, let's just say hypothetically, the SIP would not have required environmental controls, or SCRs, at Mill Creek 2 and Gent 2? Was it your testimony earlier that effectively you still think EPA would take some action to require those SCRs on Mill Creek 2 or Gent 2?
Mill Creek 2 is impacted by different things than Gent 2 is. Gent 2 is not impacted by the Jefferson County ozone NOx issues. So Mill Creek 2 has a more complicated set of challenges to continue running significantly beyond where it is right now. It's different than Gent. Gent has come into this portfolio as a consequence of the Good Neighbor Plan.
Okay. Is the 111 rule, taking the terms of the application, in your personal opinion, reasonably foreseeable?
I do not believe that the 111 rules as presently proposed are reasonably foreseeable in a fashion that looks like they look now. There's so much to it, but I think that they will ultimately be modified.
Mr. Riggs, it's already 11:50. It might be easier to conduct your cross-examination or redirect after a break if you have any, but I'm also happy to go ahead and allow. Do you have any redirect?
Very brief.
Would you like to go ahead and
Very brief.
ask your redirect? Okay.
I have only one or two questions.
Please proceed.
Thank you, Your Honor. Mr. Crockett, do you recall the examination of the Kentucky Coal Association?
Yes.
Do you recall the specific examination as it related to KCA Exhibits 2, 3, and 4 concerning PPL's proxy statements and representations in those documents?
I do.
Mr. Crockett, was the proposal the company presented to this commission made for the purpose of improving PPL's earnings and profitability, or was it done for the purpose of providing safe, affordable, reliable service to customers?
The latter.
Is it a fair inference from the examination of the KCA that the company's proposal was driven or determined by the executive compensation and the profitability goals of PPL?
That certainly is the inference that Mr. Malone was attempting to make. It could not be farther from the truth. Our proposal was based upon our analysis of least cost, reasonable reliability for our customer base.
Thank you, Mr. Crockett. Those are all the questions I have.
I do have one question, if you'll indulge me, Mr. Riggs. And I meant to ask it earlier. How long have you been with LG&EKU?
Since January of 2018.
Okay, and you worked with the companies for many years before that, is that right?
I did.
Okay. Does the incurrence of an expense or an expected incurrence of the expense by the companies make it recoverable in rates historically?
Not necessarily. It has to be prudently spent.
Are you aware of past instances with LG&EKU or with other entities where the commission has denied recovery from customers of long-term incentive plans, especially those related to earnings per share growth?
I am aware that that has occurred in the past. I think it's very rare as it relates to our investments.
But just because PPL may be giving people long-term incentive plan compensation based off of EPS growth doesn't mean the commission has, or rarely means the commission takes that at face value and allows for 100% recovery in rates. Is that your understanding?
That's my understanding. I do not believe that part of compensation is recoverable in rates anyway.
Okay. Mr. Riggs?
Nothing further, Your Honor.
Mr. Treaver, I'm fumbling around. I found this document on the LTI. I had one more question for you.
All right, so I'll let you.
I won't do it again.
Well, and I'll just as a statement, everybody gets one shot, and because we don't have enough
I understand.
time or gas in the tank to probably give everybody 2 rounds of.
And I'll give Mr. Riggs the same shot if he forgets something. But I was looking at the PPL 2023 proxy statement, and this is what I was fumbling around trying to find. In response to shareholder feedback for the first time in 2022, our long-term incentives included awards based on EG and ESG metrics. Does that sound familiar to you?
That sounds familiar.
Okay.
Yes.
All right, and while keeping the overall mix of 20% time-based and 80% performance-based, the committee added EG and ESG metrics to the LTI mix at 20% each, replacing the 40% ROE-based performance units. ESG metrics are tied to climate-related matters. So my question is there would be an incentive on your part to shutter coal plants, correct?
I would not say that I have an incentive to shutter coal plants.
Okay.
I have an incentive to retire coal plants when the portfolio is in the best interest of customers.
And it changed this year to 80% for your LTI. I mean, in other words, you're now being incentivized from an ESG standard this year as of 2022, I should say.
I don't believe it's 80%.
Okay, fair enough.
It is whatever it says in that public document.
Thank you, Mr. Crockett.
Mr. Riggs?
Nothing.
All right. Thank you, Mr. Crockett. May I
Thank you.
step down? All right, we will take a lunch. We will go until 12:55. I promise I'm not obsessed with food. I'm just trying to stay on pace here. So we will come back at 12:55. Mr. Riggs, you can call your next witness.
Yes, thank you, Ron.
back on the record in case number 2022-00402. Mr. Riggs, would you like to call your next witness?
Your Honor, Mr. Ingram will present Mr. Beller.
The company's next witness is Mr. Beller, Your Honor.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat. State your name and business address for the record.
Lonnie Beller. My business address is 220 West Main, Louisville, Kentucky, 40202.
Mr. Ingram?
And what's your job title, Mr. Beller?
I'm the Chief Operating Officer for LG&E and KU.
And did you cause to be filed direct testimony dated December 15th, 2022, and rebuttal testimony dated August 9th, 2023, in case number 2022-402, the CPCN case?
Yes.
And did you also cause to be filed direct testimony on May 10th, 2023, in case number 2023-122, which is known as the SB4 case?
Yes.
That case has been incorporated into the 402 case, correct?
Yes, it has.
Did you also sponsor numerous data responses that have been filed in the record of those cases?
Yes.
Do you have any corrections to any of that testimony or any of the data responses as you sit here today?
No.
Do you adopt that testimony and those data responses today?
Yes, I do.
Mr. Beller is available for cross, Your Honor.
Mr. Cook?
No questions, Chairman.
Mr. Malone? Do you have documents you would like to pass out?
We do, Your Honor.
Please.
Mr. Bell?
Yes.
Matt Bloom for KCA. Wanted to go through a few things. First thing, when I was reading your rebuttal testimony, it seemed to me, this may be just a nuance, but you do understand that KCA is not suggesting or not asking for, well, let me strike that. We are simply asking for delay as opposed to shutting down the plants right now. Do you understand the nuance that we are suggesting in our position?
As I understand it, the position was not to approve the company's plans, and that, yes, would result in a delay of retirement of the assets.
With respect to the good neighbor rule, good neighbor plan, absent that having occurred, would you all filed this CPCN?
Within the case, as I think most appreciate, the retirement decision for Brown 3 is unaffected by the Good Neighbor Plan. So there likely would have been a case that would have, as Mr. Crockett testified, looked quite different than the one that we did file.
What hinders the ability to put SCRs on Mill Creek 1 and 2 and Gent 2?
Just to be clear, when you say ability, are you talking about a constructability or engineering perspective?
Both.
Obviously, we've done that before in our history, and we can do that. Historically, as we all know, we've done it as a result of our analysis that shows those actions to be least cost and benefit our customers.
In fact, with response to a data request response, my understanding is there are no, and I don't want to put words in your mouth, but there are no undisclosed obstacles to retrofit with new SCRs.
Not from an engineering or constructability standpoint, no.
One thing that I've tried to figure out is the reliability issue with respect to these new natural gas plants. And specifically, we asked a data request, and I believe it was 2-51, that had to do with co-firing. And I believe you all answered it in a little different vein, and you referenced fuel oil. Why, okay, when you all, let me phrase it this way. When you all filed the CPCN, had you all looked into that issue or not? In other words, a dual fuel issue with respect to the natural gas plants.
So looked into is a broad term, but
Fair
we
enough.
were clearly aware that machines that we were contemplating construction would have that capability. We had intended to ask, as we did, for an option to allow that capability to be installed when we bid to the prospective vendors that construction process. And we know that from history. Some of our natural gas fired units, 4 of the combustion turbines at Brown, are able to burn both natural gas and fuel oil. They burn them separately, not in a co-fired situation, either all natural gas or all fuel oil.
Okay, and just to be clear, we're not talking about hydrogen, we're talking about fuel oil here.
Correct, fuel oil.
Okay. So, the way that I read the response and the way I read your rebuttal is that the reason that you all issued an RFP during the middle of this CPCN filing was because to enhance reliability or because of reliability issues or concerns and wanting to make sure that you had perhaps an answer to some sort of Winter Storm Elliott type scenario. Is that, I mean, why did you do what you did?
Just to be clear with your question, the RFP you're asking about, is that the RFP that we issued to prospective combustion turbine combined cycle vendors?
I believe so, relative to the dual fuel issue.
So, as I stated earlier, we had contemplated, when we filed the case on December 15th, of asking for a dual fuel option when we bid for the construction of the 2 combined cycles. And so we indeed did do that. We asked for a number of other options in that bid too, so that when we receive those bids, we can, as we've always done, do an analysis of which of those options serve to enhance reliability at a reasonable cost, and how those options play off with other assets that we have in our fleet.
And Mr. Beller, I'm not picking at you here, but I'm trying to figure out, here's the issue in my head. With dual fuel, in other words, fuel oil, you're going to have storage issues, you're going to have, isn't that different piping, pollution control equipment potentially? Is that, what do you have, what inherent costs are associated with that?
Sure. So in order to burn fuel oil, you would have to have certain modifications to the machine. Those modifications could be made at the time you construct the unit, or they could be made at some future date. Likewise, you would need to have tankage to hold the fuel oil. Obviously, if you're going to provide that capability to the machine, you'd want to have an ample supply for your needs on site. Additionally, you need tankage to support demineralized water storage. There's a significant amount of demineralized water that's required to burn fuel oil. It's part of the process. So those are the major components of what you would need on site, and those will be the components that our prospective suppliers of combined cycle technology will provide. They will provide a list of those components, their cost. They will include the layout and storage of those 2 main components, the fuel oil and the demineralized water. They'll design that within the footprint that we've given them to design on our Brown site and our Mill Creek site.
In all fairness, I'm just trying to figure out from a timing perspective, why not do that at the front end when you filed the CPCN?
Well, we had not submitted the bids to the vendors when we filed the CPCN.
Can you walk me through that? I'm sorry, I'm not following.
So when we had filed the CPCN, we had yet to submit the bids to, and for everybody's understanding, there are three prospective vendors, GE, Mitsubishi, and Siemens. Those are the only major turbine manufacturers in the world. And so, but we had not submitted those. Subject to check, we did that sometime late April. I know it's in the record, so just subject to check if my memory's not precise on that. And we had not submitted those, so therefore we didn't have to make a specific decision upon filing.
Was that not part of the original bid?
The original bid, now we're talking, just to be clear, about the bid our project engineering team developed and submitted as part of the RFP for supply options, if you will, that was run prior in late 2022. So in that bid, the bid did not include fuel oil, but it included a contingency of roughly 10%. So amongst the two bids, there's around $140 million of contingency in that bid. That contingency was there for lots of reasons, of course, but one of the reasons is to allow, as we receive the bids from the three major turbine suppliers, to be able to select certain options, fuel oil being one of those.
Okay. So as we sit here today, we obviously don't, because we haven't, have you, let me ask, have you received a response to the RFPs, or have you?
The response, this date is in the record, from those vendors is due on September 11th.
Okay. So as we sit here, obviously, then right now, we don't exactly know what this dual fuel aspect is going to cost cost-wise.
We have an estimate of it. Obviously, we're in the business, and we have an estimate of what it would be, but we don't know what each individual vendor is going to bid.
Well, but like, I mean, also the OMN, the storage and whatnot, did you build that in or no?
Just again, to be clear in the question, there is ample space when our team laid out the footprint of the combined cycles at Mill Creek 5 and Brown 12. We're calling them by their unit number and name convention that we plan to use for those units. There's ample space for the tankage that we believe we would need to do that. So in that context, we planned for it.
But it hasn't been built into a cost structure?
Not at this point, correct.
Okay, that's fair. Okay. Question about the GHG NSPS. There was a lot of testimony about intermediate load. What cost impacts are there from complying with the NSPS and switching to the intermediate load for you all?
So that's a very broad question. My interpretation of intermediate load and with respect to the proposed 111 rules, if we want to call them that, or new source performance rules as it relates to the combined cycles, is that there's an option to run them at 50% or less capacity factor. And so there would obviously be a cost to that. There's a tremendous amount of information in the record about the analysis that we've done as a result of questions by the commission as to how we looked at that and did extensive analysis to support our ability to prove that our plan remains least cost under the construct of our analysis.
Okay. Let's talk a little bit about Senate Bill 4. In going through that, are you aware, or can you point to where the company has addressed the, quote, indirect costs associated with shutting down the coal plants in the record?
So I've got a copy of Senate Bill 4 here.
Yes, sir. And I've got it if you need it.
No, I've got it here.
If you want to take a look, it's subsection 3.
Mr. Beller, could you let me know what you have in front of you? Is it the legislative version, the ACTS version, or the statute?
Well, I'd like to be able to answer that question. I'll tell you what it says at the top. It says Chapter 118, Senate Bill 4. So,
okay, so it's the ACTS version. All right.
I printed it out off the internet. So.
Thank you.
And yes, I'm at that section. If you could kind of re-ask your question, please.
Sure, yeah, so I've been looking at it, and I've been trying to figure out, the utility shall, at a minimum, provide the commission with evidence of all known direct and indirect costs of retiring the electric generating unit and demonstrate the cost savings that will result to customers. So I'm curious about the indirect costs.
Sure.
And where that would be in the record.
Sure. There's a data response in the record that replies to that, but with respect to our view on that, we've evaluated all of the costs of retiring coal assets, building new assets, adding solar, all the things that we have in our plan, and alternative proposals that aren't part of our plan in a means to compare with, of costs that will impact the ratepayer. And we see that as what our mission is, what our requirement is under Senate Bill 4, is how do those costs impact our ratepayer?
But, well, indirect costs, in my mind, could obviously mean job loss, sort of other issues that would be attenuating related to the closure of coal plants. For both KCA suppliers and then, also people that are in attenuating businesses that supply coal-related industry. So where in the record have you guys gotten into that?
Those costs would not result in a direct increase in rates that we charge our customers, so we haven't evaluated those costs. What we have done is done a net present value of revenue requirements analysis that produces the lowest cost plan that meets all of our reliability criteria to serve our customers. And we believe that represents the best analysis and the best basis on which to make a decision, because if we were to select other plans that are far greater in cost, that would have a number of impacts on our customers that could lead to job loss, lack of economic development opportunities for the state, and other things. But our practice has historically been, and we believe it consistent with this section of Senate Bill 4, to evaluate the net present value revenue requirements as inclusive of the impacts of our proposal on our customers.
Okay, so, and this is, I hate to beat a dead horse, but obviously when I look at this, how do you, from a net present value versus a residential rate analysis, how do you determine what harm is going to incur to the ratepayers without doing the rate analysis?
So, to back up a bit, how rates are set are subject to a rate case.
Sure.
And I know I'm telling you what things you already know, but it's subject to a rate case. And how those costs are allocated are subject to the facts presented in a rate case with all matter of material. What we have historically done, and we continue to believe it's the best practice for planning, is assume perfect rate treatment based on the rate of return assumptions and all the things that we have in our analysis that are fully disclosed. That assuming perfect rate treatment for those items is the best way to evaluate the best course of action for the companies on behalf of our customers. Those rate-making decisions will be determined later, and they can be adjusted over time during the life of the asset, as we all know, based on conditions and when rate cases are filed.
I would agree with you if this was simply a CPCN case, but the difference is we also have the inclusion of the Senate Bill 4 case, which specifies that, that the retirement will not harm the utilities ratepayers, correct? So
It says that that you have to demonstrate that cost savings will result to customers as a result of the retirement of the generating units, and our measure of cost savings in our case is net present value of revenue requirements as it just described, and we believe by planning from a least cost perspective that accomplishes that result.
capital costs with an NPV analysis are levelized in an NPV analysis, correct?
We do not levelize those costs. We calculate them as they would be in a rate case. A rate case is a snapshot in time, I appreciate, but we calculate those costs on a declining book value basis, not on a levelized cost basis.
We do agree that if the companies get what they're asking for, that there will be an increase in rates to the customers for the next 10 years.
That is not what we considered to satisfy the requirement. We have a data response that shows, I believe in the first 9 years there's an increase and then it turns in year 10. But we still believe we have to make long-term decisions. If we made decisions in our business over short-term rate impacts, there would be a lot of investments that the company wouldn't make that benefit our customers both today and in the future. So we believe looking at decisions over assets' lives and longer-term time periods is the appropriate standard, and that's what we've represented to this commission for a number of years, and we believe that approach is consistent with Senate Bill 4 language.
So I guess one thing that I go back to is that, I mean, obviously you guys did the NPV analysis, but why not go ahead and just do the residential rate analysis as well?
Well, again, as I already testified, that analysis is dependent upon the outcome of a filed rate case. And rate allocations, cost of service studies, I can go on and on about the complexities of a rate case. And,
Sure.
We assume perfect rate treatment. So what we assume is all that works perfectly. And when I say that, so you follow that a bit, is there are certain costs that the company will incur and won't receive recovery of until we file a rate case. We don't consider those timing differences in our calculation. We assume perfect rate treatment. And likewise, the benefits would go to the customers through other mechanisms that we have, fuel adjustment clause, lower fuel savings, O&M savings that we may achieve by operating a more efficient unit. And so we continue to believe that the net present value of revenue requirements is by far the best way to judge that, and far too many assumptions and presumptions need to be made to perform a rate analysis, much less make a different decision based off of those assumptions.
Yeah, you are aware, though, that, you know, the EPA does a rate analysis when they're putting their regulations together.
I'm not familiar how they do it. It makes sense that they would. We typically hear of the health benefit analysis they do against what they believe the rate increases will be for customers.
Just taking a quick step back to talking about the dual fuel one more time to go in reverse. How much supply do you all need to have an ample supply to address this reliability issue?
So help me a bit with your question. I'll restate it and see if this is what you're asking.
Okay.
How much fuel oil do you think we would need on site to address a concern
Correct.
with the availability of natural gas to a unit?
Correct.
So obviously that's not just analysis we make with respect to just these two units. It's a portfolio analysis. We look at these things in the context of our whole portfolio. The second point I would make there is the amount of inventory, if we were to decide to dual fuel a unit, wouldn't be comparable to coal fuel inventory.
Okay.
Coal fuel inventory is set based on a whole host of reasons that I could go into but don't need to. But the primary point is coal would be the only source and is the only source for those units. Fuel oil would be a backup source based on a number of considerations we would make to give the most reliable gas supply to those units. So we haven't made a determination of that, but let's say 2 days or something like that seems reasonable. But once we get the cost, once we get the numbers, we can make that evaluation. And when I say 2 days, just to be clear, that's 2 days at full load. That doesn't mean that we would utilize all that fuel oil in 2 days. It could be used over a week, for example, depending on how you would dispatch that asset, if in the very rare instance you would need a backup fuel for that long.
I'm trying to reconcile a few things, and I just want to run through a couple things. Do the companies have replacement generation for Mill Creek 1 in 2025?
No, we do not.
Okay. How does that reconcile with Senate Bill 4?
So, with respect to Mill Creek 1, if you go back to the question I was asked by my counsel, When we filed on December 15th, Senate Bill 1 was not in effect. And so, Senate Bill 4, sorry, Senate Bill 4 was not in effect. And so we did not have the retirement of Mill Creek 1 affected by that. When we filed the supplemental testimony in the other record, I don't have the case number memorized because they're combined into this case, but we did include Mill Creek 1. And so with respect to Mill Creek 1, we had made a decision in the original case, and it's all in testimony subject to prior analysis, that we wouldn't install the necessary pollution control equipment, water treatment equipment, intake structure equipment, namely a cooling tower on the unit, to continue that operation past 2024. Our Senate Bill 4 analysis included that. We would be seeking a retirement date for Senate Bill 4 purposes with the commencement of the operation of Mill Creek 5. So if we continued on the path that we're planning on Mill Creek 1, which already doesn't run 7 months out of the year, according to agreed order with the Air Board in Jefferson County, would not run the other 5 months either until its ultimate retirement.
So I suspect you were in here earlier when I put on the exhibit, and I want to say it was maybe KCA2 that had the chart that showed the green and the black, for lack of a better way to describe it.
Right.
So is it fair to say you guys have requested to close 1,500 megawatts, but you're only replacing it with 1,250 megawatts?
The coal units, Mill Creek 1, Mill Creek 2, Brown 3, and Gent 2, sum to approximately 1,500 megawatts. The two combined cycles are 1,242 megawatts. So that's an accurate statement. That's not conclusive of our full Senate Bill 4 analysis that's in the record. I would just point that out.
Oh, yeah. Did you happen to see, I don't, and you may not have, but did you happen to see the Tennessee gas pipeline explosion in the news?
Was it recent? I've seen gas pipeline explosions before in the news, but
There was a force majeure enacted relative to the supplier. I just was curious if you'd see it, that's all.
yes.
Okay. When you all were considering what to do with the coal plants, did you consider repurposing the coal plants for any other issues? For example, when we heard today with the public comment about the biomass and, like a hydrogen production facility, did you guys look at that?
Not in the context of the analysis for these units. I think as Mr. Crockett testified, we're always open to new supplies of fuel. We'll retain, well over 3,000 megawatts of coal-fired capacity after these units retire. So we're not aware of any imaginable source of those alternative fuels that would suggest that retiring these units is a challenge with respect to not being able to use those fuels should they become economic in our remaining fleet.
But it wasn't something that was, was it just, when I say it was studied, what did you do?
I didn't intend to say we studied it. What I intended to say is we're always open to that, and should it become available, we have a large fleet that we could burn those alternative fuels in. And furthermore, we did not evaluate that as an alternative for continued operation of these specific units for those reasons.
Let's talk about Mill Creek 1 and Mill Creek 2. Why does Mill Creek 1 have to close at the end of 2024?
Mill Creek 1, the decision to retire, as we've just been discussing, pre-Senate Bill 4, the decision to retire Mill Creek 1 was fundamentally made in the company's 2020 ECR filing. And that filing included processed water treatment as a general term, effluent limit guideline compliance at the Mill Creek station. And it was decided at that time, based on the fact that we had entered into an agreement with the Air Board to not run Mill Creek 1 effectively during the ozone season, and that unit needed a cooling tower to meet 316B water requirements, that we wouldn't make that incremental investment for ELG capability to continue to operate Mill Creek 1. So for those reasons, we had decided to retire Mill Creek 1. We picked up in the Senate Bill 4 analysis, subsequent analysis to satisfy the requirements of Senate Bill 4 as it was passed.
Why does an SCR have to be installed on Mill Creek 2?
So Mill Creek 2, there are really two reasons. One is the Good Neighbor Plan, which we're discussing, contemplates SCR controls being installed on all generating assets. And when I say contemplates, there's a NOx ton allowance program run by the EPA, and they get to how many allowances they allocate to us based on SCR operation of our units over time. The second criteria is local attainment for Jefferson County, NAAQS attainment for ozone, and Jefferson County currently, counting input from this year, is in non-attainment. The level at which attainment is considered is at or below 70 parts per billion. The 3-year running average in Jefferson County sets at 72 parts per billion today.
What happens if Mill Creek 1 closes?
I'm sorry, I didn't.
What happens if Mill Creek 1 closes relative to your last statement?
If Mill Creek 1 closes, we would, it's part of our plan. We would implement our plan as we've outlined to the commission.
Well, I guess where I'm going with this is if Mill Creek 1 closes, where does that leave you with this attainment issue and running Mill Creek 2?
So as of today, only one of those units run in the ozone season as it is. And so closing Mill Creek 1 doesn't affect local attainment today. We're not running one of those units already as part of the agreed order. So the closure of Mill Creek 1 would not affect attainment issues in Jefferson County.
What if there's an SCR in Mill Creek 2?
As part of our analysis, if you put an SCR on Mill Creek 2, it would reduce NOx, and it would be considered a technology that would satisfy what we believe the Air Board would ask us to do as a result of Jefferson County's non-attainment.
And if you put an SCR on Mill Creek 2, that would also reduce the potential for stranded costs by not shutting down the coal plant, correct?
Well, that's not a singular objective that we look at. Again, we look at it from a fleet-wide perspective and a holistic perspective. So we wouldn't necessarily look at it that way. We look at it collectively, and we included those costs in our analysis.
I understand that, but I mean, just from a dollars and cents standpoint, realistically, if you didn't shut it down, there wouldn't be a stranded cost associated with it.
We would be recovering those costs as part of the continued operation of that plant.
But there also wouldn't then, if there was not a gas plant, then there wouldn't be the, for lack of a better way to describe it, a double dip on the customers where they're paying for both.
Yeah, I wouldn't agree with the double dip analogy. We are looking to minimize costs to customers, and we believe the financial criteria that I've discussed multiple times does that, and that financial evaluation is inclusive of the recovery of those unrecovered costs, you're referring to them as stranded costs, and the recovery of costs to install new assets. That's in our analysis on both sides of it.
And there is, just so we're clear, there is, I'm going to use a double negative here, there is no non-attainment issues on Gent.
As we said here today, I don't have any view that when Jefferson County files a plan with the EPA to get Jefferson County back into attainment, that Gen 2 would be part of that plan.
Okay.
Correct.
Question for you. All right, let's imagine that the commission goes along with what the company's asking for relative to these NGCC plans. What about the air permits associated with them? What's the status on them and the timing, the requirements, the risks?
So, just again to be clear on the question, you're asking about the status of the air permit on Mill Creek 5 and Brown 12. We've submitted those air permits to the regulatory bodies at Brown. You appreciate it's the state. In Jefferson County, Mill Creek 5, it's the Jefferson County Air Board. and they're processing those permits. We had made a request to have those permits issued by the end of the year, early next year, and we have every expectation that they will honor that request.
If the commission decides that it's not in the best interest of the ratepayers for the companies to get their requested gas plants, and instead looks at Senate Bill 4 and determines that the companies have not met their burden, is there anything stopping you from putting SCRs on Mill Creek 1 or 2 and proceeding?
As I testified earlier, that is physically possible from an engineering constructability. Obviously, we evaluated that scenario in the record, so we would clearly do that to retain, service to our customers.
Brown 3. Has the delay in maintenance at Brown 3 contributed to its declining performance?
So help me with its declining performance. What do you mean by that?
Well, it's not being used significantly.
Well, its low capacity factor or lack of use doesn't have anything to do in a material sense with its availability. We dispatch the units based on their cost. Obviously, they have to be available. They can't be under a forced outage or under maintenance. But its availability on the whole is primarily, or its capacity factor, to be clear, is on the whole driven by its incremental cost to operate, which is primarily driven by the high cost of coal into that site compared to the cost of coal and natural gas at our other sites.
I was going to say, what caused the decline in performance there? So is that the answer to the question?
Yes, coal price predominantly.
Sorry, Mr. Malone, I have some intervening questions. What do you mean coal price predominantly? Does it have, can coal be delivered by truck to Brown 3?
It can. Its primary delivery source is rail, and obviously that has to come from mines that have the ability to provide rail service, right, load their product onto rail cars, and so it limits our supplier base given the railroads that feed the Brown plant. So historically, delivered fuel price there is higher than the delivered price at a barge plant, or even in the case of Mill Creek 1, our Mill Creek plant, we receive rail coal there. And so that coal into Brown is more expensive even than that rail coal.
Mr. Riggs and Mr. Ingram, is the, per the testimony around the concern around duopoly of fuel, are the providers or the producers, those two individuals, those are not necessarily, the identity of those is not confidential, is that correct?
I'd have to consider it, but I don't see why it would be.
Okay. Right. So the two, I'm sitting here thinking about fuel contracts and.
That's addressed in Mr. Sinclair's testimony.
It is.
Yeah.
But I just, are you aware of Mr. Sinclair's testimony where he talks about the concern, his concern, I'm not going to testify for him, but his concern around the duopoly of fuel producers for coal for the companies?
Yes.
Okay, and I think it's a 70% number that is provided by two different producers. Is that your understanding?
Correct.
Are either of those two producers able to provide coal to Brown 3 on rail? Or do they routinely, I guess is what I'm trying to ask.
I do not believe so, but that's something you could check with Mr. Sinclair. I don't have the supplier names memorized to the extent that he would.
I just thought you might know those two, so that's okay. Mr. Malone?
Thank you, Mr. Conway. Question for you. If the final new source performance standard for gas does not include compliance from switching to base to intermediate load, what will you all do?
So your question is, in the final rules, if you can no longer operate a combined cycle at an intermediate load without controls, which we believe that to be an unlikely outcome, but if it were, obviously we'd have to look at how we would operate these assets in the future, just like the other constraints that significant other constraints that rule would have on the rest of our fleet.
Same question I had for Mr. Crockett, too. So assuming the companies get what they want and the combined cycles start in 2028, how are you all going to be net zero by 2050?
That's not part of our planning criteria. I appreciate and support the PPL commitment to do that. So first off, it's not part of our criteria. There are a number of things that could happen between now and then. Ultimately, if the right thing to do to benefit customers is in that time period to continue to operate these units without any carbon controls and quite frankly, for our company to continue to emit carbon as part of our service to our customers, we'll do that. And then corporately, we would have to look at offsets in that scenario as a practical matter to make the net zero commitment.
Yeah. So if the costs are you going to seek recovery of the stranded costs, or?
In that scenario, I wasn't, in my construct, contemplating any kind of stranded costs or unrecovered book value. We would continue to operate the assets in the least cost manner, compliant with all current environmental regulations to benefit our customers. We would not charge customers for the 2050 net zero goal in any way.
Crystal, can you put that exhibit on? Thank you. So I handed you a document earlier. I will mark this as, is it KCA 5?
6.
6.
No, hold on. Yeah, hold on 1 second. I've got an official record. It'll be 5.
Okay, thank you. Are you familiar with the North American Energy Standards Board?
Broadly, but not with any level of in-depth knowledge.
In there, they've got basically 20 recommendations, and this kind of ties into what I was asking you earlier related to the reliability issue. What are your concerns for reliability involving natural gas?
So that's a very broad question, so I'll try to be brief. As most know, we operate an LDC, local distribution company, that has provided gas service to about 325,000 customers for a very long time in Louisville. And as you know, since the early 2000s and even before that on the KU side of the company, we've been dependent on gas to provide load. Today at 90 degrees, gas is providing a significant part of our load. And so we obviously have concerns about every fuel that we procure, whether it be coal or natural gas, or whether we decide to operate units that don't need fuel. We have concerns about those, and we address those through a host of prudent practices, which I won't go into with this regard. So sitting here today, I'm not overly concerned, given all of our practices and all the plans that we take, with gas availability. We are aware and maintain knowledge base of what risks are out there for every fuel that we're dependent upon to serve our customers. And so I'm not saying we're not unaware of those situations that arise, the storms that occurred in Texas, obviously the event we had that affected our ability to serve load back in December. So I'm not overly concerned about any of those issues, given the practices that we employ.
Well, and hand in hand with that, Winter Storm Elliott it kind of highlighted kind of the concerns that KCA has relative to some of these reliability issues involving natural gas. Would you agree that it created a significant issue in PJM?
I am aware in PJM that they had far more unit forced outages than they anticipated. We're not a member of PJM, so I'm aware of that as general industry knowledge, but not as a participant in that market.
And same question I had for Mr. Crockett. Did you happen to read Senate President Stiver's letter addressing the issue where there was the outage involving gas as well?
Yes.
Okay, so you agree that happened as well?
It helped me with your question that
No,
that happened.
There was an outage related to a severe weather event involving natural gas.
And are you talking about PJM now, or are you talking about?
Mr. Stiver's letters.
that impacted the LG&E and KU system, yes, there's significant evidence in the record to that, and also our response to that.
And I would also tie in the fact, is it fair to say that the RFP request associated with the dual fuel is related to a reliability, enhanceability issue?
Correct. Having dual fuel, if it's evaluated to be the best option, provides a secondary fuel. Therefore, it would be there for reliability. No other reason to have it unless you plan to use it during a gas interruption.
Let's talk about PPAs, the solar PPAs. Okay. Do you agree they're not dispatchable?
You're talking about the solar PPAs now,
Yes, sir.
just to be clear. We do not, as the contracts are constructed now, have the ability to change the output of those facilities. They must take whatever they generate. We will pay the agreed price in those contracts for those megawatt hours that flow to our system.
And those PPAs, it's not included for replacement capacity for Senate Bill 4 purposes?
Correct.
Okay. What's the difference between the company, why is there a different viewpoint relative to the company-owned solar versus the solar PPAs? What's the difference?
And again, to be sure I'm answering your question, you mean as it relates to ability to control the output or the
Correct.
dispatch?
Yeah.
Quite simply, we will own those assets, and so we can control, if necessary, the output of those facilities. Our ability to operate those won't be governed by a contract. We'll own those assets like the rest of our assets and can choose to dispatch them or not.
Can you turn it off?
Yes.
Okay. When would you turn it off?
Well, only when it benefited customers, we would turn it off. And as we've put in the record, the level of solar that we anticipate on our system, we don't suggest that that will be a near-term problem, but if it ever became a problem, we would have the ability to curtail or, in your extreme example, turn those facilities off.
And obviously, they don't work at night.
Correct.
I think we're good, Mr. Chairman.
Yeah, I just have a quick question, Mr. Beller, and I'll give you an opportunity to introduce your witness. When you say turn off, do you mean actually throttle, or do you mean to curtail?
You could do both. Obviously, you could open the breaker and they not provide input. But inverter technology does allow you to scale back the amount of power from those facilities.
And that's just the inverter-based resources generally, or is that something special you intend on the two owned solar?
I'm not familiar enough with how independent producers install and what equipment they specify. I know in some markets it is a requirement that inverter-based technology be able to, move around and respond to changes in load. But for our system, we clearly, as you stated in your question, plan to install that on the two new solar plants that we intend to own.
So when you left MISO, and I say you, when LG&E and KU left MISO, you became your own balancing authority, is that right?
Correct.
Is that synonymous with balancing area?
Can be, yes.
Well, I guess the reference, I think Mr. Sinclair referenced balancing area a number of times in his testimony. Do you know whether it's used in that sense as being synonymous with balancing authority?
I would think they would be one and the same.
As the balancing authority, you have the option to curtail any generator due to safety or reliability or thermal issues, voltage issues across your entire area, correct?
Correct.
That would be the case for any generator connected to your transmission system, even if they're owned or not owned by you all. Is that correct?
Correct, if we follow all the procedures and rules. We couldn't do it in a non-discriminatory manner.
Yeah,
It has to be
I'm not-
consistent with all the rules and interconnect agreements that we have with those facilities.
You have authority pursuant to contingencies to do that, right?
Correct.
Under FERC approved rules.
Correct.
Okay. Is that what you're referencing when you make the distinction, that curtailability, when you make the distinction between dispatchable and non-dispatchable?
Well, I would look at these as two different circumstances. The curtailment for economics and other reasons, we don't retain that capability with respect to the 4 PPAs we have. But if in some extreme scenario, those assets were causing grid stability issues or any other issue you would contemplate, we would retain the ability to maintain the integrity of the grid. Again, consistent with all of the interconnect agreements and FERC requirements, we would be able to alter the output of those assets, if that's where you're going with your question.
Yeah, I'm trying to understand the distinction that you all draw, and I know I can wait till it's my turn, but here we are. I'm trying to understand the distinction that the companies are drawing between the PPAs and the cell phone in terms of dispatchability, because PJM is a balancing authority, correct?
Yes.
Okay, so its ability to, well, have you ever heard of self-scheduling as opposed to economic commitments?
Yes.
Okay, so that's the difference between running your own power plants in an RTO or a market area as opposed to being economically dispatched by the market, correct?
Correct.
Okay, so if somebody self-supplies and dispatches on their own instead of committing economically for the RTO to dispatch, that unit may be dispatchable, but it's choosing its output whenever it's choosing its output, right?
Correct.
Okay, so I'm trying to understand when you say that it's a market requirement, or it's your understanding that the markets require the inverters be put in. I'm not trying to testify for you, but my understanding of your response that the inverters be put in such a way that they can actually throttle the output. And so my question is, if you all are balancing authority as well, why aren't you all also able to have your open access transmission tariff or whatever tariffs apply to any generators connected to your transmission system to also have that same requirement?
We could, and I'm not familiar if we've taken that step yet as part of our specification to allow, we can do a post-hearing data response if that's part of our interconnecting requirements to connect to our transmission system, but we could. The distinction that I'm trying to draw is within the commercial relationship between our solar PPA providers and ourselves. We have not, from a commercial standpoint, factored in the ability to curtail them for non-reliability or non-critical issues.
Right, but is it an implicit that you're reading into Senate Bill 4 that dispatchability means dispatchability based on an economic basis?
That's part of what we've interpreted that to mean, is the ability to dispatch at any time, not necessarily in what we would call a reliability crisis situation where we're having grid stability issues.
So when you all are talking about dispatchable, are you actually talking about the ability to be dispatched or the expectation to be dispatched?
Well, in the case of, let's parse it based on the example we have in front of us. The 2 units we own, we're basing it on both the ability and to dispatch at any time we want for any condition we see fit, whether that's extreme reliability issues, economics, or otherwise. When we look at our relationship for our commercial providers, the only time we would contemplate dispatching those is not in a more of a free way, but in only those situations where the production of those assets would compromise the stability of the grid.
Based on your experience, are you all free to dispatch your system however you should choose, regardless of your interaction with the surrounding balancing authorities?
No, there are coordination issues. Obviously, we have a multitude of requirements that we balance load within our balancing authority. So that puts a constraint. We obviously are incented to do that, not generate any more than our balancing authority needs, nor can we generate any less. So that is the primary constraint. We can't cause other issues on other systems by the way we dispatch our unit. Our reliability coordinator, TVA, helps coordinate should those issues arise.
Mr. Malone?
I was just going to move to introduce the North American Energy Standards Board.
Mr. Riggs? Or, sorry. Mr. Ingram?
Are you moving to introduce this document?
Yeah.
The only thing I would note, Your Honor, just in reading through it, is this is an excerpt from what is an 80-page document. And looking at section 5 of the actual webpage, it appears as though there's a voting summary on each of the 20 recommendations. So while the group made 20 recommendations, the voting partners eventually voted, and so they weren't unanimous recommendations, and it might be helpful for the record to have a complete copy of this document as an
Yeah.
exhibit rather than this 3-page excerpt.
I appreciate you bringing that to my
I think it
noting
is.
that.
I think when I emailed it in, I think it had the whole thing.
He did. That's what I was going to follow up. If we're going to do excerpts, we just want to make sure that the actual version that gets included for for two reasons. First is so that all the other parties have the opportunity to use the entirety of the document for the rest of their direct or cross or redirect examination, and as well as making sure that whatever documents provided, the entirety of the documents available for briefing purposes, insofar as any other parties
For
want.
clarity's sake, I think the only one that I didn't do that with proxy statements, just because I knew you guys would have to be able to get to those. So.
Right. Is there any objection to the entirety of the NASB Gas Electric Harmonization Forum summary to be introduced into the record?
No, Your Honor.
All right, we'll include that as KCA Exhibit 5. Is that all, Mr. Malone?
Yes, thank you.
Nothing from Louisville Metro.
I'm going to miss it. Ms. Huddleston, you have... All right, let's go ahead. We've been going at for an hour while we're doing the crossover. Let's take a short 10-minute recess. Okay, we'll come back at 2:10.
Chairman, so this be our only afternoon.
the record case number 2022-00402. Ms. Huddleston?
Thank you, Your Honor.
Before you get started, we will take, to Mr. Cook's question, we will take our next break at about 3:45, and then we'll break for 40 minutes for dinner at 5 o'clock.
Thank you. Good afternoon, Mr. Beller.
Good afternoon.
And am I saying your name correctly?
Yes.
Okay. I'm Kate Huddleston, and I represent the Sierra Club in this proceeding. Mr. Bellard, do you have in front of you LG&E KU's initial discovery responses to the Attorney General and the associated attachments?
Have the AG responses to AG-1? Yes.
Yes. And specifically, do you have in front of you the response to the Attorney General question 13?
Yes.
And LG&E KU states that the responding witness is Lonnie A. Billar. Is that you?
Yes.
Excellent. And you were responsible for this response?
Yes.
So I want to direct your attention to your response A-13P, which is on the last page of the response to this question, and just let me know when you're there.
You said P, correct?
Yeah, that's correct.
Yes, I'm there.
And this question overall was about Winter Storm Elliott, correct?
Yes.
And you stated, it is important to note that one of the company's coal units was on a forced outage on December 23rd, and several coal units experienced derates during the course of the storm event. Is that correct?
Yes.
And what is a derate?
A derate, as referred to here, is the inability of the unit to reach full load due to equipment issues or other constraints.
And what was the coal unit that was on a forced outage at that time?
Trimble County 1 was on a forced outage. We had an issue leading up to the event with the bottom ash handling system of that unit, and so we're unable to operate that unit.
Okay. And I think we'll get into the specifics of this more later, but if you know off the top of your head, the several coal units that experienced derates.
Their subject check, there was a derate on a Mill Creek unit. There was a derate on Trimble County 2 and Brown 3.
Okay, thank you.
I don't necessarily have the unit numbers memorized, but that's my recollection.
And do you have in front of you attachment 1 to the response to the Attorney General question 13L, Winter Storm Elliott? It's titled, a document titled Winter Storm Elliott, Events in the LG&E and KU Balancing Authority Area, December 23rd to 24th, 2022.
Yes, I do now, correct. 9-page document?
Yes, that's correct. And Your Honors, we also have copies of this document in case other parties are unable to access them, and we're happy to pass them out to everyone or not to pass them out as you would prefer.
Just to be clear, this is the 9-page attachment 1 to response to AG1 question 13. Is it L or I? I think L.
I think L.
Okay, that's that document?
Yes, Your
Yeah,
Honor.
if you would like to pass it out, I know that maybe not everybody has the ease to get around our website, as maybe my experiences have been. So that'd be great. Thank you.
Great, thank you.
And would you like to mark this for briefing purposes, or since it's already a record exhibit, would you like to not mark it?
We'd like to mark it as SC1, please. And as that document is being passed out, Mr. Billard, you are the sponsoring witness for this document, correct?
Yes.
And you've seen this document before, you're familiar with its contents?
Yes.
And Mr. Billard, this document is an analysis essentially of what went wrong during Winter Storm Elliott in the LG&E KU Balancing Authority area. Isn't that correct?
Right. Yes, the events that led to the situation of a load curtailment.
And it's focused specifically on LG&E KU generation, is that correct?
Correct.
And who is the author of this document?
It was put together by a group of individuals. I wouldn't say that any one individual developed the document on the whole. Obviously, folks who were knowledgeable of our generation system, our transmission system, our distribution system, and the way we dispatch our units, and people that, if you will, lived through the event, all contributed to the authorship.
And these are all individuals employed by LG&E KU?
Correct.
Okay. And the document analyzes the entirety of the balancing authority area and issues during Winter Storm Elliott, correct?
Yes.
But it only discusses LG&E KU generation, as we just discussed, correct?
Yes.
And it does not discuss imports from the perspective of other companies.
Say that last part again.
It doesn't discuss imports from the perspective, I suppose, of other companies. It's sort of an LG&E KU perspective. Is that correct?
We were importing power during the timeframes discussed in this document. We were importing power from PJM, I believe, maybe even MISO during a short period of time, and we have a relationship with OVEC, and we would have been importing power from there. But with those descriptors, it's generally focused on the performance of our assets during the event.
And can you explain why this document chose to focus on the entire BAA, but also is talking sort of exclusively about LG&E KU?
Well, it's our obligation to balance load in our balancing authority, and so that was our objective function during that time. The focus on our assets are because our assets are the ones that had issue meeting their load obligation, our native load obligations in the BA. I'm not aware of any other challenges that load-serving entities in our BA had in meeting their loads on those days, or it clearly wasn't a focus of this document.
Ms. Huddleston, can I clarify, is Bluegrass technically within your all's balancing authority, even though it's pseudo-tied to PJM?
The Bluegrass generating units, yes.
And I want to draw your attention to the section that's titled Generation Events that's starting on page 3. Do you see that?
Yes.
And the document states, this narrative details the events across the LG&E and KU generation fleet over the course of the cold weather event. Is that correct?
Yes, somewhat time-stamped version of that, yes.
Okay, so there's several times in this account where the generation units are described by abbreviations, and so I want to walk through this and make sure that we're all on the same page about what generation units are being described and what happened. And so it starts, we're sort of setting the scene on December 23rd at midnight with the condition of the generation fleet. Is that correct?
Yes.
And at that time, Trimble County Unit 1 was in outage, as we were just discussing. Is that correct?
Yes.
And that's a 370 megawatt net unit. Is that correct?
Net of, it's a jointly owned unit with IMPA and IMEA. We own rights to 75%, so that's what the descriptor says, net exclusive of partners. So we had rights to 370 megawatts, or have rights to 370 megawatts of that plant.
And how many megawatts then do your, I did not have the new math as counsel for joint interveners, but clearly my math is suffering right now. How many megawatts did your partners have?
They, of CC1, they own roughly 125 megawatts.
Mm-hmm. And were those megawatts also in outage?
Yes, yes. The unit was offline at this point. It was due to the failure of the submerged drag chain conveyor hydraulic gearbox. That's part of the system that removes bottom ash from the unit. Inability to do that required that unit to be offline.
And why had that failed?
Why did it fail?
Yes.
Well, there was a failure of the gearbox. This is a large mechanism like a conveyor that moves bottom ash as coal is combusted in the boiler, falls to the bottom of the boiler. That ash has to be moved away The new design of this unit is to remove it from a submerged drag chain. Submerged means it's underwater. And that unit failed. We could no longer operate that conveyor. So as you continue to burn coal, ash built up in the bottom of the unit, and we could no longer run the unit.
And what was the cause of that failure? Why did it happen?
It was a mechanical failure of the drag chain. It basically froze up. We were unable to get it started from a stoppage that we had on the drag chain.
And this unit is a coal-fired unit, correct?
Correct. Yeah, gas-fired units don't have this equipment.
And so I was a little confused here. It says that the unit was available for up to 75 megawatts firing gas only here, but you just said the unit was offline. Can you explain that discrepancy?
Yes, so when you start a coal unit, you have to have startup fuel, and in this case, Trimble 1 starts on natural gas. And so with respect specifically Trimble 1, we can get roughly 75 megawatts out of that unit just firing it with gas before we put coal into service. If we would have had adequate gas pressures at Trimble County, we would have been able to run that unit at 75 megawatts without putting the coal mills into service, obviously, because we didn't have the drag chain in operation, as we mentioned.
And then, so that's 295 megawatts that's attributable to issues with the coal mills that was offline at that time. Is that correct?
Correct. The 75, if you're choosing to put it in columns, so to speak, would have been attributable to the lower gas pressure that we saw at Trimble County. Trimble County has 6 150 megawatt-ish combustion turbines, and they obviously need a minimum gas pressure to operate, so we were challenged in that regard. Obviously wouldn't want to, in a less efficient way, divert gas to the Trimble County 1 unit during that event.
And had that lower gas pressure already begun on December 23rd at midnight?
I do not believe it occurred. There's I think some graphs in the back that display exactly what times we saw those pressure deviations, but I don't believe it had occurred at this particular time.
Okay, so in other words, there was the 75 megawatts that could have been available at that time.
Right, but at that time, as this timestamp shows, we had 4,761 megawatts of generation was needed to meet our load, and so it wasn't necessary that we do that. And it just to be clear, that would not be routine at all to run a coal unit in that fashion. It would only be in an extreme emergency to avoid, curtailing load or something of that nature.
And were there any other coal units that were unavailable on December 23rd at midnight?
Unavailable? I do not believe so. I think this is a comprehensive picture of what we had available during that time. As we just talked about before, there were other units that experienced derates as we progressed through time.
And so please turn back to page 2 of this document, to the second full paragraph on that page, which begins, as conditions across the regional grid began deteriorating on December 23rd. So it's about halfway down the page.
I see that.
Okay, so in that paragraph, there's a sentence, the third sentence says, the LG&E and KU Balancing Authority, BA, had to shed load on 12/23 from 1758 through 22/11 by as much as 317 megawatts. Is that correct?
Yes.
Okay. And we just discussed that on December 23rd, there were 295 megawatts offline due to these mechanical problems that caused forced outages for this coal unit, correct?
Well, in totality, the full 370 megawatts were forced out. Is, I think, the proper way to look at it.
Okay. And that coal-fired unit, if it had not been offline due to mechanical reliability issues, would it have been available during the duration of the event, or at what point would it have become unavailable?
Every reason to expect, a unit can trip off at any time for a number of reasons, but we were not aware of any other issues. Had the one that we've been discussing not existed, we would have been able to run that unit and had 375 megawatts to serve load.
Okay. And so that means that LG and AKU would not have had to shed load during Winter Storm Elliott, is that correct?
In that simple math exercise, yes, we would have had ample generation to serve load had that unit not been forced off.
And that unit is a coal unit, correct?
Yes.
Okay. And so that was midnight on December 23rd. We have 370 megawatts of a coal unit offline. And so let's go back to what was happening during Winter Storm Elliott. So on December 23rd at 1:28 a.m., I'm looking at this timeline again, we have Brown 5, which is 130 megawatts, Brown 8, which is 128 megawatts, Brown 9, which is 130 megawatts, and Brown 11, which is 128 megawatts, all tripped offline due to an interruption in fuel gas. Is that correct?
Yes.
And those are all gas-fired CTs, that's correct?
Yes, these units also are available. 3 of these units are available to burn fuel oil also.
And I neglected to mention, when we were setting the stage, Brown 10 was in an outage, and that's 138 megawatts, and that was a forced outage, correct?
I'm not familiar if it was forced. You can see from the descriptor that it was out on 12/3. We could have categorized that as a maintenance outage, but for your purposes, either way, it was unavailable to be used.
And that's also one of these gas-fired CTs at Brown, correct?
Correct.
Okay. Okay, and so then at 3:10 a.m., Trimble County 2 derated by 37 megawatts due to low inlet air temperature into the air heater. Is that correct?
Yes,
Okay, and is that a coal-fired or a gas-fired unit?
coal-fired unit.
Coal-fired unit. And this document says, quote, "With the very low ambient air temperatures, the water coil air heater could not provide sufficient heat input to maintain full load." Is that correct?
Yes.
Okay, and that mechanical failure was due to weather-related issues, and it continued for over 4 days until December 27th at 4:30 p.m. Is that correct?
Yes.
Okay, and then, I wasn't sure about this. The Army Corps took 45 megawatts offline between 4:32 a.m. and 3:20 p.m. Is that correct?
Yes.
And that's the OF unit? What is that unit?
Ohio Falls, it's a run-of-river, it's a set of run-of-river hydro units. And without proper authority, we can't run those units based on river levels in Louisville.
Understood. So PR 13 is next, and that's Patty's Run 13, correct?
Correct.
And it's 175 megawatts and a gas CT unit, correct?
Yes.
Okay, and so then that's offline from 6:36 to 7:13 due to low generator gas temperature, correct?
Correct.
And that's because of a manual valve in the cooling water circuit that malfunctioned due to extreme cold, correct?
I believe technically we had set it to its winter flow setting, but given the extreme temperatures, needed to further adjust that.
Okay, so next we have CT peakers coming online, is that correct?
Yes.
And specifically, these are the Halfling units that were requested at 6:15, correct?
Yes.
And each of those is 14 megawatts?
Yes.
And so Halfling Unit 1 is running from 10:33 on December 23rd to 2:57 p.m. on December 24th, correct?
Yes.
But Halfling Unit 2 was not available from 10:33 on December 23rd to 2:57 because of yet another weather-related mechanical issue, correct?
We had a substation breaker issue, and then subsequent to not being able to get the unit online, the Louisville temp was too low to execute a start, yes.
And I know it says 2:57, but it seemed like quite a coincidence that for Halfling Unit 1, it was 10:33 on December 23rd to 2:57 on December 24th. But then Halfling Unit 2, it was 10:33 on December 23rd to 2:57 on December 23rd that it was unavailable. So just wondering if that might be a typo and should also be December 24th.
Say the last part again, I'm sorry.
Basically, I'm wondering if there's a typo or missing information, and that should also be December 24th for Halfling Unit 2 as for Halfling Unit 1.
It could be. I'm not familiar with those times specifically. It could be a typo in that instance.
Okay, so next we have Brown Unit 3, which is obviously one of the units at issue in this case, and it's listed here as 400 megawatts. Is that correct?
Correct.
And as we all know from these proceedings, Brown Unit 3 burns coal, correct?
Yes.
And from 7:17 a.m. on December 23rd to 9:15 p.m. on December 25th, Brown Unit 3 was plagued by D-rate issues. Is that correct?
Yes.
And those D-rates ranged from 62 to 76 megawatts. Is that correct?
Correct.
And this was due to, quote, problems with combustion process instrumentation, correct?
Yes.
And what does that mean?
Well, on that unit, we were having boiler slagging, which ultimately took the unit off, as you can see in the rest of the descriptor. So it was just the combustion process instrumentation. We don't believe that instrumentation issues were weather-related, just routine challenges that you can have in operating a unit.
Okay.
Mr. Beller, can you assume we're not all, no offense, but not all power system engineers, and explain to us what excess slagging is?
So within you're combusting coal within the boiler, and there's residual material, it doesn't fully combust, and you can create boiler slag on the tubes. Obviously, you try to minimize that. You want the heat exchange surfaces in the whole of the boiler to be as clear as it can to transfer all the heat you're generating by combusting the coal to the steam circuit. And so the boiler slag is what creates, and if you're unable to manage that slag, eventually you can't run the unit anymore. You can't get the adequate heat transfer and be able to continue to operate the unit.
And so then on December 25th, Brown Unit 3 had to come offline completely, all 400 megawatts. Is that correct?
Correct. After the event that we're discussing occurred. When we're in these generation emergency events, or when we're close on generation, obviously we're going to do everything we can to keep a unit running, and then take it off when those situations have resolved.
I have another clarifying question before you move on to the next bullet. Was the D rate there by 76 megawatts, the maximum D rate, or to 76 megawatts?
It looks like, we started off with a 62 megawatt D rate at the timestamp, and when we took the unit off on the 25th, we were up to a 76 megawatt D rate at that time.
So it was D-rated by 76 megawatts?
Correct,
Okay.
correct.
So 324 megawatts still available?
Correct.
Okay. And so then we see what I think are the issues that the company has talked about publicly, which is the pressure issues at Cane Run and Trimble, correct?
Yes.
So at 1:08 p.m. on December 23rd, Trimble County 5 has 179 megawatts go offline. Is that correct?
Yes.
And that's gas generation, correct?
Yes.
And that's due to the drop in gas pressure that we've discussed, correct?
Yes, if I recall correctly, we were seeing pressure D rates and Trimble 5 trip. There was, and I don't know if it's detailed, there was another issue with that unit, but I can't recall off the top of my head what that was.
Okay. And do you remember if that was weather related or not weather related?
I do not believe it to be weather related, but obviously subject to check on that.
And then at 1:47 p.m., Cane Run 7 has a D rate of 253 megawatts, correct?
Yes.
And that's also gas generation, correct?
Yes.
And
It's a
that's,
combined cycle unit versus a simple cycle unit at Trimble County, yes.
and that's due to the drop in gas pressure, correct?
Correct. Each of our generating units, whether they're simple cycle or combined cycle, have a minimum pressure that needs to be delivered to the machine to allow them to operate. Otherwise, they will trip offline based on their control set points. And so, and during this whole event, we were trying to manage that minimum pressure, not lose the generation that we did have, at the same time getting as many megawatts out of our machines as we possibly could.
And so then at 1:48 p.m., so I guess just 1 minute later, all of Trimble County has a 439 megawatt D rate, correct?
Yes.
And that's a loss of 439 megawatts, correct?
Correct.
And that's also gas generation, is that correct?
Yes, that we're referring to for the 439 megawatt D rate.
Okay, and that's again due to the drop in gas pressure, correct?
Yes.
And is that in addition to the 179 megawatts for Trimble County 5, or does that include those 179 megawatts?
I believe the D rate is in addition to the outage of the Trimble County CT.
Okay,
Because there were 5 other machines there rated at 179 megawatts.
I see. And it says that, quote, as previously noted, Trimble County 1 was available for 100 megawatts firing gas had supply been available, correct?
Correct.
Okay, and so then if we just talked about how Trimble County was available for up to 75 megawatts, can you explain that discrepancy?
The 75 would have been our share. It's a little mix and match here, which is hard to do with a joint-owned unit to avoid that, but this is referring to the total capability of Trimble 1. The 100 megawatts would have allowed us to take 75 based on the 25% co-ownership.
Gotcha. And again, Trimble County 1 is primarily a coal-fired unit, correct?
Exactly. As I described earlier, this gas-fired operation would be, I'm not aware that we intentionally operate in that mode for any extended period of time since we've had that unit in operation. So it would have been a very, very rare circumstance. So coal is its fuel.
Mm-hmm. And again, I just want to make sure I'm clear on this. So if it had never tripped offline, when it was operating as a coal unit, if it had never tripped offline, it could have continued sort of like happily chugging along on its way, subject to other weather-related issues throughout the period, correct?
Correct, utilizing coal.
Okay. And so, in fact, there were 2 failures here. Both the gas supply was not there, so you were missing these 75 megawatts of gas, but also the unit could not function as a coal unit, correct?
Correct.
And so next, at 3:48 p.m., Trimble County 2 experienced a D rate of 269 megawatts due to a frozen boiler feed pump transmitter, and that caused a unit run back that tripped a coal mill, which then went out of service, correct?
Yes.
Okay, similar to Chairman Chandler's question, could you please explain this for the rest of us?
So boiler feed pumps, multiple ones in the unit. Effectively, you want to think about it, it allows the steam circuit to work. It's moving the boiler water through the system. Apparently, we had a transmitter on that, so you're getting a bad signal. So to protect itself, the feed pump tripped, load was dropped. 269 megawatts. When load dropped, one of the coal mills tripped off. We didn't need that much fuel into the unit, and so we had a coal mill that tripped, and then we had to purge that mill, get it ready to operate again, because it tripped not on a controlled basis and an uncontrolled basis, and we carried that D rate until it looks like 2216. So the difference between 1548 and 2226 was covered in those events.
Okay.
Not an uncommon event. This wasn't, obviously the frozen boiler feed pump was somewhat weather related, but I think it's important to note when we design our system, we don't expect every unit to operate perfectly 8,760 hours a year, and so we manage these issues, weather related or otherwise, all the time, and that's of course why we have excess capacity, reserve margins and the like.
And so this is a mechanical failure due to weather, is that correct?
Ultimately, yes. The root cause of this was the transmitter that froze up, caused the boiler feed pump to trip, and the carry-on actions after that.
Okay, and so next at 4:13 p.m., Mill Creek 4 lost a coal feeder due to cold weather-related bunker issues, specifically that the coal tripper froze up, correct?
Correct.
And that sounds pretty similar to what happened with Trimble County 2. Are there differences we should know about? Or?
Definitely different. This was a mechanical freeze-up, if you will, that affected our ability to get coal into the bunker, which allows us to get it to the feeder, which allows us to get, and the pulverizers and to get it to the boiler. So it was part of that fuel delivery system that a coal-fired unit has. And so we weren't able to provide coal to one of the feeders, and therefore we had to take a D-rate.
Okay.
Each unit has multiple coal feeders, hoppers, and the like, and this one failure caused a D-rate of 121 megawatts.
Okay, and just to state the obvious, Mill Creek 4 is a coal-fired unit, correct?
Yes,
And that D-rate lasted until 6:44 PM on December 23rd, correct?
yes.
Were there any other coal unit outages, failures, D-rates, or instances of going offline during Winter Storm Elliott that are not documented in this document?
No, none that I'm aware of. As we started this discussion, the purpose here was to outline, blow by blow, the events that led to the curtailed load.
Can you please refer to LG&E KU's discovery response to the Attorney General that we were just looking at, answer 13O?
Yes,
You state that the total time duration during which rolling blackouts were instituted during Winter Storm Elliott was 5:59 PM to 10:11 PM on December 23rd, 2022, correct?
yes,
And you said already that the maximum load shed at this time, or the maximum amount of power that was unavailable to customers, was 317 megawatts, correct?
yes,
Okay, and so during that time period, we have Trimble County Unit 1, which is this 370 megawatt net coal-fired unit, unavailable due to mechanical failure, correct?
yes,
And then we have Brown Unit 3 that's derated, so subtracting 62 to 76 megawatts due to mechanical failure as well, correct?
yes,
So that's already 446, I want to say, or 432 megawatts of coal-fired power offline due to mechanical failures at the time of peak need during Winter Storm Elliott, correct?
yes,
And that is more than the 317 megawatts that was needed by LG&E KU customers during Winter Storm Elliott, correct?
yes,
And that's, again, just due to mechanical issues, not because of the storm, but just general mechanical failures with these coal units, correct?
yes,
Including a coal unit at issue here, Brown Unit 3, correct?
yes,
And so if that power had been available, there would not have been a need for rolling blackouts between 5:59 PM and 10:22 PM on December 23rd, correct?
yes. As we've been discussing, had there not been other unit issues at those two facilities during that time period, we would not have been required to curtail load.
So in addition to those 432 megawatts, also during this time period, we have some weather-related coal-fired outages. So we talked about Trimble County 2, a coal-fired unit is derated by 269 megawatts due to a weather-related reliability failure, correct?
Correct.
And then for the initial part of this period from 5:59 to 10:11, ending at 6:44, Mill Creek 4 is also derated by 121 megawatts, correct?
Correct.
And that was the most critical time in terms of customers being impacted by service outages, correct?
Yes,
So that's an additional 390 megawatts of coal-fired power offline due to reliability failures in the winter weather, correct?
259 and 121, is that your math?
That is my math. I'm hoping that's also your math.
Okay, I think that's 380, but yes.
That could well be right. Let's call it it's 390, I think. Because the 9 plus 1 creates another 10.
Okay,
Okay. So that's 432 plus 390 is 822 megawatts of coal-fired power that was offline from 5:59 PM to 6:44 PM when LG&E KU was implementing rolling blackouts, correct?
yes,
Which is much greater than the 317 megawatts of load shed during that time, correct?
yes,
And even once Mill Creek 4 came back online at 6:44 PM, so that's, you're adding another 121 megawatts back on but you're still at 701 megawatts offline of coal-fired power, correct?
Yes.
And if those megawatts of coal that were offline due to the mechanical failures, the reliability failures, those 701 megawatts had been online starting at 6:44 p.m., again, we would not have seen rolling blackouts in LG&E KU's service area, correct?
Yeah, all other things being equal, yes.
So in other words, the idea that gas was unreliable and for that reason alone, LG&E KU had rolling blackouts, that's not the entire story, correct?
Correct. As I stated earlier, we would not anticipate our system to operate perfectly during any moment in time, much less an extreme weather event. So that is true. It wouldn't necessarily have been what we'd expected to have every single megawatt of our coal-fired generation available. But with that caveat, yes, that's true.
Does the company forecast a percentage of your coal-fired generation that you expect to be offline at any given time?
It depends on in what case you're talking about. If you're talking about day-to-day planning, we obviously know the condition of our units. If we don't expect the unit to be on a maintenance or going into a maintenance, we're not aware of some emerging issue on the unit. We don't necessarily make a prediction of when a unit may be forced out. We have operating requirements where we carry a certain amount of generation that's online, spinning reserve, other requirements that account for that. But in that context, we don't make projections. In various other contexts, we do make projections when we're doing planning, reliability analysis, and when I say planning, longer range planning.
So in that longer range planning or reliability analysis, what percentage of coal units do you predict to be, or coal megawatts, I guess I should say, do you predict to be offline at any given time?
Sure, it varies. Each unit has its own operating history and characteristics, and so we have an assumption. We have a forced outage rate assumption and then an equivalent forced outage rate assumption for each unit. The forced outage is what we think the percent of time a unit would be offline, and then the equivalent forced outage includes times at which it may be derated for various issues online, but not available for full load. And so those assumptions are all detailed in the record, what we assume for each of our assets, but each unit has a different assumption.
And do you remember off the top of your head, sort of sweeping across the system, if you were to total up all of those coal units, what the percentage of the coal megawatts offline would be?
No, you would have to do that calculation. I don't have that number off the top of my head.
And do you have an equivalent sort of percentage derate for coal units, or percentage that you expect to be unavailable, I should say, for coal units during winter weather?
You know, we've actually done some analysis. It's in the record. We don't typically see forced outages accelerate in an atypical way during events. Obviously, we have situations here, but as a general rule, we're able to mitigate most of those weather-related events. You could pick another day on our system. We can have other mechanical issues unrelated to weather. But I know there's some information in the record where we detail that out, and what's been our past experience about weather-related derates and how weather impacts our assets.
And as you're sitting here, are you able to describe other occasions, or think back to other occasions where you've had coal-related outages in winter weather?
Of course, again, some of those outages could be during winter weather, but unrelated to the actual weather itself, or some of them could be, as we discussed here, related directly to the weather.
And so going back to the events of Winter Storm Elliott, so the mechanical failures of LG&E KU's coal plants alone were also enough to account for the needed megawatts that were missing that caused rolling blackouts, correct?
Yes, all other things being equal.
So LG&E KU could not count on its coal units to perform during Winter Storm Elliott when they most needed to be called upon, correct?
I wouldn't agree with that statement. As we just discussed, we anticipate any mechanical asset having a failure rate. We do a lot of planning to account for those failure rates and how we would meet our ability to meet load. Had we not had the gas pressure derate, we wouldn't have had the curtailment either and wouldn't have had any of the issues. The megawatts of coal derate and coal forced outage, we could have worked through that and still been able to maintain our system. So I wouldn't point the finger solely at coal units. No asset is perfectly available all the time, 100%. Gas units, coal units, renewable resources are not available 100% of the time. And so all that's factored into our planning. So I wouldn't point the finger at coal units specifically in that instance.
So would you say your planning is sort of probabilistic in a way, like you're estimating the likelihood that a unit is available at any given time?
Again, it depends on the time frame in which you're talking about planning. Clearly, our long-range planning looks at and our establishment of reserve margins, our predictions of the probability of loss of load in a planning perspective. All that is done probabilistically related to what we believe the outage rates of our facilities will be, which is partially informed by history and what we see in the future.
Okay, so I want to go back to the LG&E KU situation during Winter Storm Elliott. So you mentioned OVEC before, and there were points at which OVEC contributions fell 150 megawatts short, correct?
If it's detailed in the memo, I don't remember that fact specifically, but I know we had challenges with OVEC, both in their ability to provide load, and there were some issues with the ability to import that load.
And OVEC contributions are, again, contributions from coal-fired generation, correct?
Are a what?
Contributions from coal-fired generation.
Yes, OVECs are a series of, I believe, 11 coal-fired units.
Okay, so LG&E KU and TVA are part of an automated reserve sharing group, is that correct?
Yes.
And what is an automated reserve sharing group?
So there are, I mentioned it lightly before, there are requirements that you maintain certain online or / spinning reserves on your system. And the criteria of those are either the loss of load of your largest unit, or if you're in a pool, you can look at those benefits of being in the larger pool. And so we're in with TVA. And so we pool our resources on a day-to-day basis so that the reserves that each of us have to maintain are lower than they would be if we did that individually.
And during Winter Storm Elliott, TVA's Cumberland fossil plant experienced issues, correct?
To my recollection, yes, it did.
And that is a coal-fired unit, correct?
Yes.
Okay, so I'm looking at external impacts, which is page 5 of this handout. And in the external impact section, it has a timeline that details the interaction between LG&E KU's balancing authority and external entities whose actions impacted the LG&E KU system, correct?
Yes.
Okay, and so we just discussed OVEC, which is on that list somewhere. I think OVEC actually might be detailed in the narrative above, but maybe didn't make this list. So LG&E KU was receiving exports from PJM, correct?
We were purchasing power from PJM at various points, yes.
Mm-hmm. And at 4:29 p.m. on December 23rd, PJM curtailed export to LG&E KU for 400 megawatts. Is that correct?
Yes.
And was that 400 megawatts an ordinary 400 megawatts you normally count on from PJM, or was that a purchase above what you would normally purchase, LG&E KU would normally purchase from PJM?
I wouldn't necessarily categorize it or above or below. It was what was available to be bought. We don't necessarily depend on a daily basis when we look at our fleet unless we've already established the economics of a purchase or the availability and the economics of a purchase. So this is what was available in response to what we were seeing on the system. So I wouldn't really say it was more or less than we would have bought. We, again, wouldn't go into a day absent known conditions planning on buying from PJM unless we'd already established the economics and availability of that power.
Well, I just, clarifying question. This 400 megawatts that you were buying from LG, you were buying from TVA, but for that 400 megawatts, you are an EEA3.
The 400 megawatts, yes, correct.
That's not like an economic, like, power in PJM is $17 a megawatt hour, we'll take it all we can at $17 a megawatt hour kind of thing. It was, you were desperate for power. Is that accurate?
Correct. We were looking for all sources of energy to avoid going into a curtailment mode of operation, yes.
Okay, and so for how long were those 400 megawatts of PJM, I guess, imports from the perspective of LG&E KU unavailable to LG&E KU?
I would have to study this chronology. Obviously, it was unavailable for the time period in which we curtailed load. If we go down on the paper copy, if it has an additional, I don't know if we reestablished the purchase or not. I just can't recall off the top of my head. It doesn't look like we established the purchase, but if we did, it would be detailed in here. So once it was curtailed, we were into, after hitting the automatic reserve sharing and moving into EEA3 and curtailing load.
Mm-hmm. And so, can you explain for everyone what EEA3 means, please?
It's just a classification of where we're at on the system, and EEA3 is necessary to be declared, and we part of that is up to curtailing load, and so that's the mode we were operating in to maintain our required balance of load and generation within our balancing authority.
And it's an extraordinary or an emergency situation, correct?
Yes, up until this point, we've never curtailed load in the history of our company.
And so why were you unable to purchase the 400 megawatts from PJM? Because at that time, PJM decided to keep the power within its own regional transmission organization?
I presume that to be the case. It was unavailable. There wasn't the ability to purchase from PJM, MISO, or any of our other interconnected entities.
And that's because LG&E KU is not part of a regional transmission organization, correct?
I wouldn't say that. It's hard to say, obviously, but that there wasn't 400 megawatts available in PJM. There was not 400 megawatts of excess capacity. I guess what I'm trying to say, I can't tell you if we had been in an RTO, had we been in the same situation. We very well could have been in the same situation.
So, well, I take your point that you could have been in the same situation insofar as, maybe in some situation there would be some missing load to make up. Isn't it the case that LG&E KU is de facto last on the list after all of the utilities that are within PJM or within MISO because LG&E KU is outside of those organizations?
I don't know enough about their practices to say we're last on the list, but there was clearly no power to be bought. It was needed to meet the needs of the operating companies within PJM.
Isn't LG&E KU lower on the list than all of the utilities that are within the RTO?
I would say their priority is to meet their needs first, yes.
Okay, so if LG&E KU had had access to the 400 megawatts it was requesting, LG&E KU would not have needed to shed load, correct?
Correct.
Okay, and I see at 4:29 p.m. the Automated Reserve Sharing Group called for 400 megawatts. And can you explain what that means?
So that is a feature that we can, what we characterize it as hitting ARS, and allows a short-term supply of energy into your system until you can either make up for that, let's say at the top of the hour through a purchase, or in this case, as I testified earlier, the only time we've had to do, and that's curtail load.
And so I guess I am wondering the sequence of events. Is it that you called for 400 or the automated reserve sharing group called for 400 megawatts, thus LG and EKU requested from PJM where it was unavailable? Or is it that LG and EKU attempted to purchase from PJM, it was unavailable, and that led to this automated reserve sharing group call?
It was the latter of your description.
Okay.
Right. We were, the imports were curtailed, then we called for ARS, and then you can see at 16:45, we declared EA3 and moved toward shedding load at 17:58.
And so what happened between 4:29 p.m. and 4:45 p.m.? Is it that there were not 400 megawatts available within the automated reserve sharing group?
I don't recall specifically. Obviously, our load situation as it evolved between 1629 and 1758 necessitated that we curtail load. Mr. Schramm can talk to the specific details of the ARS, but to my recollection, that would have been coming from TVA as our reserve sharing partner.
And I saw at 6:05 p.m. or 18:05, end of TVA curtailment tag. Can you explain what that means?
Maybe go on to the next page and see if it says.
I think it's at the very bottom of page 5,
Okay,
the
all right,
last,
go back up.
last bullet.
I am not specifically familiar with what that particular notation means. So Mr. Schramm could give you the detail on that.
Did TVA curtail, I guess, exports or power sharing with LG and EKU at any point during Winter Storm Elliott?
Say that again.
Did TVA curtail, I guess, exports or power sharing with LG and EKU at any point during Winter Storm Elliott?
Well, when TVA, as it states here, entered an EEA3, they were in a load shed situation similar to us, so obviously they were focused on their load, so reserve sharing and other activities that we jointly procure with them, they withdrew from that.
Mm-hmm. And why did TVA have those curtailments or have that EEA3 situation?
So TVA had a host of issues. They had natural gas units out, coal units out. I'm not, familiar with all the particulars, but aware that they had a host of system issues related to cold weather.
Fair enough. And that was, again, for both coal and natural gas, both of those
Yes.
sources. Okay. Okay, so if we were going to sum up what happened during Winter Storm Elliott, and I appreciate your patience so far. So you've previously testified that the company has had a significant shortfall due to Texas gas supply derates, correct?
Yes.
And at 5:59 p.m., when the companies began shedding load, they were in that shortfall, correct?
Say that again, I'm sorry.
At 5:59 p.m. on December 23rd, when the companies began shedding load, they were in that gas shortfall, correct?
Yes.
And in addition to that gas shortfall, the companies lacked all of the coal-fired generation that we've described, more than 800 megawatts at 5:58 p.m. that otherwise could have been available but for reliability failures, correct?
Yes.
And additionally, because the companies, PJM curtailed 400 megawatts worth of imports to keep for their own member utilities, correct?
Correct.
And the lights stayed on in PJM for PJM's member utilities, correct?
I believe so. I don't believe they had to take the last step to curtail load.
And that includes PJM's member utilities in Kentucky, correct?
As far as I'm aware, the PJM membership didn't have any issues meeting load during that time.
Okay, and so we talked about there was 844 megawatts missing from LG and EKU's own coal generation, 150 megawatts missing from OVEC's coal generation, and 400 megawatts that was curtailed because PJM chose to hold it back for utilities that are its members, correct?
I wouldn't necessarily say that PJM held it back. We, as I stated earlier, we wouldn't have depended on that 400 megawatts had we not been in this condition. I would just say that it was not available for purchase yet.
Mm-hmm, mm-hmm. And I think I misstated that 822 megawatts. But so if we're summing all of these together, that's 822 plus 150 from OVEC plus 400 from PJM. So that is 1,372 megawatts unavailable for reasons besides the gas pressure drop, correct?
I would agree with your characterization except for the 400. I wouldn't have considered it unavailable. That would have not been something we planned on to use to meet load that day, but the rest of the assets were clearly unavailable, yes.
And the other thing is, it seems in a way like there could have been more load shed if the Brown Unit 3 going offline December 25th, rather fully offline December 25th rather than December 23rd is in a way kind of a lucky break for LG&E KU, correct?
I wouldn't call it luck. I would say it's a skill of our operators to be able to keep that unit online.
Fair enough. And so this means that when we're thinking about the event in its entirety, there are a variety of causes of the 317 megawatt load shed on December 23rd, correct?
Yes.
Okay. And in this instance, it was not the case that coal generation was 100% available when the companies needed it, correct?
Correct, nor do we plan for it to be.
Mm-hmm. And if coal generation were always 100% available when the companies needed it, the companies would not have had rolling blackouts during Winter Storm Elliott, correct?
That's true. Same could be said of our gas generation portfolio. Had it been 100% available, we wouldn't have had to curtail load either.
Mr. Villar, are you familiar with the phrase correlated outages?
Yes.
Okay, what is a correlated outage?
Well, obviously, different people can have different opinions, but events that affect more than one asset at a time would be my general, as we've been talking about in this case, explanation of that.
So this is an example of correlated outages, correct?
Which?
Winter Storm Elliott is an example of an event that caused correlated outages, correct?
Correct. You could look at that, particularly as it relates to the pressure issue, because that affected multiple assets at multiple locations due to one event.
And you could also say, if you're taking a broader lens, that Winter Storm Elliott's extreme cold weather caused multiple coal plants to go offline or derate, correct?
Some of those issues, as we've gone through in detail, were related to the weather, correct?
And so that's another example of correlated outages, correct?
It could be, depending on how broad your definition is, correct, with respect to weather.
Okay, so finally, the companies are seeking a 4-hour, 125 megawatt battery at the Brown site, correct?
Yes.
If that battery had been available during Winter Storm Elliott, what would have been the impact on the period of peak need for LG&E KU?
So if it were operating as designed and available, we've been able to use 125 megawatts of that energy for up to 4 hours. Had we not used it until the time if it had been fully charged at the beginning of the curtailment, obviously it could have offset some of that curtailment.
And could you please refer to your direct testimony at page 17, lines 12 through 13?
Sorry, what page, please?
And I apologize, I believe this is not your direct testimony. This is the hazard of writing these things down. Rebuttal testimony, page 17.
Okay.
And please look at lines 12 through 13. And so there you are discussing the proposed battery at Brown, correct?
Yes.
And you described, quote, "the advantages of having flexible backup power to complement an expanded reliance on intermittent generation," correct?
Yes.
And one of those advantages is that during extreme weather, when generation is less reliable, the idea is that you have additional backup power available in a battery, correct?
Correct. Obviously, that could be said about other assets, but for sure in the case of a battery, if it's fully charged, it would be available to be able to discharge and meet customer load.
Great, thank you. And I want to switch gears a little bit and talk about.
Ms. Huddleston, if we're switching gears, it may be a good time to take a short recess. So we'll take a recess until 3:30. We'll come back and then we'll push until a little bit after 5. Thank you. All right, we'll be in recess for 15 minutes. We're back on the record. Counsel, would you like to continue your cross-examination?
Thank you, Your Honor. Mr. Ballard, before we move on, I actually realized I have a couple more questions about what we were talking about regarding coal plants and sort of sussing out their percentage D rate. And you said every unit is different. What are the values for the units that are at issue in this case? Mill Creek 1 and 2, Gent 2, and Brown 3.
So it's in the record. I don't have those forced outage rates committed to memory, but we can definitely provide those. It would have been in the files that Mr. Wilson would have produced that relate to the assumptions that were input into the models that he used to perform his analysis.
Okay, thank you. Okay, so I'd like to shift gears now to RTO membership. Could you please refer to page 27, line 18 of your rebuttal testimony?
Yes, I'm there.
Okay, so you state RTO membership will not allow Mill Creek Unit 1 and 2, Brown Unit 3, or Gent Unit 2 to avoid the environmental compliance challenges discussed throughout our analysis, correct?
Yes.
And these units in an RTO membership scenario will need to comply with EPA's regulations, correct?
Yes.
And you further state, finally, RTO membership will not increase the economic life of these units or change their lack of cost effectiveness under the analysis presented in this case, correct?
Yes.
So I'm wondering, maybe let's single Gent 2 out as an example. Joining an RTO won't prevent Gent 2 from having to engage in environmental compliance. What do you mean by that?
Well, in order for Gent 2 to continue to operate, whether in its current state in a non-RTO state or in an RTO state, Gent 2 will still be subject to all the EPA regulations and limitations that exist.
And when you say it won't increase the economic life of Gent 2 or change its lack of cost effectiveness, can you say a little bit more? What do you mean by that?
Really just that. It has nothing, RTO membership wouldn't extend the life of the asset in our view. If it became uneconomic to operate, as in the case of Brown 3, I know we were using Gent 2 as an example, we don't believe that RTO membership would suggest that we operate that unit any longer than we would under our construct that we operate in today.
Understood. And so for a utility in an RTO, the utility continues to own its own generation, correct?
Yes.
Mm-hmm. And so if the utility is part of the RTO market, the utility is bidding its generation into the broader RTO system, correct?
Depending on how they participate in that market and what RTO you're talking about. But ultimately, the RTO, ultimately based on the construct, decides how those units are utilized.
Mm-hmm. And so in certain constructs in an RTO, you can have essentially a bidding stack, and all of the generation lines up in the bidding stack, and the least cost generation needed to meet requirements is successfully bid into this centralized market managed by the RTO, correct?
I know there's a set of rules. I'm not intimately familiar, since we're not in an RTO, of those rules, but effectively, units are, I think in the broader sense, dispatched by a central resource, not by individual companies that are members of an RTO.
And so then the utility is also, kind of broadly speaking, purchasing the least cost generation from all of those stacked up bids from the central market, correct?
My understanding of general RTO construct, that the utility, if they own assets, those assets would be dispatched by the RTO, and they would receive the revenues, if we're talking about the energy market, from the LMPs at those generator buses based on how those units are dispatched and to the quantity in which they are dispatched. And then by the same token, the load serving entity in that RTO would be responsible for buying generation to meet their load requirements, and you would be responsible for the balance between those two sets of configurations.
So in the company's view, in an RTO, Gent 2 would not be able to compete in that marketplace because its generation would not be the least cost generation or essentially meet that threshold, correct?
Well, what we are saying here is Gent 2 would have a compliance decision to make regardless of whether they were in an RTO or not. One would make a different calculation if you were in an RTO and you own these assets. Your calculation would be, if you're in a traditional RTO, would the revenues I can generate from that unit being available satisfy the incremental cost to keep that unit operating? We look at that in a sense of serving our native load, and there can be shades of gray in between that depending on what your current regulatory construct is.
I'm sorry, why would that be the case? Why is the first calculation the calculation that a utility would use in an RTO?
I'm sorry, Chair, ask your question again.
Yeah, why is it your position that the calculation for a vertically integrated utility that's a member of an RTO calculates their, makes a determination about their own resources differently than a utility that's not part of the same utility that's not part of an RTO?
So what I was intending to say is you could, I wasn't saying that you should. Our view, if we were in the RTO, would still be to maintain our ability to serve load, but there would be the additional overlay, as I was describing, of the revenue produced by those units against the cost of serving load in an RTO construct.
Right, but it would be net revenues, right? So if you're, let me just clarify the question. So if you're in PJM and you're in a capacity market and you are, let's say you have an adequate amount of generation, whatever that means. You have exactly the reserve, target reserve capacity reserves that you would need. So let's say the PJM 18% reserve margin, you had exactly 18% reserve margin. And you were required to bid in and then buy back the entirety of your demand. You would literally just be paid the clearing price, and then you would pay the clearing price, but the net dollar difference would be zero, right?
Well, again, others could be more versed on RTO economics than I, but I don't know that there's exact correlation between what we would pay to meet our load in this hypothetical construct or any vertically integrated utility and what they receive for their generation. I'm not sure that those are precisely correlated.
Well, it's like PJM just has a single clearing price capacity market. So whatever the marginal unit's clearing price is what all capacity is paid, right?
Yeah, yes, if you're talking, I was talking about the energy market, not the capacity market.
And that's fine. I just wanted to for the full. So that's the case for capacity market, single clearing price, and then on the flip side, the energy markets, load and generator LMP and markets are usually not, if they're in the same geographic area, are usually not very different. Is that your experience?
Well, we're not in an RTO, so I wouldn't necessarily have that experience to call upon. But there could be differences, is my general understanding.
So you think you would, if you had a generator next to load, and you had a node that was your generator node, and a load that was your generator node, you would expect, absent constraints, that the generation in that geographic area, security, terrain, economic dispatch being what it is, that the generation is at LMP is effectively being paid what customers are paying in that general geographic area, right?
Well, absent congestion and other things in that simplifying assumption, yes.
And that's what I'm trying to ask. Your assertion that it's just different, it's a different going forward calculation for RTO membership versus non-RTO membership, all else equal. You were talking about revenues, but that should be net revenues.
Correct, net of what you receive. Your generation would produce certain financial benefits in an RTO,
okay,
and your load would incur certain financial cost, right? And you would need to look at the net of those to see how those interact for the benefit of the customer. Because
Go ahead.
I'm assuming in this construct, we remain vertically integrated. Generation is recovering costs in the regulated utility construct.
And that's why I want to be clear about your response to Ms. Huddleston. Are you saying that you all would necessarily do this entire process differently, whether you were a member of MISO or PJM or not?
So obviously, if you assume that the capacity market and the energy market somehow is equal to the cost of serving load, we wouldn't do that. But wouldn't consider myself an expert enough in the RTOs to appreciate that that's always going to be the case. Your capacity market varies based on the auction price, as you said, the clearing price of capacity. And I'm unsure what I'm going to receive in that regard. I'm in a vertically integrated status, right? And so I'm going to assume I get to recover ultimately my net cost and cost of serving load. So I guess what I'm trying to say is I'm not sure we would plan exactly identically if we were in an RTO as we do today, based on those net revenues, capacity plus energy, not all the time equaling our cost to serve load in that construct.
Okay, just so I have an appreciation for what you think the distinction is, what you expect possibly the distinction to be with RTO membership is you would do effectively this type of resource planning and then take into account, assuming that is your, and then you would layer on top of this the impact those decisions have vis-a-vis the market.
Correct.
Okay.
Okay, so were the companies to sell the power from Gent 2 to Kentucky Power in a way that's similar to creating a mini RTO energy market, correct?
Please re-ask that. I didn't quite follow the question part of that.
Okay, so are you aware of the proposal in this litigation for the companies to sell Gent 2 power from the Gent 2 unit to Kentucky Power?
Yes.
Okay, so that proposal in a way is similar to creating a mini RTO energy market, correct?
No, I mean, hypothetically, if we entered into that, I would see it in two constructs. It could be a unit sale, the whole of Unit 2 could be sold, a unit participation agreement could be established where, as I just described, we have at Trimble 1 and Trimble 2 with our two partners, or it could just be a simple bilateral purchase power agreement with terms and conditions associated with it.
Okay, and it of course wouldn't have like protections like reliability backstops, et cetera, that you find in the RTO?
Those would all have to be negotiated, whatever reliability terms that you'd want to place with that unit sale.
And I guess the point I'm getting to is you don't expect that Gent 2 is economic for LG&E KU ratepayers, correct?
The whole of our analysis details out the economics of Gent 2, and we're asking to be able to retire it, and so thus we don't think its continued operation beyond the proposed retirement date is economic for our customers, yes.
And we were just talking about how you testified that you don't expect Gent 2 to be cost effective in an RTO either. You discussed environmental compliance and then you discussed lack of cost effectiveness, correct?
I didn't intend to say, as the chairman and I discussed, we haven't done that analysis and we're not in an RTO. And what we were trying to say in my rebuttal testimony is we would still have those environmental issues to deal with and challenges to deal with if that unit were to continue to operate, whether it be in an RTO construct or in our current construct.
And those environmental issues would have associated compliance costs, correct?
Correct.
And so I guess,
or unit limitations, just to be clear. We've evaluated a number of scenarios where we only operate Gent 2 outside of the ozone season.
and so I guess what I'm getting at is the company doesn't want to keep Gent 2 for LG&E KU customers. Your rebuttal testimony suggests that Gent 2 is not something that you see competitive on an RTO marketplace. And so selling Gent 2's power to Kentucky Power customers would necessarily mean that either Kentucky Power customers were losing out on a better possible deal, or LG&E KU is selling the power at a rate that's creating a loss that makes it not economic for LG&E KU customers, making them in effect subsidizing Kentucky Power customers, correct?
So there's several parts of that question. One part in the middle, I'd reinforce, we have not done an analysis of the economics of Gent 2 and an RTO construct. So we are not saying that with my rebuttal testimony. But we did say, and the evidence in the record suggests and supports the retirement of Gent 2 based on the analysis that we've done in the record based on our current construct. And any purchase power agreement that we would contemplate should we not receive approval to retire Gent 2 would be subject to approval and would be to the benefit of our customers, or we wouldn't enter into that arrangement.
And I guess what I'm trying to say is if it were to the benefit of your customers, it would necessarily be to the detriment of Kentucky Power customers compared to what they could receive on the open market, given the economic issues associated with Gen 2, correct?
You know, obviously that would be up to AEP to determine if they had an interest in that. I can't make that determination as we sit here today.
Okay. So let's move on. Mr. Bellart, can you please refer to your direct testimony at page 4, lines 6 through 9?
What are the line citations again, please?
6 through 9.
And page?
4.
4, okay. Page 4. Okay, go ahead and read that passage so I can see if we're on the same page, literally.
Sure. So you state the fully implemented Good Neighbor Plan, as discussed in Mr. Wilson's testimony, makes it uneconomical to continue operating these units because it is uneconomical to equip the units with selective catalytic reduction (SCR) controls.
That's not where I'm at. We are, maybe I'm in the wrong document here.
I apologize. And
It has two pieces of direct testimony.
it
One
may
in
be
402 and one in 122.
it may be in
Is it-
122. I apologize.
Mr. Lovekamp need a little bit of time to get to the 122 record.
I'm not sure if that's it, Ms. Huddleston, either, but it's your question.
Okay, why don't we skip that and move on, and we can see if we can come back to. Oh, you know what? It's page 3 of your direct testimony. It's page 4 of the PDF.
Which direct?
Your original direct testimony in 2022-402. I apologize. And so it's the lines 6 through 9. It begins the fully implemented Good Neighbor Plan.
Yes, we're on the same page now.
Excellent. So you state the fully implemented Good Neighbor Plan, as discussed in Mr. Wilson's testimony, makes it uneconomical to continue operating these units because it is uneconomical to equip the units with selective catalytic reduction (SCR) controls or operate them only outside of the ozone season of May 1st to September 30th. Correct?
Yes.
Okay, so since the beginning of this case, the underlying reason for the requested retirements of Gent Unit 2 and Mill Creek Unit 2 is the fact that environmental compliance makes the units uneconomic, correct?
Yes.
And that remains the underlying reason for the requested retirements, correct?
Yes.
And are you concerned that placing an SCR on one of the units at issue in this case could, down the road, lead to stranded asset costs as the unit is no longer economic?
So we've done analysis with respect to Gent 2 in the case that shows how long It would need to run to evaluate out on a net present value basis to be least cost under different scenarios. But fundamentally, we've looked at the economics of that investment, and we've not necessarily looked at it from a stranded cost standpoint. But if we were to install an SCR, operate it for the study period, what would the economics of that be? We would assume if we're going to install an SCR, we would continue to operate it, continue to make the improvements necessary for that unit to be reliable.
Are you concerned that if, in this case, you did not receive a retirement order, and instead you ended up in a situation where you had to install SCRs on these units, that down the road, SB4 may make stranded asset recovery more difficult?
Trying to understand the correlation between the two issues. We believe we met the requirements of Senate Bill 4 in this case. Again, back to the premise of our analysis, we've proven that operating these units with SCR is not economic and won't benefit our customers, and therefore we are, in the context of the December 15 analysis and then with the overlay of the Senate Bill 4 analysis, recommending their retirement.
Yeah, let me put it another way. Are you concerned that, so imagine a hypothetical world in which you did not receive the order you're seeking for the coal retirements, and instead you needed to install SCRs on the units. And so then you're in a place where you've spent this additional money to install SCRs. Are you concerned that if you then, at some point you're going to have to retire these units, and so then later down the road, when you come back to the commission again seeking retirement proceedings, once you've spent that money on the SCRs, are you concerned it will be more difficult to retire the units given that additional money that had to be spent?
Well, as a general rule, we have the obligation to make prudent decisions. We presented a prudent decision to our commission if they were to disapprove that, and in a sense, give us limited options to respond to these environmental rules. I wouldn't be as concerned. Obviously, commissions change over time, but we would have had fewer alternatives to meet customer demand at that point, and adding the SCRs would have been really the only practical way to do that in the short time that we'd have to meet these environmental obligations.
Okay, please refer to your direct testimony at page 26, lines 4 to 14, and this is your original direct testimony. Let me make sure it really is page 26. This is the part where you discuss, did the companies consider an RTO membership in their analysis?
Yes, I'm on that section.
Okay, so the question states, did the companies consider RTO membership in their analysis? And you responded yes, correct?
We had looked at an RTO membership analysis, as we've done on a fairly frequent basis over the last several years, and filed that with the commission, and I believe that's what this section of testimony references.
And was this membership analysis the 2022 RTO membership analysis?
Yes.
And this was the analysis that the companies refiled in May 2023 as corrected, correct?
I have our RTO analysis here that's in the record. The copy I have is dated November 22nd. I'm not aware if we filed a corrected version of that. Maybe another witness would be aware of that.
And so in May 2023, in these proceedings, you're not aware of the companies refiling an updated RTO membership analysis?
No, my recollection is we had a commitment to file annually an RTO membership analysis, and we met that commitment back in November 22.
So you're not aware of an error discovered with this 2022 membership analysis that led to an updated version.
Again, another witness may be, but I'm not aware of that.
Okay, do you know which other witness we should speak to about that?
Mr. Sinclair
Okay.
would be someone we could explore that with.
All right, so Mr. Billart, the companies have taken the position, as I understand it, that the environment is too uncertain to undertake joining PJM at this time, correct?
That and the results of our analysis that was filed in November of '22 suggests that it's not advantageous. But we've clearly made points, and Mr. Sinclair makes extensive points in his analysis that the uncertainty as to the rule set that PJM uses to implement their marketplace are so uncertain it would be a challenge and not recommended to join at this particular time. We're not saying no, not never. We're just saying no, not now.
And so the commission could order, in this case, given the substantial evidence about potentially joining PJM, that the companies reappear before the commission and explain a decision to seek or not seek PJM membership following the announcement of market reforms, correct?
What was the last part of your question?
Following the announcement of market reforms.
I'm not an attorney, but I'm sure the commission has that leeway to bring us over and have a conversation anytime they desire.
Okay, I have just a few more questions for you.
I would make one point to that. Obviously, if you think about it from a market functioning, I think we would need to think about not only when those market reforms are approved by FERC, but some indication that they are functioning. I think that the prudent way to think about that is how those market reforms are working, not just because they're proposed. Obviously, PJM has a history of modifying those, and I think it'd be the best time for us to have that discussion after we have some evidence that those market reforms are functioning and working as intended.
Mr. Billard, are you aware of the, first of all, you said you're not aware of a $200 million difference in the company's outside consultants' assessment of the economics of joining an RTO that changed from November to May, correct?
Your Honor, I'm going to object. This has been asked and answered. Mr. Beller has already said there's another witness that can address it. It's Mr. Sinclair. He'll be glad to address it.
I think the answer was, can he confirm that he doesn't know? So I understand that the other question was asked, so please, overrule the objection.
I'm not aware, yes, as I previously testified.
Okay, and you are aware that another witness in this case has filed, a witness for Sierra Club and Lexington, Louisville, has filed testimony that is contradicts the RTO study or is contrary to the RTO study, correct?
I would defer to Mr. Sinclair on that. That's an issue he took up on in his rebuttal.
Okay, and I'm asking you those questions because I think they really go to the heart of the recommendation that you're making to the commission about timing. And it sounds like the best person for us to discuss these timing questions with is not you, but in fact, Mr. Sinclair.
Yes.
Okay. All right, so I want to move on, and I have just a few last questions for you. Thank you for bearing with me. So you all evaluated geologic storage in thinking about carbon capture and sequestration, correct?
Historically, we have looked at that some time ago.
And there's a limited amount of geologic storage near the Brown generating station, correct?
In general, really related to all of our generating stations, not just Brown, but I'm specifically aware of the details for our system. There's not adequate storage for any substantial period of time for geological storage for carbon capture from a coal unit, yes.
Thank you. And do you know the total capital cost of carbon capture and storage? Have you all examined that for the units at issue in this case?
Obviously, we have a long experience in researching carbon capture. We've had facilities at Brown for a number of years. We're participating in the potential to develop a facility at Cane Run 7. So over time, from a R&D standpoint, we've understood the cost of that. but we didn't undertake a cost estimating exercise as part of the record in this case.
Understood. Okay, so Mr. Crockett noted that Mill Creek 1 has a variety of operational challenges. And I'm wondering if it's better to ask you or Mr. Ember to detail those operational challenges.
I'm happy to answer what I can on that, and if we get into environmental compliance details that I'm not aware of, we can defer to Mr. Ember.
So could you please describe the operational challenges you're aware of at Mill Creek 1?
So Mill Creek 1, as we've already talked about, is currently not operating effectively during the ozone season. And to be clear, we have an agreed order that limits the daily NOx emissions and enumerated in tons at that facility. So we typically choose to not operate Mill Creek 1 or Mill Creek 2 during that time period. We're not restricted to each in terms of each having very similar NOx emission perspectives. So we already have a limitation to operate only one unit of Mill Creek 1 and Mill Creek 2 during the ozone season. The second feature that Mill Creek 2 has as a challenge is we've deferred our compliance process with respect to 316B, which is water intake regulations, by virtue of establishing a retirement date of the end of 2024. And so if we were to continue to operate that unit, we effectively would have to do a set of studies which we believe would result in the requirement to add a cooling tower. That unit is what we call once-through cooling. Doesn't employ a cooling tower. It's the only unit on our system remaining that has that technology.
Thank you. And do you know the NOx ton allowance requirement for Mill Creek 1 or for Mill Creek 2?
And when you say requirement in the context of what regulatory
Environmental
regime?
regulations. Is that a question that's better for Mr. Ember?
Well, I'm not aware that they have specific tonnage limits themselves. The NOx program and the Good Neighbor Plan is it's a twofold requirement, and it is based upon, over time, units eventually having been equipped with an SCR. And so you have to look at it on a system basis. But there is a backstop limit in the Good Neighbor Plan that begins in 2030, and that limit is 0.14 pounds per million BTU. That's a more real-time limit, not a daily limit for those units. And so any unit operating after that time period would have to have the ability to produce NOx below that level.
Thank you. No further questions, Your Honor.
Mr. Smar?
Yes, Your Honor, thank you. Good afternoon, Mr. Belair.
Good afternoon.
If I could, I just had a couple, to start, I had a couple quick follow-ups on the discussion you just had with Ms. Huddleston about RTOs. Would you agree that one benefit of being a member of an RTO is that when there's a shortfall, there's a broader pool of resources to draw from?
It could most definitely be a benefit if those resources were available.
And so, all other things being equal, would being a member of PJM reduce the company's reliability risk?
Well, it all depends, of course, on the real-time operation of the RTO. Going into an RTO, we would still consider, as we do today, reliability is a key issue. And we would want to retain our assets in the manner in which we do today. I don't believe that it would provide a material impact on top of what we're able to do on our standalone basis. But that is obviously something we would consider if we were choosing to join an RTO. Against the costs that we evaluate typically, the cost and the benefits of joining an RTO.
Would you agree that being a member of PJM would provide the companies with easier access to resources outside of your territory?
You would have to define easier. Obviously, their transmission costs are more of a fixed postage stamp rate if you're a member of an RTO. From that standpoint, there's a different cost structure. We have the ability to interact with RTOs as we discussed. We were importing power from PJM and discussed that at length. So it would put us in a centrally controlled dispatch. And so from that standpoint, depending on how you define easier, it would be much different than we're in today.
Well, so in a situation like what happened last Christmas time with Winter Storm Elliott, I believe you discussed with Ms. Huddleston that PJM members did not suffer any curtailments, and the companies were forced to curtail for their own native load. Is that right?
I'm not aware that PJM curtailed native load customers during that event, and as we discussed at length, we did have to do that for the period of time we discussed.
Thank you. Would like to switch to, there were a few questions from earlier today that Mr. Fitzgerald asked to Mr. Crockett that he deferred to you relating to the cost of demand-side management investments. Were you in the room for those?
Yes.
So, first question, assuming that the approval of the company's demand-side management, energy efficiency measures proposed in this case, are you able to say what percentage of the company's investments would that represent relative to the proposed supply-side investments in this case?
Well, it's not a simple question to answer. When you use the word investments, I think capital, not expense. As you know and appreciate, a lot of DSM programs are expense items, not capital items. I believe the scale of our proposed DSM program is around $340 million. Mr. Bevington or Ms. Isaacson could break that down for you and talk about if any of those components would be considered capital. I'm not aware of the details at that level, but we all appreciate the investment in our portfolio that is part of the CPCN is around $2.1 billion. That is CapEx. There are OpEx obligations that go along with those plants that we would choose to build and construct and own and operate. So it's a hard comparison to make in a simplistic calculation, but that gives you two numbers to relate to each other if that's helpful.
Thank you. What are you able to say what percentage of reduction in total energy sales will implementation of all the DSM EE proposed in this case achieve?
So again, I'll provide you some broad numbers. If you want precise numbers, you can follow up Ms. Isaacson. So it's about 0.9 terawatt hours that we're looking at. Our load is around 32 terawatt hours. Additionally, Mr. Jones can fill you in on customer-driven DSM that we think customers would take outside of our program. That's another maybe let's say 0.3 or so terawatt hours. So those two items, if that gives you some frame of reference, and again, I would encourage you to follow up with other witnesses if you need the precise numbers.
Do you know if the company's developed the DSM plan to achieve a target percentage of savings?
Again, my general understanding is we looked at the traditional tests that we've used to receive approval of prior DSM approvals, not focused on a particular percent reduction, but what programs pass certain cost effectiveness tests.
So you're not aware of any particular target percentage?
Correct.
And so you're not aware how this might compare to the national average for utility DSM initiatives and energy efficiency initiatives?
No.
And you're not aware how it compares to the top performing utilities in the country on energy efficiency?
No.
All right, thank you. We'll follow up with the other witnesses about that. Thank you. Earlier today, you were discussing, I believe, with Mr. Malone, you mentioned you would be getting some responses by September 11th. Is that to the request for proposals from EPC contractors?
Correct, from the three main vendors that I talked about to construct the combined cycles. We should receive the results of the RFP on September 11th.
And one thing I wanted to clarify about that, so are the companies only entertaining bids from original equipment manufacturers who would also be EPC contractors? Is that the arrangement?
No, what we've asked them to do so that we would have, kind of one set of complete bids. We've structured the bids that we ask that they partner up with what we would consider acceptable EPC constructors, and they're going to partner with an engineering firm, a construction firm, and then they'll submit a bid based on that total constructed cost of their asset or their machine, if you will. We've also asked them to bid their what we call a long-term service agreement, which is a typical agreement that you enter into when you have combined cycle units to specify the maintenance cost of predominantly the combustion turbine as you operate the unit through time.
And you're aware of you mentioned three particular equipment manufacturers, and those equipment manufacturers would be partnering with EPC contractors and they'd be submitting combined bids?
Correct.
Would you agree that there's a potential for a major change in the cost estimate for the two NGCCs as a result of the responses to the EPC RFP?
Of course, they could bid higher or lower than what we have. Obviously, as I talked about, we have some contingency in the kind of bottoms-up exercise we did with HDR, our engaged engineering firm, to create that estimate. But it clearly has the potential to be both lower and higher than what we have in the bid.
Companies ask for bids for a lump sum contract, is that right?
Correct.
Does that mean that the bidders for the RFP will be pricing into their bids the risk of cost overruns?
I would assume so. Ultimately, we'd enter into contract negotiations with the bidder that we think will produce the lowest cost of construction and operation. That's why we bid the LTSA component with that. So one would assume that they are going to look at that bid as a lump sum and therefore have some of their risk priced into that.
And they'd have an incentive to be appropriately conservative about estimating the cost of the two NGCCs, correct?
Conservative in the sense of being low? Is that the inference of your question, bidding low?
Well, I meant conservative in the sense of they wouldn't want to put in a bid for a lump sum contract and then find out as the project moves forward that it's significantly more expensive than their bid.
Sure, they're in business to make money, of course, but they also want to win the bid. So
Sure.
They have to balance those two constraints, if you will, on how much of that risk they factor into their bid versus what the cost structure and risk tolerance of the other bidders might be.
The company's current cost estimate, the one in this case, is based off a study by HDR Engineering, correct?
Correct.
And that study was prepared at the request of the LG and EKU Project Engineering Group?
Yes.
And I believe you discussed in your rebuttal testimony, there were no other bids for gas-fired units into the company's June 2022 RFP for capacity and energy, is that right?
Yes.
And one of the major reasons why there were no bids by other parties to build a new gas plant in your territory is because the June 2022 RFP did not allow bids that would seek to utilize the company's own sites, is that right?
I can't say that definitively. I obviously don't know the universe of individuals who contemplated making a bid. That was one of the constraints that we had. We believe we're in the best position to optimize the use of the assets that we own and our customers are are paying for, and we would seek to do that with this proposal. If it were least cost, which obviously the bulk of our cases supports that.
But you included in your testimony a list of reasons why self-building an NGCC at a site where you currently operate a coal-fired plant it provides advantages, right? There's multiple advantages to that?
Correct. There are advantages that we obviously want to take advantage of for our customers.
And so the responses to the EPC contractor RFP that are due on September 11th, those will be the first time that outside companies other than the project engineering group and HDR engineering, which was paid by the project engineering group, those will be the first time that outside parties will be weighing in on how much the two new NGCCs might cost. Is that right?
We are in contact with each of those three vendors. HDR has contacts with that, so I wouldn't say that exclusively, but it's the first time they will put a binding bid, if you will, down for us to evaluate. I will agree with that.
Would the lump sum contract that the companies are seeking from the EPC contractors have provisions that would allow cost increases to be passed on to the companies and through the companies potentially to ratepayers?
Any commercial contract would have excusable events and things of that nature. That would be part of the contracting strategy. And obviously the ultimate passing on to customers part of your question is determined by the commission, not us.
Do you have a sense of what those provisions in the EPC contract might look like? Is there a standard practice that the company would intend to follow here?
Well, we have contracted for a number of large projects at our facilities. We would be informed by those. We most recently built Cane Run 7. So we would be looking at those type, weather delays, uncontrolled weather delays, supply chain issues and things like that. Typical practices that we would look to as to establish liquidated damages in some cases, excusable event status in other cases.
Would this be an issue that would be likely to be addressed in the RFP responses from the EPC contractors?
We had a base bid. Some of that criteria may be in there, that we would be looking for certain liquidated damages. Obviously, as you were describing before, those vendors have to look at all the risks that they undertake when they make a bid. That information, I'm sure, is in the record, and we can detail that out if you desire.
Is there any reason why you would not be able to provide the EPC RFP responses in response to a post-hearing data request?
Don't see any reason we couldn't provide those after we receive them. Obviously, we would like to have a petition for confidential treatment, but.
Your Honor, we would request the opportunity to ask a post-hearing data request on this topic.
That'll be fine.
I'd like to move on to talking about the proposed EPA greenhouse gas rules. And in particular, I'm asking in reference to the company's response to PSC data request 5-2.
Okay.
And so, is it fair to say that if the proposed EPA greenhouse gas rules are finalized, the two NGCCs would essentially be required to choose among, I think it's 3 compliance pathways? in terms of how to comply with the rules going forward into the 2030s. Is that right?
We looked at the evaluation that we describe in the response to this request as those three pathways being limited capacity factor, intermittent load operation, namely at around 50% capacity factor. We also looked at their ability to burn low GHG hydrogen, co-fire with that, or some kind of carbon capture. The premise of the analysis was to look at the 50% capacity factor limitation as being the worst case of those, noting that if hydrogen co-firing were more economic, we'd take advantage of that, and carbon capture, if it became more economic, we'd take advantage of that compliance alternative.
So just to make sure it's all clear for the record, and these are in no particular order, the three compliance pathways, the first one would be for a new NGCC to reduce its capacity factor below 50% to qualify as an intermediate load plant. Is that right?
Correct.
And then another compliance pathway would be to meet a 90% CCS standard by 2035. Is that correct?
Correct.
And then a third one would be the low greenhouse gas hydrogen co-firing standard you mentioned, which I believe is 30% co-firing by 2032 and increasing to 96% co-firing with low greenhouse gas hydrogen by 2038. Is that right?
Correct.
The companies don't currently know which of the three pathways they would choose to meet these requirements for the two proposed NGCCs. Is that right?
Correct. That was premised in the way we structured the response to this data request.
And the companies don't currently know how much it would cost to meet those requirements, correct?
What we've done is, I think, what we generally refer to as a no regrets analysis here. And so we've shown how the two combined cycles under the set of assumptions that we lay out in detail in this response would perform under the new proposed rules operating at 50% capacity factor or below.
Is it fair to say that there are still significant uncertainties associated with how the companies would comply with EPA's new greenhouse gas rules?
Well, as proposed, most definitely. That's why we've made extensive comments to the EPA, and industry has made extensive comments. We're not alone in those extensive issues we would have complying, not only the units that are the subject of this case, but the remaining units in our coal fleet.
So with respect to the proposed new NGCCs, you don't know where the low greenhouse gas hydrogen would come from, right? That would co-fire in these plants?
Yeah, I think we state that, that technology is not, in our view, available, achievable, or adequately demonstrated to meet the criteria that it would need to be part of a compliance strategy.
And you don't know how much, I guess this is sort of implicit in what you just said, if you don't know where it would come from, you probably don't know how much it would cost, right?
Correct. I mean, you could do a theoretical calculation of producing green hydrogen today, but in terms of the volume and scale and whether or not that would function in the way it would need to supply a unit, that is undetermined. That, again, is the premise of our comments to the EPA.
And you don't know how much any upgrades or modifications to the NGCCs to co-fire with hydrogen would cost?
In that specific question, we have several options. We talked about options that we've asked the potential suppliers to make part of their bid. We've looked at different levels of hydrogen consumption and asked the vendors to provide costs on that side, setting aside, where that fuel is going to come from and how much it will cost to produce that fuel. So we will have that part as part of the responses that you've indicated to request to receive after we receive them.
I see, so that will be something that's included in the EPC
Yes.
responses?
Yes.
And would that be to meet the 2032 co-firing standard or the 2038 co-firing standard, or both?
I don't believe our bid, subject to check, and it's in the record, I don't think we go so far as to ask about 96% co-firing, but we look at different levels that would, I think, surpass the 30% level. But that'd be subject to check, but that's in the record, what we've requested.
Okay. But you don't think 96% was part of that?
I'm not aware that we went that far with asking the vendors at this point.
Do you know whether carbon capture and sequestration would be feasible for the two proposed NGCCs?
As, again, per our 111 comments, we don't believe that it's feasible today. We're, as I mentioned in my testimony earlier, we're involved in a pure R&D project that could result in a pilot-scale carbon capture plant to be built at Cane Run 7, the first of its kind. So we clearly have concerns about the ability of that technology to perform.
And so I think implicit in that answer, you don't know how much it would cost to capture and sequester carbon from the proposed NGCCs, correct?
Well, again, I think industry has the capability to do, tabletop exercises in costing out both the ability to produce hydrogen and the ability to develop carbon capture, but those technologies haven't been demonstrated to function in a utility scale environment over, a wide range of operating conditions and everything that are required to integrate them into our system and operate the system reliably.
And I believe there was some discussion in the discovery response here about potentially needing to build hundreds of miles of pipelines to transport captured carbon, is that right?
Correct. What we discussed earlier, that we don't believe there are ample geological formations to store hydrogen really close to our plants, and if that were required across the fleet, we would look to move that carbon off to more appropriate geological formations.
And has the companies developed a cost estimate for how much that would cost?
No.
You had mentioned in this discovery response, and I think just now, the requirements for the company's existing coal units under the proposed new greenhouse gas rules. What is your understanding of what the company's compliance options would be for those units as if the rule were finalized as it was proposed?
Those requirements are specified in that same data response you were referencing earlier, PSC, let's see, get it here. Question 2, is that fifth round? Yeah, fifth round, question 2, page 6. I believe those are the options we have for coal-fired boilers specified there. So we could opt to take a retirement in 32. We could limit capacity factor to 20% through 35 and then retire. We could co-fire with 40% by volume of natural gas until 2039, I believe, subject to interpretation of this table here. Or we could carbon capture 90% CO2 on those units.
And I believe you say here in this discovery response that the stress test modeling you performed showed that the only scenarios in which continuing to operate existing coal units rather than retiring them is economic is if compliance with the new EPA greenhouse gas rules is essentially free for existing coal units. Is that right?
Please repeat that.
I believe you said in this response here, and I can find the language if that would be helpful.
It would, thank you.
Hold on one second. You turn to, well, the first time I see it is on page 4 of 22 of this response to PSC 5-2, where it says, in fact, the only scenarios in which an alternative portfolio would be lower cost involve situations where compliance with the new GHG rules is free for coal-fired units while constraining the use of lower CO2 emitting NGCC units. You see that?
Yes.
And do you have any reason to believe that compliance with any final EPA greenhouse gas rules is going to be free for existing coal units?
Well, that was obviously the premise of this analysis, that with all the descriptors that we put in here, with the inability to determine what those compliance costs were and our desire to produce an analysis as a result of this request, that's the assumption we made. That free assumption obviously includes the application of the 45Q tax credit, so in a sense, free net of that credit, and that's the assumption we did make.
I see. So do you think that is a reasonable assumption?
Well, in the context of providing a response to this request, that was how we thought about it a long time and came to the conclusion that that's the best way to be responsive. The request, if you go back to the beginning, asked us to look at compliance with existing units that are in this case. Obviously, that needs to be done in the context of what will happen to the rest of the fleet. And given the discussion that we just went through about the inability to predict costs of carbon capture at the remaining coal fleet, we think that's a reasonable way to reply to this data request.
I understand that it's a
We don't think it's going to be free, if that was going to be your follow-up
I just wanted you to
question.
state that, yes.
Because we also reflected, values in our analysis, I believe, of there being a CO2 price reflecting some other component of cost to the quote free assumption, free net of the tax credit.
Understood. Thank you.
I'm sorry, I still don't understand. Are you saying that the assumption is that the cost of abatement is the same as the tax credit?
That was the base premise of our scenario for all of the units not subject to this case.
So you're saying like the remaining Gent units, the remaining Mill Creek units, the Trimble units, and Cane Run 7?
Yes.
Mr. Smart?
Thank you, Governor. If you could turn to your rebuttal testimony, page 16.
Yes.
And refer you to the first Q&A there on page 16. You're responding here to Mr. Collins' testimony concerning Gent 2.
Yes.
And at the end of that paragraph, you say there may be other EPA requirements that could drive a retirement decision for Gent 2 based on EPA's semi-annual regulatory agenda. Do you see that?
Yes.
Am I correct in understanding, when you say by other requirements, you mean other than the Good Neighbor Plan?
Yes.
Could you describe what some of those other EPA requirements might be for Gent 2?
Mr. Ember details that in his rebuttal testimony, I believe, or his testimony in general, so he would be the best one to detail those out and give you the most fulsome response there.
Okay. I can save that for Mr. Ember. Lastly, had a few questions about the Brown battery storage project. I believe the companies have said that the rationale for seeking approval of the battery storage project is to gain operational experience with battery storage at utility scale. Is that right?
Yes.
And the term operational experience, could you unpack what you mean by that? Like what all is included in that?
So to set the stage, we have been operating a 1 megawatt, 2 megawatt hour battery at our Brown plant for a number of years, effectively an R&D type project. And so we've gained experience there, so we're very knowledgeable about that. The experience we're talking about gaining with a larger utility scale is something obviously 125 times the size with capabilities to produce 4 hours of storage versus 2. And so operationally, how will that integrate with the grid? What are the responses of that asset? What are the benefits of that asset on a utility scale? We sized that unit based on roughly the size of a combustion turbine. We have a number of combustion turbines on our system that are aging. And in addition to appreciating the deployment of battery resources throughout the grid, we want to also see if potentially that would be a resource that could be considered as those CTs reach the end of their useful lives. The other thing I would say is anything you operate in a very small scale, whether it be what we would call a tabletop or whether it be something more like the 1 megawatt, 2 megawatt hour battery, doesn't compare to something that we would call utility scale, 125 megawatts with 4 hours of service. So the sheer scale of that, we'd want to gain experience with that. Any complications you would have with heating and cooling systems that you're trying to manage in that environment would be different on that larger scale than it would be on a small scale.
Thank you, that was very helpful. In terms of operational experience, does that also include experience constructing the battery? Is that part of it as well?
It could be. It could be. Obviously procuring the assets is all part of constructing, so procurement of the batteries and constructing, we would gain certain knowledge on that, how we would want to lay out the battery farm, if you will. They come in modules, as you're aware. We would gain some valuable experience in that regard.
And would it also include getting experience in how the utility scale battery operates once it's put into service?
Clearly, how we could utilize that for different system conditions. How does it perform in extreme heat, like we're having this week, and how does it perform in extreme cold that we experience on our system, and all the operating parameters in between. If we have system response issues, we want to see how quickly we could engage the battery and what benefits it might provide to grid stability also.
And is there a need for the companies to gain experience about the physical management of the battery? Is that also part of it?
Yes, we've learned a lot with the research project we have, but then at scale, those learnings can be enhanced and discover many other things if you're operating a larger battery, how you'd want to maintain them, how you would want to cycle those batteries, and there's obviously the chemistry that's inside the batteries. How does it function on a large scale?
And does it also include having specific personnel who are trained in operating the utility scale battery?
Yes, you would obviously employ a different staff for a 125 megawatt battery than we have for our 1 megawatt, 2 megawatt hour battery. So we would gain experience in staffing that facility also.
And could it also include affecting how the companies dispatch resources in your portfolio to meet demand?
Well, obviously, we'd have a big resource that needs to be charged on a very frequent basis, so we need to factor that into the way we manage our assets, and it would give us the ability to integrate that into our system, charging and discharging included.
Do you have any sense at this point how it might affect how the companies decide in real time which units to dispatch, or any sort of dispatch algorithm that you have?
Well, given the size of our system, 125 megawatts would not be overly material input to the system, but just as we do with our current assets, we have processes we've developed over time to optimize the benefit of those assets based on their attributes, and we would clearly do that with the battery. Looking at maintenance cycles and replacement cycles and degradation, charge, discharge cycles, all those things will be factored into the way we would utilize that and how it would impact our system.
And would addition of the battery storage also contribute resilience to the company system?
Clearly, we evaluate that in the case. It's demonstrated in the case. We looked at that, I think, as an individual step of adding that battery. And so the information in the record supports that it would improve the reliability as measured by loss of load probability.
I believe that's all my questions. Thank you, Mr. Beller.
Counsel?
Thank you, Your Honor. Good afternoon, Mr. Beller.
Good afternoon.
Let me read a brief excerpt from Senate Bill 4, the definition of reliability. Reliability means having adequate electric generation capacity to safely deliver electric energy in the quantity, with the quality, and at a time that the utility customers demand. You familiar with that?
Yes.
Okay. So reliability is a capacity and an energy concept, is your understanding?
Yes, yes.
Okay. Now, resilience means having the ability to quickly and effectively respond to and recover from events that compromise grid reliability. How would you distinguish resilience and reliability, other than those exact words?
Well, reliability in my mind is meeting the needs of customers real time and having enough capacity and energy to meet those needs. And resiliency means the grid has to be able to respond to unexpected outages or events. And that's the way I distinguish those, and still retain service to customers. Mr. Kurtz, we talked about having spinning reserves. That would be a resiliency component to that, so that if a unit trips off, there's capacity online that can immediately make up for that shortfall without causing any issues on the grid. Obviously, having adequate capacity to meet load at any given moment in time is the way I would think about reliability.
What type of generation has the best quality of spinning reserve on your system?
Well, it obviously depends on how they're dispatched. And there's a table in testimony. The way I think about resiliency is ability of a unit to respond to fluctuations in load in this particular instance. Our combined cycle unit, or our CTs, can ramp quicker than a coal unit. I don't have the number memorized for Cane Run 7, but I know our new units that we're contemplating can ramp 80 megawatts a minute. Our coal units are limited to around 10 megawatts a minute. So I think about that in that terms of ability to respond if you're thinking about spinning reserves.
When you testified that your plan meets Senate Bill 4, you were doing it on a system-wide portfolio analysis basis, not a sort of an individual power plant look?
Well, what we did in the analysis is we took a baseline, which was status quo, and then we implemented components of our plan and showed that at each step you satisfy the requirements of Senate Bill 4 all the way through the development of our entire portfolio that we're recommending in this case.
Do you think that the analysis under Senate Bill 4 would differ by utility? For example, you have coal, natural gas combined cycle, gas peaking units, OVEC entitlement, hydro, versus a utility that did not have that type of portfolio?
Clearly, these evaluations are dependent upon how adding new and different resources to the portfolio, how it responds to those new additions. So clearly, each utility has an existing set of assets, and as they add new assets, how they interact with the others would most definitely be different. Hard to say how material that difference would be.
Explain how a coal power plant works versus a natural gas combined cycle plant.
Broad question. So,
I didn't actually hear the question.
A coal plant is much more complex in its operation. So maybe I can just briefly describe the components of a coal plant that will help. So if you think about a coal plant, you start on the river or on the rail or at the truck, and you have to unload the coal and move that coal into the power plant. That coal goes into a hopper, down to a feeder, down to a pulverizer. That coal is crushed. That coal is burnt inside of a boiler. The boiler turns the water to steam, goes through a steam turbine. You recondense the steam into water and complete that boiler cycle. On the back end of a coal plant, you have numerous pollution control equipment. You have SO2 scrubbers to remove sulfur dioxide. You have SCRs to remove NOx if so equipped. You typically have some particulate matter controls, whether those be electrostatic precipitators or bag houses. Then obviously you have a stack that takes the flue gas out. You have other injections of reagents that you need in that flue gas stream treatment process. So, simple overview of the coal unit. A natural gas unit, the gas arrives by pipeline, or fuel would arrive in a pipe if you were utilizing fuel oil. It's combusted in a simple cycle machine, which is a single shaft machine that compresses air into a combustion zone. The natural gas is combusted. It expands through the turbine part of the machine where the rotating force is created. That machine drives a generator to produce electricity. In a combined cycle, the exhaust gas from that simple cycle machine is used to make steam in a very similar way to what I described in a coal unit. And then there can be an SCR on a combined cycle, but it's much less complex than an SCR on a coal unit. And then there's an exhaust for the ultimate exhaust from the process.
Just looking at the fuel aspect, it's true, isn't it, that the coal unit has because it can store 30, 60 days of fuel on site, that it's more reliable in that sense than relying on gas transmission?
I wouldn't necessarily agree with that. All units have their reliability challenges. If you think that there's clearly the ability to have coal on the ground, and if you look at a combined cycle unit, there are a number of things that you do to ensure fuel supply or fuel assurity issues. One is you can obtain fixed transportation, firm transportation, which we do for our combined cycle units would plan to do. You can acquire the commodity both in an advance basis or on whether it be a year in advance or multi-years in advance, or you can do it on a day ahead basis. So there are a lot of things that you can do there. We had a discussion, you can obviously have fuel oil as a backup to the natural gas that you burn. So I wouldn't say if appropriately evaluated and managed that one has an inherent advantage over the others. We operate coal units very well, and we operate combined cycle units and simple cycle units very well.
But it is true that the coal can store the fuel 30, 60 days on the ground, and for natural gas, even with firm transportation, it's real-time and energy usage. No matter how you hedge the price, I mean, talking about the physical.
Correct. The fuel has to show up, and it is consumed in real time with respect to natural gas.
Okay. Now, equivalent forced outage rate and forced outage rate is going to be better for your new gas proposed combined cycles versus the coal units you're proposing to retire?
We'd have to check the assumptions in the case, but they'd be very comparable. Our combined cycle unit now runs at a very comparable equivalent forced outage rate to our coal units.
What about planned outages? Which have longer planned outages, coal or the combined cycle?
Coal would typically have a longer planned outage cycle. Obviously, we have experience with Cane Run 7. I haven't tried to add that up. It obviously depends on where you're at in the life cycle of those two assets. But over time, the combined cycle, it has less components that need to be serviced. I described the coal handling and the back end, as we call it, treatment. All that has to be maintained on a coal unit, and on a combined cycle, those aren't required to be maintained. A coal unit has a more corrosive combustion zone that creates the heat that affects the boiler in different ways than just taking the exhaust gas from a CT and creating steam in a boiler. So a lot of differences. I would generally say a combined cycle has less planned outage maintenance time than a coal unit.
You talked about the ramping and the load following. The combined cycle is a superior technology versus coal on the ability to follow load and move up and down quickly?
Yes.
Heat rate, the combined cycle has a much lower heat rate than a coal unit.
Correct. The combined cycles that we're contemplating in this case would have around a 6,200, 6,300 BTU per kilowatt hour heat rate, and a coal unit would be around 10,000 BTU per kilowatt hour, with the exception of our supercritical unit, Trimble 2, would be more in the 9,000 range.
And low heat rate is good because it converts the fuel to energy more efficiently?
Yes.
Okay. Let me ask you about the plants in particular. Mill Creek 1 is a 300 megawatt unit.
Yes.
Okay, you're proposing to retire it in 2024?
Correct.
And that unit is only operating 5 months out of the year right now because of NOx restrictions in Jefferson County?
Effectively, yes. I mentioned the flexibility we have. Should something happen, we could run Mill Creek 1 instead of Mill Creek 2, but yes, as a practical matter, we can only run one of Mill Creek 1 or Mill Creek 2 during the ozone season, as you described.
So one of the two, Mill Creek 1 or Mill Creek 2 has to sit idle 7 months out of the year?
Correct.
Okay. Now, you're proposing to build one of your combined cycle facilities at the Mill Creek site?
Yes.
Right. Okay. Is it a, is it mutually exclusive? Can you build the Mill Creek natural gas combined cycle plant and keep Mill Creek 1 and 2 operational?
So our current environmental permit for Mill Creek 5 that I discussed earlier that is being processed, it contemplates Mill Creek 1 and 2 being retired, and we utilize the environmental offsets of doing that as a primary part of our permit application. So there would be a challenge there in the permit application process. And then as it turns out, the megawatt capacity of the combined cycle proposed at Mill Creek is almost equivalent to the output of Mill Creek 1 and 2. So the transmission service is not anticipated to be any issues there. If you tried to operate them together, that'd be an incremental 600 megawatts, and that could cause challenges with getting that power out onto the grid, and there may need to be made additional network upgrades in order to do that.
No, I didn't understand your answer on the permitting. It's not technically mutually exclusive. You could continue to operate Mill Creek 1 and 2 and get a permit for the combined cycle plant?
Mr. Ember would be better to speak to that, but it clearly would change the way we've applied for our permit today. We would have to reapply, which we think would result in delays that would push us off the schedule we need to meet, the requirements that we proposed if we altered that permit application.
And if you had Mill Creek 1 and Mill Creek 2 and Mill Creek combined cycle, you would need transmission upgrades?
We haven't studied that in totality, but we would have to study that, and if anything was required, we would have to construct that.
Okay. Brown 3 is a 416 megawatt coal plant?
Yes.
Oh, by the way, the Mill Creek unit's operated at mid 50 capacity factor, 50% about, low 50s?
Are you talking about the whole plan or just 1 and 2? I'd
Well,
have.
they're about the same, I think,
Yeah.
aren't they?
Yeah, it's in the record, but yes, that sounds right. If you look at all 3 units, considering one is not operating, one of the 4 units at Mill Creek is not operating during the ozone season.
And Brown is a 416 megawatt coal plant,
Yes,
operates in the low 20s capacity factor.
yes.
And it's not because, and it's fully environmentally compliant, has SCR, new scrubbers, new everything, but it's just not economic. Is that why it doesn't run as much?
Correct. Its dispatch cost stacks higher than all of our other coal units.
And it's primarily the coal transportation differential?
Yes.
Is Brown 3 supplied with Kentucky coal?
Not that I'm aware of. I think it's out-of-state coal.
And you're proposing to build the second combined cycle plant at the Brown site?
Yes.
Okay. And there's no air permit issue about the combined cycle plant at the Brown site if you were to keep Brown 3 and build the combined cycle?
Again, Mr. Ember could provide the details, but I think we would have the same problem I described at Mill Creek. Our Brown 12 combined cycle application for environmental permit includes the offsets of retiring Brown 3.
Okay, so it might be mutually exclusive.
Correct. Mr. Ember could fill you in on the details there, the steps we'd have to take if we were trying to permit both of those facilities to operate.
What about
I'm sorry,
transmission?
Mr. Kurtz, can I ask a clarifying question? So, what I hear Mr. Kurtz asking you is a broader question. I understand the implication with the permits, but do I take from your response that the answer is yes, except for the permits to both of those questions about Mill Creek and Brown?
The questions of them being able to operate together?
The technical feasibility, like for instance, is there enough room? Like that kind of thing. You can speak to that. I understand that Mr. Ember is the expert on the air quality side, but is it that your response is supposed to be indicating what you don't say is, well, except for the permit, yes? Is that what I'm supposed to take from your response? I really don't understand your responses other than with regards to the air quality permit.
Sure. So let's take Mill Creek. Physical layout of Mill Creek 5 will not require the demolition of Mill Creek 1 and 2. Now, we would have to change how we connect it to the substation, but that would be workable. So in the Mill Creek situation, it would fit on the site. We would take up a bit of the coal pile. I haven't done the calculations if that would create a challenge for coal storage on the site, but we are taking a bit of the coal pile up with that construction. So we'd have that is generally possible, and we would have the transmission constraint I described at Mill Creek and the permitting challenge. So,
Do you know the incremental cost of those items, like the transmission issue?
no, we have not done a study to look at whether Mill Creek 1 and Mill Creek 2 could operate in conjunction with Mill Creek 5, or said another way, we could get another 621 megawatts out of the Brown site than what we're able to do today. We haven't done that study.
Okay. And then Brown, sorry.
Yeah, and so Brown, a different story at Brown. Our construction plan as it stands today would be to demolish the old units 1 and 2 as we construct the combined cycle. So we'd have to manage that around the operation of Brown 3, which we'd already planned to do. Permitting would be an issue at Brown, as I described. Transmission, again, this was not necessarily planned out specifically, but if all recall, we used to operate Brown Unit 1, Brown Unit 2, and now we continue to operate Brown 3. The sum of those 3 units was very comparable to 621 megawatts. I don't have that number memorized, but very comparable to that. So we know we have the transmission to operate the combined cycle. Again, we would have to do transmission studies to see if we could operate an additional 415 megawatts there at the site. But the layout would be possible. one thing I would say, we haven't really studied, that. We contemplated demolishing 1 and 2, building Brown 12, and then, moving on to retiring Brown 3. But it's likely possible that we could continue to operate in that mode.
But you also haven't done those studies in conjunction with the determination around East Kentucky's Cooper units, right?
Correct. I think there's information in the record about the analysis that we've done about Brown 3 retiring with no replacement there, and some of the issues that could entail, and the analysis and maybe operating procedures we'd have to put in place. But we haven't looked at how all that would interact. Of course, I'm answering all these questions. We obviously don't have a need for all of the capacity that we're talking about now. We would not have a need for that capacity. I think that goes without saying, hopefully.
Does anybody have the need for that extra capacity? Anybody being, does PJM have a need for that capacity, for example?
We are not in the business of, building capacity for other entities. We're focused on providing our customers' needs. So we haven't run any type of RFP or anything like that to see if there's others interested in purchasing, excess capacity that could be created.
Well, I now meant, would PJM, who is desperate for more thermal resources, would Brown 3 be something that PJM might want?
I can't say. With respect to PJM, they're redesigning their markets. It's hard to say what they would value in that new construct.
Gent 2, 495 megawatt coal unit?
Yes.
Okay. There's no permit issues for Gent 2 because you're not proposing to build a gas plant there?
Correct.
Okay. It was originally designated for retirement in 2034, but it was moved up to 2028. Is that correct?
Yes.
Okay. Right now, it can operate, and the reason you've proposed...
Sorry, Mr. Kurt?
Yes, sir.
I have a feeling, I've got to know you fairly well, but you're getting started on something. So, it's 5:08, and I don't want to get you halfway down the lane and then have to stop you halfway down. So, let's go ahead and we'll come back to you first for you to continue your cross-examination on the Ghent unit there. But we will take a recess. We'll take a recess until 5:48. We'll come back in 40 minutes, and then we'll continue with your cross-examination. I think the hard stop any evening that makes sense is probably about 8 o'clock. Sure. And so we'll do a hard stop at 8.
All right, so before we go on, then I would simply ask the parties that if you have a specific scheduling issue with your witness, to send me an email. So I'll go ahead and speak to you.
Yep.
You're on, Chairman.
All right, great. We're back on the record in 2022-00402. I want to make sure everybody's back. Okay. When we go back on the record, now that we're back on the record, I do want to note, earlier I mentioned after 5 o'clock when the doors are locked and nobody is watching the front door. I mentioned that please make sure you're communicating with someone. My request is that you're communicating with someone that's not one of us. So find a friend in the gallery and coordinate your necessity to get back in with someone from the gallery. So please don't have an expectation that anybody in this crescent here will have an opportunity to let you back in. So, all right, any questions about that? Any questions? All right, so we will try and go without taking a break the rest of the evening. We'll see what happens. It's almost 6 o'clock. So, Mr. Kurtz, would you like to continue your cross-examination?
Good evening, Mr. Bellar.
Good evening.
Okay, so the original retirement date for Gent 2 was 2034.
Correct.
I mean, the original, before the Good Neighbor Plan, moved it up to 2028.
Correct.
Okay. And in order to comply with the Good Neighbor Plan, the company would have to spend $126 million on a SCR?
Correct.
Okay. At a 495 megawatt plant, that's about $250 a kW.
Yes.
Okay. Right now, it can operate 12 months out of the year, correct?
Yes.
Okay. If the Good Neighbor Plan was enacted and you did not build an SCR, it could operate 7 months out of the year.
Yes. When the Good Neighbor Plan would restrict its operation, then we could operate it 7 months out of the year. The ozone season is different for the Good Neighbor Plan than for local ozone attainment.
Okay. You can define the word best however you want in this question, but would you agree that of the 4 coal units that are proposed to be retired, Mill Creek 1, Mill Creek 2, Brown 3, and Gent 2, that Gent 2 is the biggest and the best of the 4 coal units?
Yeah, I love all of our units on our system, but and all the people that operate them, but it is obviously the largest. It's a very reliable unit. I think year-to-date, its equivalent forced outage rate is less than 1%. So it's a very reliable unit. So I will give you that much.
Okay. Gent Unit 2 is at the 4-unit Gent site on the Ohio River?
Yes.
Okay. If you were to retire it in 2028, you would not actually decommission, you wouldn't tear down anything, would you?
No, we would not, given where it sits in the plant layout, we wouldn't intend to do anything to demolish any significant component of the unit.
And Gent 2 has certainly a very good fuel rate, fuel cost per megawatt hour.
Yes, it receives coal by barge and very competitive with respect to coal costs across our fleet.
Compare Brown 3 and Gent 2 fuel cost per megawatt hour.
I wouldn't have the number off the top of my head, but Brown would be, let's say, in excess of 10% more expensive to operate from a coal perspective. We can get that precise number, but it's in that order of magnitude. Brown 3 clearly dispatch is after all of our coal-fired units, and depending on the price of gas after Cane Run 7, actually today's current gas prices, Cane Run 7 dispatches first, Trimble County 1, the remaining coal units, then Brown 3. There are times when natural gas is very inexpensive that all other things considered, you could run a simple cycle machine cheaper than Brown 3.
assume the commission granted the 2 CPCNs for both natural gas plants and denied the retirement of Gent Unit 2. What would the company do operationally?
So what we would do in that case is continue to operate Gen 2. We wouldn't have an authorization under Senate Bill 4 to do that. We assume the commission would deny that request under the expectation we would continue to operate the unit and not put it in some type of reserve status. We would be able to operate that unit until it created Good Neighbor Plan compliance requirements. We could likely run that unit through 29. In the Good Neighbor Plan, there is a daily backstop limit contained in that regulation. I mentioned it before, 0.14 pounds per million BTU. And so that kicks in 2030. And so we potentially could operate that unit through 29 during the full year. We would obviously be constraining our dispatch using an adder as we do today. It's a very minor component now, but the value of NOx allowances, so that unit's dispatch would be affected by that because it would be a non-SCR unit, so it would run less than it runs today. But we could run that through 29. Then in 30, if we hadn't pre-planned and we didn't have an SCR, we would have to go to the 7 months of the year operation to avoid the daily backstop limit that I described earlier.
And to the extent 2 new natural gas combined cycle plants plus continuation of Gent created excess energy on the system, the company would sell that when it was economic off system?
Yes, yes. And just to back up on that question, just to make it clear to everyone, the scenario I'm describing has the 2 new combined cycles. Our ability to operate Gent 2 without an SCR, we haven't studied it if we don't get both combined cycles. That's part of the case, obviously, is being able to reduce NOx and provide energy from those 2 assets. So just want to make clear that I'm answering your questions based on the scenario you're putting forth.
Yes, thank you. My assumption was that you got the 2 new gas plants and you were denied the retirement request for Gent.
Yes.
Okay. Would under that scenario, that hypothetical, would the company be willing, or if it was economic for your ratepayers and economic for the ratepayers of another Kentucky utility, to offer that energy and capacity to that utility under a unit power agreement, similar to the way that the Indiana municipals and the Illinois municipals have a share of Trimble County 1 and 2, or a similar, some sort of structure?
If we were in the situation you described, our case describes a situation where Gent 2 is retired. So under the case that you're talking about, we would have capacity, excess capacity in that situation because we've justified our ability to operate the system without Gent 2 in addition to 2 new combined cycles, and presuming other of the components of our plan are approved also in this answer. But we would be looking to optimize that asset. Today we make what I would call opportunistic all-system sales based on the occasional excess capacity and energy that we have and the need of the marketplace. But if we were in a situation where we had those circumstances, we'd likely ensure that either selling it in the off-system opportunistically, using it for customer load, or in this scenario you portrayed, selling that power would be most beneficial to our customers.
Can I ask a question, just real quick? Along the scenario that Mr. Kurtz is asking you, though, taking a huge step back and considering Senate Bill 4, if you retired Mill Creek 1, Mill Creek 2, Brown 3, left Gent 2 open, but didn't scrub it, I know this is a laundry list of things, had all the other, jet engines on their side, tiny little CTs, And you then got whatever varying amounts of the solar you're proposing, the PPAs or the self-build. Do you expect, and both of the combined cycles, I don't know if I said that, but both of the combined cycles, do you have an expectation at that point that your LOLE will be higher than 3.5 or lower than 3.5?
Well, our analysis would say with our proposed plan, it would be much lower than 3.5. So obviously, if we kept Gent 2, and there's scenarios in there as we walk through our retirement compliance, if you will, with Senate Bill 4, there's scenarios that show what our portfolio would look like. Now, we did it in sequence, and so some of the other attributes are done later, but it would definitely be below 3.5 or, it's in the record exactly what those numbers are.
Okay, because so you're basically, what Mr. Kurtz is asking about is your proposal, maybe Mr. Kurtz is asking without the PPAs, I don't know, but with or without the PPAs, and adding Gent 2 back in non-ozone season, basically, right?
As we were discussing, a full year through 29, non-ozone season thereafter.
Starting in 29, right. So that would be probably, in terms of LOLE perspective, probably even lower than the one that you all proposed, right?
Correct. Again, we have that progression. We evaluate the retirement of individual assets and the addition of the 2 combined cycles, and then we start adding Gent 2 in, and then we progress to add the solar and other assets. So obviously, if the portfolio we're proposing in this case has Gent 2 retired, and we believe we meet LOE reliability requirements Senate Bill 4, if we were to add it back, it's even going to be more compliant with that reliability metric that we're using.
Yeah, and I don't, because I know Mr. Wilson talks about that quite a bit, and I don't want to get to like super detailed. I just want your perspective on Senate Bill 4 and how you all are saying that you're meeting the as reliable or more reliable, whatever it may be. You're taking a snapshot of the current system effectively and saying this is the LOLE, meet or exceed, right?
We've looked at that in a general sense, but yes, and we walked through what the LOE would be of those different portfolios, and whether it's better, and to the extent that it's not better, is it still an acceptable level of reliability?
And what I'm trying to understand, though, is taking Senate Bill 4 on its face, if you did what the scenario that you're being asked about, okay, basically the proposal with or without the PPAs, plus keeping Gent 2, doesn't that effectively raise the bar from 3.5 LOLE to whatever the resulting LOLE is from this case to be the new reliability bar that you have to meet going forward for retirements?
If I understand your question, the answer would be no. The baseline would be the same, okay? So let's go a little bit in pieces. So the baseline would be our current system operating as we would need to stay compliant with all the environmental rules. And so that's the baseline that we've laid out that says, okay, this is where you start to look at the Senate Bill 4 requirements from. Where's your launching point? We talked about retiring Mill Creek 1 and 2. We talked about retiring Brown 3 and retiring Gent 2. So Gent 2 is in that baseline running 12 months out of the year with an SCR on it. And so if I'm understanding your question, my baseline is exactly the same. What happens as I retire units and add units, there's interplay between those. If I don't retire Gent 2, its contribution is fundamentally the same as it is in the base case through 29. It would be slightly less than it is in the base case. But it doesn't create a higher bar. It's additive to that to keep it. But my baseline doesn't change.
Yeah, but I think you're answering a different question than what I asked. What I'm trying to say is in 2029, under this conversation that you're having with Mr. Kurtz, where you have a Cane Run 7 and a Mill Creek 3 and a Mill Creek 4 and a Gent 1, 3, and 4 and a Gent 2 with no SCR and a Brown 5 and a Mill Creek 12, okay, and the cell phone solar and the battery, okay, and the DSM. your LOLE, the way you are modeling it, you assume at that point your LOLE will be something lower than 3.5, right?
Oh, for sure.
And then if you come back to the commission under Senate Bill 4 to retire, just hypothetically, Gent 2 at that point, it would be a, I guess what I'm trying, but you would have to at that point go, well, here's our counterfactual, it's something less than 3.5. Your proposal for replacement generation, if retiring maybe Gent 2 and Gent 3, I'm making up scenarios, you would have to then beat that now even higher bar of a lower LOLE than 3.5.
Definitely lower than 3.5, and I agree, based on Senate Bill 4's requirements, by the fact that there's no mention of need in that set of requirements. Senate Bill 4 says what it says. It would create a new standard, and that standard, maybe I understand your question now, that standard would be in 29, if I were making this evaluation, or 30, it would either be the standard of the portfolio that we would get in this case, but retain Gent 2. That would be the new standard for us, and that would be a very high level of reliability. As I said, we've justified in this case the ability to retire Gent 2, meet all of Senate Bill 4's requirements. So I think I get your question. If you added back, my base comparison at some future date would be at a higher level of reliability than the portfolio that we're recommending in this case, because we have Gent 2 added back as the baseline.
It's like a new demand ratchet, right? It ratchets up, but can't come down necessarily.
Correct. Obviously, Senate Bill 4 says what Senate Bill 4 says, but yes, that does create that consequence if you go out to 2029, 2030 time period. The way we look at Senate Bill 4 and the way it's written, we have to look at where we're at, and if there's a retirement decision, can we at least, justify that we have acceptable, improved reliability from that. And if you look at that scenario, let's say the hypothetical is Gent 2, with or without an SCR, and let's say we decided we'd replace that with a combined cycle at that time, whatever the technology choice was, you would. In that sense, it would be a fairly simple analysis. Whatever new technology we're replacing with, how does it compare to the reliability and resilience of Gent 2? Whereas the absolute loss of load probability may be lower, there would still be that fundamental trade-off in that case between what you're replacing Gent 2 with and how that meets the requirements, assuming Senate Bill 4 is not altered between now and then.
And the only mitigating factor to that ever-increasing ratchet that can only go, I say up or down or whatever you want to say, but making it more reliable and then keeping it or exceeding it, exceeding it upon retirements or replacements, is if effectively your all's generation gets less reliable between now and the next time you all needed to propose to replace something, right? Because by definition, if your E4D for all of your generators goes up, then your loss of load expectation in any given planning year would go up, right?
Correct. That would change the bar, if you will, if you're using that term of what the baseline reliability is. But it would still be effectively, in my mind, what Senate Bill 4 requires is for us to look at what's leaving the system and what we're adding to the system, and what are the interplays between those two technologies. And it limits what we can count in that. Obviously, it has to be fossil fuel dispatchable and those type criteria. But you're right, it creates a new planning constraint with respect to that. And so if we were to retain Gent 2 at the time we were needing to replace it, whenever that was, if it were that simple, if it was just one unit in and one unit out, whatever we replace that with, we'd have to pass all the Senate Bill 4 tests.
But going one step further, Mr. Kurtz, I promise you're going to get to ask your questions. But let's just say the company is proposing that the commission in this case enter an order declaring that the PPAs don't have to be necessarily approved. There's no requirement for them to be approved by the commission, right?
Correct.
Okay. So if the companies in between now and 2030 under this, fictional, and I appreciate Mr. Ingram giving me the opportunity here to ask these hypotheticals, but if say the commission says that do all the PPAs you'd like, as long as they're, you try to pass them through the FAC, as long as they're, quote, economic, then, whatever it may be, go ahead. And you all add PPAs in this intervening hypothetical between now and 2030. The way you all are modeling in this case, those PPAs would be taken into account in determining system LOLE, right?
Correct, if they're already in service. That would be the portfolio we would be comparing it to.
So there's a moral hazard for making, effectively, there's a moral hazard of making your system more reliable between retirements because you have to meet that status quo reliability for retirements. Is that how you're reading and implementing that reliability provision of Senate Bill 4?
Your Honor, could I jump in for just a second? This is a discussion that calls for legal conclusions about the way Senate Bill 4 is going to work.
Yeah.
And I think there's something in the record already, and we'll be glad to brief it, we will. But there is a different reading under Senate Bill 4 than what you're suggesting when you look at the definition of reliability and the requirement to maintain or improve that reliability. All right? So you're focused on the LOLE requirement, but if you look at the definition of reliability, what it says means having adequate electric generation capacity to safely deliver electric energy. If you've got enough, even with a retirement, that doesn't necessarily mean your baseline has changed if Gen 2 were to stay operational, for example, under the scenario. So I just want to point out to you and Mr. Beller, I don't think that's the only legal conclusion that can be drawn from a reading of this brand new statute.
Yeah, and I'm not trying to implicate that or necessarily imply that through the question. I'm trying to have an appreciation for what the impact of the line of questioning here is and the issue in regards to effectively how LOE is being taken into account in proving out this case. How the case of first impression, right? How the companies are proposing to meet that requirement by the use of LOLE and the impact of the portfolios have on that LOLE, that changing LOLE, depending on what the portfolio actually looks like and what the retirements look like.
Fair enough.
That's where I'm trying to understand. If we just go with LOE or EUE or LOH, whatever it may be, if we just pick a standard, any increase, or I guess technically reduction in those standards, right? A lower LOLE, lower LOLH, lower EUE, that changes the benchmark as you all are proposing it, that changes the benchmark from that, Mr. Ingram's point, that single piece of how you are looking at reliability in the sense that if how do I say this? If significantly more, if the reliability is significantly increased between cases, retirement cases, that effectively moves the bar, as you all are proposing to look at it here on that LOLE front, that changes the bar of your counterfactual that you're comparing to meet more reliable or keeping the same level of reliability, right?
Well, I would say it's still a comparison between the asset leaving the portfolio and the asset coming into the portfolio. In other words, how the asset that you're retiring or proposing to retire interacted with the portfolio, how it affected reliability, was it a acceptable level of reliability? You take that asset out, that's what Senate Bill 4 requires. I want to retire it, so I take that out, and then how does the new asset that you're placing in, how does it perform in the portfolio? I wouldn't want to get into hypotheticals of lower, higher, and all that, but that to me is kind of the fundamental, and that's what we have done in our analysis is we've looked at our current base portfolio with everything that we have today operating fully, and then we've incremented through removing certain components of that portfolio, retiring them, and adding new components. And how does that affect the LOLE? How does it affect our perception of reliability? We also look at our reserves. That's one of the other requirements. Mathematically, what does it do? How do those portfolios meet those reserve requirements? And resiliency, we talk about dispatch ability and all that. So I think it's still a fundamental comparison of what you're taking out versus what you're putting in. And somewhat irrespective of what the status quo was, did you hurt it, or did you help it, or did you leave it the same, and is it still acceptable?
Yeah, I appreciate it, Mr. Beller. I'm sorry, Mr. Kurtz. There's a lot of questioning there. If there's another decision point at 2030 and the system is even, from an exclusively LLE perspective, is more reliable than even the one that you're proposing in this case, it begs the question, does it raise the hurdle? So, Mr. Kurtz.
I see your point. So let's just, a little bit further, 2030, Gen 2 is not retired now. In 2030, the decision is to retire it and to replace it with a new combined cycle plant. Are you saying, Mr. Beller, if Gen 2 is unreliable at that time and the new gas plant will be very reliable, that mathematically you will be increasing system reliability by replacing an old unreliable plant with a new reliable one?
Correct, that could be the case, right? It is that comparison in terms of what the new portfolio is going to look like in comparison to the portfolio you have before you make the retirement decision.
Chairman, I think those are all my questions. Thank you, Mr. Beller.
I'm happy to have taken the wind out of your sails, Mr. Kurtz. Promise it wasn't on purpose. Mr. Howard's not here. Ms. Vinsel? Mr. Bellamy? Mr. Bellamy.
I was looking at KU's response to staff's first request for information, question 100. If I can pull it up on the screen. So the question was just provide forced outage rates for each thermal generation unit in LG&E KU's fleet over the last 5 years. And I guess my question for this was, earlier you kind of talked about calculating a forced outage rate, and then I can't recall the exact term you used, but the exceptional first outage rate, or
Equivalent forced outage.
Equivalent, I'm sorry, equivalent. Could you kind of explain what was done with this chart?
Rick, could you go down and see if...
You want me to go down?
No, I was, all right, and then, okay. So it looks like what we're providing is the forced outage rates, not the equivalent forced outage rates. So this would be the rate at which the unit was unable to produce any energy. It wouldn't include the times at which it was derated from its rated capacity.
Okay, that's what I was wondering. So this is just the periods in which each of these units were completely unavailable during each year, due to a forced outage.
Yes.
When you calculate the equivalent forced outage rate, how do you calculate that component?
So you effectively take the time at which the unit was derated and you equate it to a full forced outage. So you have a 500 megawatt unit. If it was derated for 5 hours at 100 megawatts, that'd be equivalent to 1 hour of it being out. And so the math effectively accomplishes that result.
Okay, that's what I figured. Some sort of like weighted average type thing.
Correct. So it just equalizes it to a full outage.
When the companies calculated or looked at like past forced outage rates to determine what forced outage rates to use when looking at reliability, do you know if they use just the forced outage rate or both the forced outage rate and the equivalent forced outage rate?
In the modeling assumptions, we would model Obviously, they affect the models differently, but we would use a forced outage rate, and then an equivalent forced outage rate would be another input to the model. So both D rates and full forced outages, and of course, maintenance outages and other things are all inputs to the model. So the random unavailability of a unit in terms of it being totally forced off and it being derated would be in the models.
Could I ask for a post-hearing data request that would essentially be the same as this, but provide the equivalent forced outage rate for each of these units? Would that be something you'd be able to provide?
Yes, yes.
I was just looking at Cane Run 7, and it does have if you look at Cane Run 7, which is the natural gas combined cycle unit, correct, at Cane Run?
Yes.
If you notice, in 2018 through 2021, it has a really low forced outage rate, and then in 2022, it's 5.29. Do you have any idea what caused that uptick in 2022?
In 2022, and we can provide this as part of that data request, we had a forced outage issue with the unit coming back in service, and we can provide the details of that, coming back in service from an outage, so it resulted in a higher forced outage rate. I think it's pretty much one event that caused that, but we can definitely provide that.
So you think it was something like it was out for maintenance and then it couldn't come back online when expected for some reason?
I think it was, in course to come back online, it was forced off. There was an issue with some of the work that was done during that outage.
Kind of same thing with Gent 4. Do you have any, it kind of had similar forced outage rates to Cane Run 7 through 2021, and then again in 2022 it had a forced outage rate of 5.25.
Yes, we can provide that information. I don't recall.
You don't know offhand, but if we asked, you would be able to provide an explanation of what caused it.
Yes, yes.
Would you be able to provide, and I think I know how the calculation will work, but to kind of illustrate how something like what happened to Cane Run 7 during Winter Storm Elliott, the effect that just that particular event. So you would kind of get an idea of what an event in which it was on, or it was derated for 4 or 5 hours, whatever the time period was, how that would actually affect the forced outage rate or the equivalent forced outage rate for the year, assuming there was no other forced outage issue.
Yeah, we can do a math calculation based on that D rate, but I will say, and this is in the record, the calculation of forced outage rate, equivalent forced outage rate, and all the other unit availability factors is driven by a set of standards and rules by GADS. I think it's a Generator Availability Data Service. And just to be clear, the event that occurred with the pressure, that's not a recordable event in that database, but we can definitely take those hours. The math can be done to answer your question, but I just want to be clear that if you looked at Cane Run 7's availability in 22, it's not going to be impacted. This is an FOR, but forced outage rate, the E4 will not be affected by that event. But we can turn it into just that to give you that relative impact.
No, I do get that. Thank you for the clarification. So basically, if I were asking for the equivalent forced outage rate for Cane Run 7, when you were providing, the actual calculation, how you would typically do the calculation, the derating from Winter Storm Elliott wouldn't be reflected in that in any way.
Correct. Okay. But we could do the math that you just asked for. We obviously know the D rate and could and calculate it as if it were included, just to give you the perspective of how that would impact the annual availability of the unit.
Well, I was actually trying to see how an event like that would be translated into an annual forced outage rate, to get an idea of how many events like that would translate into a 5% forced outage rate or equivalent forced outage rate. But if you're saying that's not an event that would show up, then, that might be not an important exercise. But I might ask that as a post-hearing data request, but I do have a follow-up question to that. Is there any mechanism that's used to track deratings of that nature, of the nature that happened at Cane Run 7 during Winter Storm Elliott?
I'm not aware of one. It's the first event in our company history similar to that. I'm not aware of an industry indices that looks at that. Again, it would be excluded from GADS data. That's kind of the Bible of, and that's how we do all of our benchmarking, compare ourselves to other entities is through the GADS data. So we wouldn't be including that, nor would if it has happened to others in the industry, even though it's only happened to us in this one instance. We wouldn't be including that.
Are you familiar with certain RTOs and perhaps some utilities that will use effective load carrying capability as a measure of reliability of a particular unit?
I'm generally familiar with that term.
Okay. Do you know if an effective load carrying capability calculation, would it capture the type of derating that occurred at Cane Run 7?
I'm not aware. I don't know if it would or not.
You don't know? I might ask, would there be a witness who might have a better idea of whether that would be the case?
Mr. Wilson would probably have a better idea if he's dealt with that.
I'll follow up with him. Thank you. I was looking at your rebuttal testimony on page 12. Yeah, I'll actually switch to the rebuttal. Yeah. Just looking at page 18 of your rebuttal. And you're kind of responding to Mr. Goggins' testimony. There on line 4 or on line 5 is where I'm starting.
Yes.
And you kind of say that you disagree with his premise that the companies have overstated the reliability of gas-fired generation. You say that it's flawed, and you put that Goggins attributed correlated outages, and you put correlated outages in quotation marks. Was that to indicate that you didn't believe that, I think his testimony was, to the effect that there was a correlated outage on, with Winter Storm Elliott, and that's not something that the companies took into account with respect to their modeling? Do you disagree that there was a correlated outage? From your testimony earlier, I think you said that you thought there was a correlated outage on.
Correct. And what we're stating here is that we're not missing anything in our analysis by not evaluating, considering correlated outages. By their very nature and the way we view those, or the way I view those, they're very, very rare events. And you can see from our response how we address that particular event. Again, it's an event that had never happened in our company's history before, operating the LDC, operating gas units at our gas-fired units for a number of years. And so that was really the purpose of the testimony, is that we're not missing anything in our evaluation. We didn't not consider those events. So the way we've dealt with this particular event is fully detailed in the record, and we continue to believe that particular issue that would have created this correlated outage, in quotes, it has been eliminated from our system, so therefore our analysis is not deficient in that way.
And you think that your testimony is kind of that the issue, and it goes down here on page 18 and then on to page 19, you indicate 3 fixes, I think, that the companies had identified. And I was just wondering, you kind of talked about some of these earlier, but is it your testimony that with these improvements that you've eliminated the issue that caused the outage, whether it was a correlated outage or not, with respect to a hurricane or Winter Storm Elliott?
Correct. Obviously, the biggest of which would be for the efforts that Texas Gas has taken in a very holistic way to address that issue. But we also point out that we are instituting a software improvement at our CTs at Trimble County. If we would have had that software capability, we could have eliminated a significant amount of that load shed, and then I think we go on to talk about the new combined cycles. As the options I talked about earlier today, one of the options is to have increased compression. So at those units to avoid a lower pressure situation like developed. Just to be clear, during Elliott, the pressure was low. It wasn't so low that gas couldn't be delivered. Significant amount of gas was delivered to our system. Our LDC ran perfectly fine in that scenario, and the units that we had online, while derated, still were able to run. So it wasn't a zero pressure event. There was no gas. There were plenty of molecules of gas available. I believe Texas Gas told us they withdrew 1.5 BCF of gas out of storage during that event. So we believe we've put a focus on this effort, and we'll continue to look at events like this as they occur. By very nature, they're very random events, and we believe the prudent way to go after those events is to continue to evaluate them to the extent they do occur and make sure that they remain at the very end of any probability distribution that you would look at.
Could you just explain number 2 there, implement the previously discussed software improvement on the simple cycle combustion turbines at Trimble County? Could you provide a little bit more explanation of what exactly that is?
Sure. So the units require a certain pressure to operate. And once they go online and they're operating the units up and stable, the control system, one of its monitoring points is what that inlet pressure is. And so GE has provided software to us that would allow that parameter to be a broader range of gas pressure, in this case lower pressure, and still operate. The prior settings for that software and that input point to the decision making that the software has as it relates to the unit was at a higher pressure. It was, I think, equivalently equal to the pressure it required to start the unit. Now that has a broader operating range. It really doesn't affect the operation of the unit otherwise, other than allow that lower gas pressure to continue to allow the unit to operate at full load. It was basically a software constraint programmed in by the vendor. We reached out to them and said, do we have any flexibility in still maintaining reliability and integrity of the unit to lower that real-time operating pressure? And GE had the software available, and before that we were generally unaware that we had it. We've not had a need to implement it, but now we're implementing it. And we chose that because it was, given it was software, not hardware, more readily implemented before we get into this winter season.
Was that software constraint put in place originally to protect the unit, or did you get any explanation of why that was there originally?
Originally, it was a specification by GE. We can definitely follow up if you want more technical details why they believe that it was necessary to have that in the control package. But we worked with them to institute changes that allow that unit to run at those lower inlet pressures.
I was just curious if removing it in any way would damage the unit or affect its future reliability.
No, I don't believe that to be the case.
And you said that just that software fix would have reduced 90% of the load shed noted by Mr. Goggins. So is that saying that 90% of the load shed that took place as a result of Winter Storm Elliott would have been eliminated just by the software fix on those CT units?
Yes.
Okay. And the third fix is something that you've kind of talked about already, but adding fuel oil to the new natural gas combined cycle units or adding some compression device, is that correct?
Yes. Those units themselves require a certain level of gas pressure to operate, but that pressure can be provided by the pipeline, or we can augment that pressure with on-site compression. And we're going to look at different levels of compression so that if we have a pressure deviation event, again, it won't be as impactful as it was during Storm Elliott.
Are you looking at that, because you indicated earlier when you were requesting bids from the vendors and the contractors that you had asked them to also look at adding fuel oil. Are you requesting bids from them to add compression devices too?
Yes, we are.
Do you expect-
We've got some layers in, if you want the inlet to the compressor to be X, to boost it, if you will, to what the unit needs, and, maybe so many pounds per square inch less than X. So we'll get some different bids, generally surrounding, kind of the conditions we saw at Winter Storm Elliott and what the inlet pressures were on the Texas, or what the pipeline pressures were on the Texas gas system.
Does the request for bids or request for proposal, however it's termed, does it require the vendors to respond with either some sort of compression control device or fuel oil, or does it allow them to respond without either?
We've asked for those options. If they didn't respond, we would go back and try to understand why they didn't meet that requirement. We fully expect the vendors to comply, be compliant with the bid and submit bids that meet all of our requirements.
But that's what I was wondering, the bid actually requires that or indicates that in the request documents, that that's something you want.
Correct, and we would look favorably on a vendor who didn't provide us all those options, because what we want the ability to do is, number one, understand the cost of those options, but also compare how vendors view those respective costs, and if we choose them, how does that affect our comparison of vendors?
Are you confident, with respect to number one, those are the upgrades that are made on the Texas gas transmission pipeline. Are you confident that those upgrades on the pipeline will prevent future issues with respect to the loss of pressure and or the loss of, I guess, gas itself?
So the issue that Texas Gas had was basically, I don't want to oversimplify it, but a frozen valve that wasn't adequately protected from the elements. And so Texas Gas has done an extensive study. They brought in a third party to look at their system and, in simple terms, weatherize it as if it were located, 500 miles north of here, not in Kentucky. So they have done what we believe to be a very thorough job of looking at their system. They have redundancy on their system in terms of their compression. One of the levels of redundancy they have is reciprocating engine compressors. As it would turn out, those units were out on maintenance during this time period. Supply chain issues prohibited them from getting parts. So we don't see that replicating, that type of situation replicating again. And they've also changed their operating practices. Another thing that Texas Gas did is they started that compressor the day before the weather came in, but they turned it off and did not retain it at operating temperature. One of the lessons learned for them, and we do this with a lot of our equipment, is start the equipment but leave it running. And so that's just a snapshot of the things that they've done, but they've gone through an exhaustive both operating practice, the way they protect their equipment type issues to be able to ensure that that type of event won't occur again. And it was clearly a pressure issue. As I mentioned a moment ago, they were able to withdraw 1.5 BCF of gas through their system and provide it to the pipeline system. So it wasn't an issue of the molecule, it was an issue of the pressure that they could deliver gas at.
Well, Mr. Bellamy, let's just take a recess for a minute or two and go off the record.
Yes.
back on the record. Mr. Bellamy, would you have to continue?
I'm just looking at your response to staff's second request for information, item 73, and I'm honestly not sure if it was you or Mr. Sinclair who provided this response, because you were both listed. But it was explain and provide any analysis performed by LG&E and KU regarding whether there will be sufficient capacity on the Texas gas transmission pipeline or Tennessee gas pipelines to serve existing gas units, the proposed NGC units, and gas units being proposed by other utilities. And the response was the companies confirmed with Texas Gas Transmission and Tennessee Gas Transmission Pipeline that sufficient firm transportation capacity was available for the company's proposed NGCC units. And you go on to say that you have no information regarding other utilities. My question was just, what was the nature of that confirmation you received from the Texas Gas Transmission Pipeline and the Tennessee Gas Pipeline?
I will give a general response, and then if you have specifics, Mr. Sinclair can fill those gaps in for you. Was quite simply, as it says, there was incremental capacity available on their system, or obviously they map it out, they know what's available, what's going to become available, what people have told them about, not continuing to renew gas service on their system. So my general impression is we've had discussions, we believe we'll be able to buy firm gas service on each of those pipelines.
But Mr. Sinclair would have more detailed information?
Yes.
Okay. And you mentioned earlier regarding the reserve sharing agreement with TVA. The companies are in a reserve sharing agreement with TVA, correct?
Yes, as it relates to spending reserve.
Yes. Are there any other entities in that reserve sharing agreement?
No.
Sorry, Mr. Mr. Beller, when you say spending reserves, are you referring to contingency reserves?
Daily operating reserves that we have to maintain on the system that are specified by NERC with respect to how much capacity. I think it can be both online spending and 10-minute quick start. And so it's the daily reserves. It's not, long-term generation planning reserves was the distinction I was trying to make.
Right, but is it operating reserves equal to the single largest systems contingency?
It would be if you're not part of a reserve sharing organization, yes.
And then it's just your portion of the biggest unit on the system?
It would be the combined system, and yes, it would be our portion pro rata based on the capacity we provide with respect to the capacity we have on our system versus TVA's capacity, yes.
So those are and the reason I ask is but I've got lots of questions about the TikTok, effectively, that you all, provided through Discovery, and there's a portion in there that talks about CRSG. Those are the reserves that you're talking about, those operating reserves?
Yes,
okay.
I think so.
Do you coordinate with TVA at all with respect to planning generation?
We would inform them of decisions that we make, but there's no coordination with planning generation with TVA. Obviously, if we are adding generation and doing transmission service requests, our IT independent transmission operator would, if needed, coordinate with TVA, but there's no active planning with TVA.
And do they inform you of their plans with respect to generation?
Not other than what we would be aware of through transmission studies that we're asked to do for affected system studies and things of that nature.
Do you have any idea, just based on either your interaction with TVA or just based on general knowledge, whether TVA is looking to build new natural gas combined cycle or CT units within their service territory?
I do believe they're building natural gas units. I read an industry article about a pipeline they're looking to construct to serve one of their units, but I wouldn't know all the details.
Do you know what the extent of the capacity that they're planning on building as far as gas?
No, I don't have that number.
given TVA service territory, would you expect them to be sourcing their gas from the Texas gas transmission pipeline?
I'm not familiar with what pipeline system they would be sourcing from.
I think in a response that Mr. Wilson gave, he had indicated that EPA, or I'm sorry, no, this was actually in response to staff's 5th request, item 2, which I think you were one of the responding parties to. On page 16 of that response, you all discuss the fact that your all's plan is consistent with projections made by the EPA that there would be new natural gas units of approximately 3,173 megawatts in the reference case and 2,886 megawatts under the new GHG rules.
Yes, I see that.
Have you heard any talk of, assuming that level of, there was gas built, and that's just talking about in LG&E's balancing area, correct?
Yes.
So that wouldn't include territory served by TVA in Kentucky or territories outside of LG&E's balancing area in eastern Kentucky?
Correct.
So just with that, additional gas transmission capacity or gas generation, has there been any discussions about whether or not a new pipeline would be necessary, to serve that load in addition to, other load, of other natural gas units that are expected to be built as a result of the GHG rules?
Yeah, I'm not aware that EPA did any analysis to support, the addition of this additional gas capacity, because not only would it have been added in our balancing authority and their modeling, it likely, even though we didn't study other areas, likely been added in those areas. So I'm not aware of any analysis that's been done to support that level of gas infrastructure. That's actually one of the comments that we make with respect to existing sources, particularly in our 111 comments, is that assuming that you could co-fire existing coal units, where's all the gas infrastructure going to come from, and was that evaluated? So it's clearly a challenge to look at that much incremental gas capacity, particularly on our system.
So with that, if they were building that amount, or if that amount was being built within your balancing area, in addition to the surrounding balancing areas, it is the company's position that there probably would be some issues with respect to the supply of natural gas, given the existing pipeline infrastructure.
I wouldn't foresee the existing infrastructure to be able to serve that load based on the conversations we've had with the pipelines. Again, as we talked about a moment ago, they have sufficient capacity to serve the units in this case, but we haven't gone beyond that, but I wouldn't have any expectation that they'd have that much gas. But we clearly hadn't asked that question. They'd often have to expand their facilities, whether it be new pipeline, new compression, or otherwise.
In talking to the pipeline companies, did they give any kind of indication as to the extent to which they would have the capacity to serve new natural gas units?
I'm not aware of those conversations. Mr. Sinclair may have, delved that deeper into that and could give you insights if they did share that with us.
Okay, thank you. I was looking at your response to LG&E, or your response to staff's second request for information, item 55. And it's about transmission projects that would be necessary.
Yes.
And, you were asked a question about voltage support in the event that Brown 3 is retired. And you referred to this confidential document, the generation replacement and retirement scenarios, expected impacts on the transmission system, which was provided as part of I think, saw Exhibit 2, or
Yeah.
saw 2. I wasn't going to ask about, I know that that document is confidential. I wasn't going to ask about the specifics of the cost in there, other than what's reflected in the response to the request for information, which is public. But if you feel that I'm getting into something that should be confidential, please let me know.
Okay.
In the response there to item 55, you indicate that the document, the report, discusses transmission upgrades that would be necessary in various scenarios, including a scenario in which Brown Unit 3 is retired and the proposed Brown NGC unit is not added. And my reading of it is that those are the projects listed in that report are the projects that would be necessary to avoid voltage issues and other issues serving load. Is that correct?
Correct.
I guess to avoid thermal overloads and voltage support issues.
Correct.
And the analysis that was provided in that confidential document you put here on 55, it assumed that both Cooper Unit 1 and Cooper Unit 2 were online, but did study the loss of Cooper Unit 1 and Cooper Unit 2 individually as a contingency scenario. Correct?
Yes.
So it studied the loss of one of those units, but not the loss of both. Is that correct? And I can scroll down. I think you actually say that below here.
Yes, correct. We studied those individually. And then, well, if we go on to say, we looked at them individually, and then we say, or I say in real-time scenario where Brown Unit 3 is retired, the proposed Brown natural gas unit is not added, and neither Cooper Unit 1 or Cooper 2 is available, that we would have voltage supports, and we may have to look at operating procedures, which is also a method that can be used to comply with voltage or projected voltage issues. And we go on to explain that more fully.
Yeah, and I had some more questions about that, but I actually wanted to switch up to item 53 here, which is a similar question, but it just asks about the costs. And I'll just show you and Mr. Wilson had responded to it. But I'm looking, so in response to B here, and I'll scroll up. I'm sorry. I'm sorry, there was C. It says provide transmission system upgrade costs projected in the same manner as Table 35, which is referring to the SAW 1, and itemize as requested in subpart B if Mill Creek Units 1 and 2 and Brown Unit 3 are retired and NGCC is added at Brown. And you indicated and perhaps this is a question for Mr. Wilson, but you indicated that in that scenario that the cost would be $988,700. So if there's no, if the NG, that scenario is assuming that there's no natural gas combined cycle unit built at Mill Creek, correct?
Roll back up.
Do you want me to scroll up?
No. Yes, that looks to presume, I don't know if there's any modifier, Rick, go up to the.
Yeah. Okay. It refers to the scenario. I was just trying not to pull up the confidential document. I can do that if you would prefer that.
No, that's fine.
Okay. Because it does lay it out, I think, more explicitly. So, and that $900,000 is what would be necessary to basically operate Ghent 2, operating year-round, and then a natural gas combined cycle unit at Brown, with Brown 3 retired and Mill Creek 1 and 2 retired. Is that correct?
Correct.
And if you look at subpart B, it says, in response to subpart B there, it says, in this file, capital costs for projects identified in the document responding to Part A were escalated $28, retiring Mill Creek 1 and 2 and Brown 3 while only building a natural gas combined cycle or SCCT generation at Mill Creek creates the need for transmission system upgrades with a capital cost ranging from $39 million to $52 million. So that's basically saying if you only built a natural gas combined cycle unit at Mill Creek and you retired Mill Creek 1 and 2, kept Ghent 2 open, operating year-round, and then also retired Brown 3, that you'd have to spend $39 to $52 million on transmission upgrades.
Correct.
There are several points in response to request for information and in exhibits where effectively the companies say that, and in fact I think they might say it right here, but basically that you all looked primarily at putting a natural gas combined cycle unit at Mill Creek if you were only going to build one. And I guess my question is, why do that if you can save $50 million in transmission costs by putting it at Brown?
Well, you'd have to look at the total capital cost of installation of the combined cycle, not just the transmission cost. You would also look at what units you could retain, depending on the scenario you were in. Obviously, Brown 3, as was stated earlier, can continue to operate. We don't see any on the near-term horizon, 111D set aside for a moment, affecting the operation of that unit. So you'd have to look at it holistically in terms of the total installed cost.
So was the decision to, if you're only building one, was the decision to put it at Mill Creek associated with the need to continue operating Brown 3 because it does have SCR?
No, I was saying you could continue to operate Brown 3 in that scenario, whereas Mill Creek 1 and 2 would require additional investment, SCRs and otherwise, to operate. So you would have to look at that and determine what the least cost would be. Transmission would be part of that decision. And obviously the installed cost of the two combined cycles there's a cost difference between installing the combined cycle at Brown and installing the combined cycle at Mill Creek. If I believe the Mill Creek combined cycle is a lower expected installed cost than Brown.
Okay.
I'm sorry, I still don't understand why Mill Creek is preferable when talking through these as opposed to Brown.
Well, let me find.
Because I'm with Mr. Bellamy. When I read all the responses in combination, it basically sounds like if we're only given a CPCN for one combined cycle, we want to put it at Mill Creek. Is that wrong? Is that not how I'm supposed to read the responses in totality?
It depends on the scenario if that you're talking about here in terms of an alternative. It depends on what units we're allowed to retire via Senate Bill 4. But if we were to build one combined cycle, we would prefer to put it at Mill Creek, retire Mill Creek 1 and 2. Mill Creek 1 and 2 would require incremental investment. There may be a difference, as we pointed out, in transmission costs, but there's also a difference in construction costs of the construction for Mill Creek 5 versus Brown 12. All that leads us to say that we would want to build it at Mill Creek. If we were to build one, and avoid the construction, the installation of SCR on Mill Creek 1 and 2. Again, depending on what the scenario is, could we continue to operate Brown 3? We could do that without incremental investment. Obviously, we'd have to make ongoing investments that we've talked about.
Yeah, so all those scenarios that you all looked at, the transmission cost difference between all the different retirements and locations, did those assume the Brown BESS?
No, I do not believe they did. It's in the queue to be constructed. I do not believe, we can do that as post-hearing data request. I'm not aware that it was, but we can check.
Because they weren't just about combined cycles either. A lot of them ran, I don't think this is confidential, but different types of units.
Yeah, exactly, yeah.
Okay. All right, go ahead, Mr. Bellamy, sorry.
And that was actually, and I think you just answered that, and if this is confidential, then, by all means, let me know, but the scenarios that are discussed here and referring to the confidential document, did those include, you were just asked about Brown Best, but did those include any of the proposed solar additions?
I'm not aware that they did, but we can definitely provide that. I would want to provide that as a post-hearing data request.
So we can do that as a post-hearing. And this might be the same response, but when the transmission scenarios were ran, did they anticipate the retirement of the 3 simple cycle units that you are seeking to retire?
We can include that in the request.
Okay, I'll just do a post-hearing for that.
So I just would like, in the additional post-hearing, make sure that we have an appreciation that there were no differences, that there was nothing studied that was different than it was explained in the executive summary of the November 18 generation replacement retirement scenarios, expected impacts on the transmission system. But the TPL studies, N-1, contingency studies, whatever it was, were accurately reflected in the executive summary.
Yes, yes. Yeah. And I think the full of the analysis provided to generation planning by transmission group was included in the record also. Yes.
You were asked earlier by Mr. Kurtz about the possibility of building the Mill Creek natural gas combined cycle unit with the Mill Creek units there and without retiring them, and the possibility of building the Brown natural gas combined cycle unit while keeping Brown 3 open. And I might have misheard you with respect to Brown. You said that Brown 1 and 2, you're retiring Brown 1, or Brown 1 and 2 are being, I guess, decommissioned, and the natural gas combined cycle unit would effectively be put in the same place that they're in right now. Is that correct?
So Brown 1 and 2 are not in service. They've been retired. We would demolish those units to provide construction margin so that we could build the new unit and not interfere with the operation of Brown 3 while the new unit, Brown 12, is being constructed.
And Brown 1 and 2, what was the nameplate capacity for those 2 units?
Brown 1 was around 100 megawatts. Brown 2 was around 160.
Okay, so that's why you weren't sure whether you could add a 600 megawatt natural gas combined cycle and operate both that and Brown 3.
Correct. The sum of Brown 1, 2, and 3 is very comparable to Brown 12.
Would it be possible, with the transmission study that was done, would it be possible to look at, using the assumptions in that confidential transmission study that was provided, what kind of additional transmission capacity might be required to operate the natural gas combined cycle unit at Brown with Brown 3 still operational?
Yes, we could do that evaluation.
Okay, I'll put that in the post-hearing data request. I guess I don't know that I'll put this in there, but would you be able to do the same thing with Mill Creek?
Yes.
Okay. So I might put that in there as well. Earlier, when you were talking about reliability and resiliency, and you were questioned by Mr. Kurtz and the chairman regarding, and I don't want to get into what the legal standard is in SB4 for reliability, because I know what arguments have been made in SAW 1 and, you know, what suggestions other people might have made. But you kind of talked about looking at the baseline. And I know when looking at, and this might be a question for Mr. Wilson, but when looking at reliability and calculating LOLE, I think the companies were looking generally at 2028 for the baseline, you know, based on that being the year that the Good Neighbor Plan was expected to go into effect, such that the existing units may need improvements in order to continue operating. Is that correct?
So we did look at 2028. That's included, tables included in my testimony, laying out that analysis in 2028. And we did that because both of the new units that we're looking to build in this proposal and the retirement of the existing units would have already occurred. So it would be the new system, the system we're proposing. So that's, if that answers your question, that's the way we evaluated it.
Yeah, and I didn't really have a question necessarily about that, but what I was wondering about, you kind of talked about looking at the baseline and whether or not that's the standard or not. You know, you talked about looking at the baseline and comparing the baseline to how the new system would operate from a reliability perspective. With respect to the current system, would you consider the baseline to be the coal units, specifically Mill Creek 2? Let me just refer specifically to Mill Creek 2, just for ease, because I know there's some differences in what the units may need. But for Mill Creek 2, would the baseline be Mill Creek 2 without an SCR?
No, because as we started off this line of questioning, we looked at 2028. We assumed in the baseline for our analysis that given the units that we plan to retire, that Mill Creek 1 would be operating with all the necessary enhancements. Mill Creek 2 would be operating a full year with all the necessary enhancements. We assumed that we would comply with the Good Neighbor Plan through continued operation of existing assets.
So are you talking about what you did in Exhibit SAW or Exhibit SB41?
The analysis is in SB4-1, page 14, table 5. That's one version of that analysis, how it's laid out.
Okay. And in that analysis, when you say no retirements, you're assuming that those units have all the environmental systems added to them.
Yes, because of the need to comply with the environmental rules and maintain reliability of the system.
And you can tell me if this is a better question for somebody else, but do the companies have a position as to whether or not a CPCN would be required for an SCR on Mill Creek 2 or Gent 2?
Most definitely. We would likely couple that with an ECR filing if we were to move in that direction.
Okay. So that was sort of my question about the baseline. I was just curious if the baseline would be, from a reliability perspective, Mill Creek 2 and Gent 2 without an SCR, and then operating those to the extent you could, you know, under the Good Neighbor Plan, assuming that the Good Neighbor Plan was effective.
Repeat that, please.
I guess the question was, if you needed a CPCN to add SCRs to Mill Creek 2 and Gent 2, would the baseline from a reliability perspective be to look at
Mill Creek 2 and Ghent 2 without an SCR, and then looking at, because you're looking at whether to add an SCR or to build a natural gas combined cycle unit. So would the baseline be Mill Creek 1 and Mill Creek 2 without an SCR and operating to the extent possible under the environmental regulations that you would expect to be in place at that time?
So we looked at the baseline. If you think about our baseline, we looked at Mill Creek 1. I may have misspoke. Mill Creek 1 retired in 2024, and then Mill Creek 2 with an SCR, and then Gent 2 with an SCR. That was our baseline. And that's what we think would be the counter to a denial of the actions we plan to take in this case, and obviously the continued operation of Brown 3. No additions for that, as we've been discussing.
With respect to Mill Creek 1, the retirement of Mill Creek 1 in 2024, the decision, you indicated in your testimony in 2023-122 that it was a decision that was made in 2020-00061 regarding the environmental compliance plan at that time.
Yes.
And you referred to Project 31, and I think you testified earlier too that the reason that decision was made is because it was going to, the opinion was that it was going to need a cooling tower and ELG water treatment facilities. And because, is that correct?
Yes.
And because it couldn't operate simultaneously with Mill Creek 2 because of the agreed order with Louisville, it was determined not to be cost effective to add those improvements. Is that correct?
Correct.
So it wasn't a situation necessarily where there was, you could add those environmental improvements and then, or alternatively have replacement generation. It was that unit actually wasn't operating at full capacity already, and it was determined not to be cost effective to add the environmental controls, correct?
That was part of the decision-making in that case. Of course, we didn't have the Senate Bill 4 requirement in that case.
Mm-hmm. Could you just explain and what the agreed order requires specifically?
So what it requires is that on a daily basis, that the total Mill Creek station doesn't emit more than 15 tons of NOx a day. And so effectively, if you do the math, that requires us to meet that daily criteria to, if we are operating Gent Unit 3 and 4, that we limit the operation of Mill Creek 1 or 2 during the ozone season. There are emergency provisions allowed in the contract or in the agreement that if we need to operate it for emergency purposes, we can do that, operate all the units, and we wouldn't obviously compromise daily reliability.
But there's no trading or anything like that. It's just a hard limit, and that hard limit prevents you all from operating both at the same time, basically?
Yes.
Okay. You mentioned earlier a hard limit with respect to the Good Neighbor Plan that will go into effect in 2030.
Yes.
And I think you answered this, or you at least provided an explanation that seemed to answer it, but
is it correct that that hard limit would effectively require any unit to have an SCR to continue to operate? Is that the company's opinion?
Yes, the daily backstop limit, I think, is 0.14 pounds per million BTU of NOx. It's a relatively instantaneous value, not a daily value. And an SCR would be the only thing, technology available to consistently operate below that limit.
Oh, so it's not an accumulated amount per day. It's in any instant you can't produce that much, and the only way to do that would be with an SCR, in the company's opinion.
That's my understanding. Mr. Ember could, talk more in detail about how the EPA would plan to institute that daily limit, what the monitoring and averaging period would be. But it's my general understanding that it requires an SCR operation.
When you were talking about the company's, or PPL's carbon plan, and I think there was a question about, taking the natural gas combined cycle units out of service in 2050. And I think you answered something to the effect of, if the right thing to do is to continue operating the units, then the company would continue to do so. And you may not even remember this at this point, but are you essentially saying that if the, and I don't know what the law will be at that time, obviously, either, but, assuming that the law requires, assuming that environmental regulations wouldn't prevent them from continuing to operate, and the law requires just a least cost analysis with respect to selecting generation, is that essentially what you're saying, that the companies would, if it made sense, the companies would continue to operate it from a least cost perspective?
Yes, and that was to, kind of augment the conversation that was had earlier, that 2050 net zero goal is not an input into our analysis. And I wouldn't anticipate it to be in the future. Obviously, as you said, laws and regulations will change in that intervening period, but as I said here today, I wouldn't envision that being an input to our process unless it was also accompanied by a law that required it.
And this question might be better for Mr. Ember, but does the EPA look at new and existing source performance standards every 8 years?
Yes.
Okay, so when would be the next time you would expect them to look at them?
Mr. Ember could probably speak to that date, but obviously they're looking at them now, so 8 years later, but I would leave it to him to give you the precise clock that would be ticking on that 8-year time period.
Does the company's carbon plan envision continued risk of further carbon regulation? I guess I know you say like you wouldn't plan just based on the carbon plan, but I guess is the carbon plan kind of reflecting where the companies expect the market to go?
Well, I think it's fair to say when our company established that net zero goal in 2050, that was in line with what a large number of other, or very similar to what a large number of other generation producers across the nation were providing as commitments. So in that sense, that was somewhat envisioned of where the system would be. From that perspective, I would agree that it was somewhat visionary based on what the industry was looking toward at that period of time. And whether getting there through natural addition of lower carbon resources or forced to get there through regulation or a combination of both.
So do the companies anticipate, and you can tell me, to ask this to a later witness. In fact, I think I will withdraw because you said Mr. Ember would be the better witness, so I think I'll just save it for him. All right, I don't have any more questions. Thank you.
Vice Chair?
I don't have any questions.
You don't have any?
Mr. Feller. Surprise, surprise, I do have a couple of questions. Let's take them in sort of a, well, before I start, I'm sorry, I do want to do a housekeeping before we end today. Ms. Huddleston, would you like to, I know it's already on the record, but would you like to move to introduce your Winter Storm Elliott, the TikTok, the 9-page exhibit?
Yes, I would, Your Honor.
Okay.
No objection.
Mr. Riggs, okay. All right, housekeeping out of the way, Mr. Feller. In 2017, are you generally aware that, well, in 2017, are you aware that the companies, LG and EKU, filed an application with the commission to just use a colloquial term here, but get rid of the majority of the company's demand-side management programs?
Yes.
Okay. I think that was 2017-441. Does that sound, I know, I probably, yeah, you have other things to do. So, but you didn't provide testimony in that case, did you?
No.
Yeah. I think Mr. Huff provided testimony in that case, who I think is now retired from the companies. Is that right?
Yes.
Congratulations to him. So, I didn't mean that to be, that was a sincere congratulations. His testimony was alongside witnesses Lawson and Lovecamp. Does that sound about right?
Yes.
Okay. And do you remember, as a general matter, that the primary reason for the company's proposal was, well, I'll read you a quote from the witness Lawson's testimony just to see if you remember this. The company's most recent annual 30-year demand and energy forecast and resource plans project relatively flat demand and sufficient generating capacity over the next 30 years. Therefore, the companies project no significant investments in new generation, which indicates zero avoided capacity cost benefits from DSM-EE programs. Does that sound familiar?
Generally, yes.
And I don't mean familiar from the testimony, but just, is that your understanding of where the company felt like it was in 2017?
Yes.
Okay. And due to the zero avoided costs and low, relatively low, zero avoided capacity cost and relatively low avoided energy costs, because those are inputs into the calculations of the tests you were talking about earlier, DSM programs didn't pencil out. Is that fair?
Correct.
Okay. So that was in 2017. I looked up, the commission entered the order in October of 2018 in that regard. Then in 2020-61, that's where we've talked about Mill Creek 1 being discussed, right?
Yes.
Okay. And in Mill Creek 1, in 2020-61, the only change effectively from the 2017 441 case was effectively that the companies expected Mill Creek 1 to retire before 2025 due to really the expectation of the non-attainment, right?
Right, and the obviously prompt case in that was to add effluent limit guideline controls to the Mill Creek station.
Right, and I guess that's a much better way. That you all chose not to propose in Project 31 a CPCN for Mill Creek 1 to comply with the LG, just the other 3 Mill Creek units, because of the expectation that, because there were going to be intervening, non-attainment situation, intervening issues that caused the unit to retire in 2024/2025 anyways. Is that right?
Correct.
Okay. Now, and I don't have a quote from it, but was it your understanding that around that time the company's position was basically that given your all's load profile and everything that was going and every new thing that is sold is more efficient than the thing it's replacing, that kind of stuff, that you all expected to be able to retire Mill Creek 1 without the need for additional generation.
Correct.
Okay. Then, the commission, in granting that CPCN, specifically discussed the fate of Mill Creek 2. Do you remember that?
Don't recall that specifically, but.
Okay, and just a quote from the order, it speaks for itself, but LG&E should use all reasonable efforts to delay Project 31 until the fate of Mill Creek 2 is more certain. If LG&E determines that Mill Creek Unit 2 will be scheduled for retirement before 2025, at any point before Project 31 must begin to avoid noncompliance by the December 31, 2025 deadline, then it should request a CPCN for a revised Project 31. And the reason I ask you this, not because you were testified in 61, Mr. Wilson did, but I did ask you to go back in a case in the last couple of years, to go back and watch that discussion in that hearing. Do you remember that?
Yes.
Okay. So, at that point, at the end of 2020-61, did, other than Mill Creek 1 expecting to retire because of the non-attainment, and because it was not going to be LG compliant, at that point in time, was anything different from Mr. Lawson's testimony in 2017-441? That the companies do not expect any new generation in the next 30 years because of declining or I want to get the term right, relatively flat energy forecasts.
So, obviously, you read the quote, and not debating Mr. Lawson. I would have thought in 2017 that we would have anticipated units reaching the end of their useful life. I don't know the case in its entirety or whether that was part of the discussion or part of that quote. At that time, we didn't have any definitive construction plans. I would appreciate that. But I don't know that we would have said, we would have had an active IRP at that point in time. But that's the part that is throwing me off a bit in this line of questioning, that we would have not recognized in that time period that we would have had units reaching the end of their useful lives.
Yeah, and I want to be as helpful as possible, Mr. Beller. So let's just rip off the Band-Aid here. Let me know the screen on your right-hand side. Ooh. Okay, screen on your right-hand side. Do you see that?
It doesn't appear to be on, but I can.
Well, that's been very unhelpful through the entire.
I turned
we put
it
it
on.
there specifically for your benefit. Okay. All right. Do you see in the middle it says 0 avoided capacity benefits?
It's coming on.
Do you see it up there at least for the time being until the one in front of you comes on?
Oh, now I can see it. It's
Okay.
just a slow response. So,
All right, hold on one second. Do you see Exhibit GSL-1, page 9 of 182? And I was going to actually print this, and then I realized it was 182 pages. Okay, so just a quick, do you see the URL at the top, the website?
oh, yes.
Okay, so that's it's the PSC's website. Then the case number 2017-441. Mr. Lovecamp uploaded it, I think all the other numbers are internal to you all.
Mhm.
But this is, and I'll go to the just very quickly. This is the Louisville Gas and Electric Company and Kentucky Utilities Company 2019 through 2025 Demand Side Management Energy Efficiency Program Plan, Exhibit GSL-1. you see that?
Yes.
Okay, so on page 9, I'll give you a chance to read that entire paragraph on zero avoided capacity benefits. You let me know when you're done.
Okay, finished.
Okay, so I'll ask you a question, a big picture question. After having read this paragraph, and just assume for a second that I knew that this existed, does the level of the questions that I had in the 2020 environmental control case and the 2020 rate case with your LEB, I think maybe it was LEB 1, but your retirement scenario, and probably the integrated resource plan in 2028. Do the questions that I asked make a bit more sense juxtaposed against what the company was saying in 2017?
Yes, in the sense that this paragraph says that we would not have generation capacity needs over the next 30 years, and as stated a moment ago, surprised me in the sense that units do reach the end of their useful life, and there was no recognition of that in this statement.
Okay, so 30 years from 2017 would be 2047, is that right?
Correct.
Okay. I'm going to stop sharing for a second. And then we'll quickly bring up SAW 1 from a completely different case. Mr. Wilson certainly is earning his pay. Do you see the depreciation retirement years on this page?
Yes.
All right, and this says redacted. This is the public version of this, but this is from SAW 1 again. We can go to the URL at the top. This is from the 2020-61 case. Do you see that?
Okay.
And that case is part of the record in this case. This is technically already in this record. But this is table 3 on page, 6 of 41. And this is kind of the question that Mr. Kurtz asked you earlier. This is the depreciation retirement year, right? I pre-said it before. This is the year in which you all were depreciating, assuming that was the economic life of generating units, right?
Correct.
Okay. Now, this would predate your LEB 2 that you did in the 2020 rate cases, right?
Correct.
Okay. Mill Creek 1 has a retirement date of 2032. Mill Creek 2 had a retirement date of 2034. And I'll just go down these real quick. 2038, 2042, 2034, 2034, 2037, 2038, 2050, 2066. Just a direct question here. Other than the 2 Trimble County units, would you agree that all of these units were expected to be retired within the next 30 years from 2017?
Most definitely, their depreciation retirement years were set at that. Obviously, as you appreciate, we would do a further analysis, but yes, that was the baseline assumption at that time.
Okay. And did you have any reason to believe in any of the positions you've held at the company, either in your current position as COO or Vice President of Operations, which I think 2017 might have been around the time you moved into the COO position, that the company would be expected to retire any of these units in any of these years without a need for replacement generation?
Collectively, we would have always considered a retirement as an opportunity to evaluate whether we needed, this is pre-Senate Bill 4, whether we needed to replace that asset. In the case of Mill Creek 1, we came to that conclusion, but I wouldn't have had an impression that we could have walk through this progression of time that you just took me through and not replace any generation, if that's the root of your question.
That's my question. Could you have replaced the entirety of Mill Creek and the entirety of Gent and only had Cane Run 7 and 3/4 of Trimble 1 and Trimble 2 and run your system? Did you ever envision that in some outer 2047 scenario?
No.
Okay. So fast forward from this, which was provided to us at the beginning of, I think March 31st of 2020, because our URLs are very helpful up there after this was filed in March 2020, I think. Then in the rate cases, and I'll stop sharing for just a second because I want to bring up this particular page. In the rate cases, you provided LEB2, right?
Yes.
Okay. And in LEB2, you proposed to update some of the retirement dates. Is that correct?
Yes.
Okay. Now, I just want to make sure I have an appreciation. We were talking about a second ago, and I get that you said, we'll reevaluate that chart we saw a second ago, but that's just the depreciation. That's what you were effectively trying to do, though, with these updated retirement years, correct?
Correct. To correlate in the rate case these retirement dates with appropriate depreciation schedules that would reflect those retirement dates.
Okay. Okay. 15 years, which is the ordinary time horizon for an IRP, right?
Yes.
Okay. 15 years from that 2017 testimony we saw a second ago, Mr. Lawson's Exhibit GLS 1. 15 years from 2017 would have been 2032, correct?
Yes.
The time you did this study and finished this study, wrote the report in October of 2020, how many of the units did you update for retirements within that before 2032?
In this analysis, is that what?
In this analysis, yeah. So how many of these updated, just look real quick, which of the updated dates are within 15 years of 2017?
We would have updated, if 2032 is the outer date, we would have brought Brown 3 in, we would have brought Mill Creek 1 in, Mill Creek 2 in.
Okay. Gent is not in this. Would you agree? Gent, I'm not Flemish. Gent isn't updated as part of your LEB2, correct?
Correct.
Okay. When did you know that Gent's retirement date needed to be something earlier than it was currently being depreciated in rates?
At 2034, that's the what I believe the current retirement date. It would have been when we started our analysis of the Good Neighbor Plan compliance and what would be the optimal approach for that. And would we add an SCR and continue its operation to 2034 or perhaps beyond, or would we, as we have in this case, recommend its retirement? And then update that date to the retirement that would be consistent with our analysis.
All right, so just to be clear, taking a big step back, that would have been just in immediate anticipation of filing this case.
Correct.
Okay, so you just had an IRP in 2021, right?
Correct.
Okay. Were the retirement of your generating units in the integrated resource plan hard-coded for retirement or chosen economically? Let me withdraw that question. Did the model pick the economic retirement dates of generation retirements in the IRP, or were they hard-coded to the dates that either you updated with LEB2 or that the companies were currently depreciating the units over?
I do not believe the IRP tried to pick a retirement date for those units, but Mr. Wilson can provide detail on that.
I don't think they were either. So I don't think you're wrong. But within the 15-year horizon, they were. Is it your understanding or memory at least? If you have no personal knowledge, it's fine. I got lots of questions for Mr. Wilson I can add to the list. Do you expect, or is it your understanding that within the 15-year time horizon, anything that was planned to be retired in those 15 years was hard-coded to those years that they were planned for?
As I said just a moment ago, I do not believe that they were optimized or somehow picked in that evaluation, but Mr. Wilson would be best to talk about the details of that.
Okay, so why wait until a CPCN? Why wait until it's looking you in the face to make these decisions, right? Either upgrade, do whatever the environmental compliance upgrade is, or retire. Why wait then to figure out when the economics suggest a retirement, as opposed to doing that in the integrated resource plan? Just from like a big picture conceptual perspective.
Well, as we've talked about before, a CPCN is different than an IRP. It's when, at least the way the IRP exists today, I'm not saying that it couldn't be changed, and if we are looking at real-time prompt decisions with the necessary data that we believe is necessary to support that decision, that is a time frame to make those decisions. You could change the IRP and assume every unit was retired, at a particular date, and based on what I would call more hypothetical information out in the 30s and the 40s for those replacements, and do that exercise. You could do that. That's not necessarily how we've chosen to look at IRPs. The IRP history, as you know, was filed at a time when load was growing and generation capacity was being added at a fairly regular sequence. Only until recent years have we had such a flat load profile that an IRP wouldn't naturally, through normal load growth, require new capacity additions. So I don't know if that's helpful to answer your question, but.
Yeah, it's helpful, but I mean, these rulemakings, let me ask you this way. From the positions that you've had at the case, was it a surprise to you when you found out that the good neighbor rule was being updated?
No, it is obviously a sequence and a requirement that that be looked at in subsequent, I think it's 5-year increments in NAAQS. This is all based on the 2015 NAAQS standard.
And that's what, I guess there have been previous ECR cases where I found, I think it was the 16 one, where there was discussions about the fact that you have three units across the system that don't have SCRs, and that's a consideration that has to be taken into account in determining which upgrades to make to these generators, right?
Correct.
Okay, so it wasn't like you all weren't looking or weren't considering the risk that future compliance costs existed, but you only looked at that risk in the context of intervening, usually ECR cases, right? CPCN analyses. That wasn't a risk you all looked at in IRPs, right?
Not explicitly. Again, Mr. Wilson will be more familiar with all the nuances of the IRP.
Yeah, but if it's good for the goose, why is it not good for the gander? If it's a risk that you're taking into account when you're going through in each specific integrated resource plan, and you guys were on a cycle with the ECRs, right? Every 2 to 3 years, I think for a couple of years it was $1 billion a year that you had environmental compliance plans for, right? It was a lot of money at least.
Correct.
Hundreds of millions of dollars on an annual basis. You guys were modeling these in incremental, the risks that there would be future environmental costs in each incremental CPCN, but then when you were looking at the system on a wholesale, I don't mean wholesale, but on a holistic basis, none of those risks were necessarily taken into account. Would you agree with that?
In a broad sense, we didn't attempt to predict when Gent 2 would be caught in what the Good Neighbor Plan wasn't even a term, but CASPER or some of those transport rules, to say it more generically. Yes, we did not try to predict when Gent Unit 2 would have been, in my simple lay terms, caught up in that, either a SIP or a FIP, in this case, compliance plan. And we didn't try to predict that, even though, to your point, we were aware that that would be a possibility. We did not put that in the IRP. But, obviously, we're making decisions now, or attempting to make decisions associated with the actual, in this case, the federal implementation plan.
And that's exactly what I want to get to. Now, I've got a couple questions, and then we'll rest for the night, and I've got some follow-up in the morning. Doing that, or doing it in that way, right? Knowing that a risk exists, but because it's not definitive, you're not necessarily taking it into account when you're doing holistic planning. That runs the risk of created stranded costs. Would you agree?
Help me understand in what way.
If you make an investment that you assume you're going to be able to depreciate over a long period of time, but because of intervening, whatever it may be, intervening regulations or intervening or subsequent occurrences, it doesn't last as long as you thought, right? You buy a new car, you think it's going to last 10 years, you go, oh, that's good because I can levelize the upfront purchase in my mind over 11 years. It only lasts 4, you're like, oh gosh, right? I paid all this upfront cost, I didn't get the benefit over the time horizon that I initially indicated. Here it's a little different because there are people to recover. There's you're a monopoly, right? There's a captive customer base to recover expenses from. But if you're making an investment saying this is economic because we assume this unit's going to run for 10 years with no additional compliance costs, and then a compliance costs show up in 2 years that make you retire it after 3 years total, on hindsight being 2020, the intervening occurrences didn't necessarily, the reality didn't line up with the expectations. Would you agree?
So, to kind of deconstruct that question a bit, I agree, implicit in your question, that the timing and pace of environmental regulations are hard to predict with any precision. They vary based on administration and so on and so forth. And if we make an investment, I know in the last many years, given the increased uncertainty of those environmental regulations, we've attempted to look, and we did it in some of the material in this case, how long would that investment have to operate to cost justify? That is a recognition, to the point I think you're bringing up here, is that it's highly uncertain. The challenge, of course, is if you were to alter a significant opportunity to save customers money today based on something you think may happen 10 years from now, while it may be interesting to evaluate that, that's a hard decision to make, because if that other shoe doesn't drop in 10 years and you've taken a higher cost option today, that's the flip side of what you're talking about, right? Yeah. That's the opposite of that, where in that 10-year decision, you would have liked to have known that when you made your decision today. So we have to look at both sides of that, and I think the way we've tried to address that in most recent analysis is to look at how long a particular asset would have to operate to be cost justified based on new environmental regulation.
A break even, effectively, right?
Effect. A
Okay.
break even year, how many years would it have to operate? I know that was part of the ECR, even though I wasn't intimately involved with that, both the decision for Mill Creek 1 and Mill Creek 2. How long would those ELG controls need to be in service in order to justify making those investments?
Okay. So two quick questions, and then we can talk details in the morning. Do you believe it would be reasonable, don't you agree it's not reasonable to assume that there's no cost of abatement for the two proposed cane run, or the two proposed combined cycles with relation to the NSPS?
So the one that we have the clearest vision on, should those rules be passed, is the 50% capacity limitation, and we've attempted to structure an analysis around that. I would agree if those rules pass, in their current form, there'd be a cost to not only the 2 new combined cycles, but the entirety of our fleet, and it would be a very significant cost, obviously, and significant operational challenges, and that's, the root of our comments.
I guess what I'm trying to, it's clear from the record to me, and I want to make sure you agree that I'm not just making this up in my head, that you all think that it's reasonable to assume some sort of cost of compliance, even if it is a reduction of the capacity factor of that NSPS. That is some sort of risk to the operating either characteristics or cost of the 2 proposed combined cycles.
Correct, and we framed it as trying to appreciate a no regrets strategy, and we've looked at a whole other host of analyses in the case that looks at different fuel cost scenarios. As you know, we price carbon in and so on and so forth.
Yeah, and I guess what I want to get to is the next step. Do you believe it's reasonable to assume there won't be a higher abatement cost, some sort of compliance cost, environmental compliance cost, just exclusively related to NSPS, 8 years from that initial implementation?
That question was premised on what happens with the current NSPS, correct? If those technologies, as we're arguing in our comments and many of the industry comments, if those requirements are pulled back and they are looked at by EPA in 8 years, I would be more in the camp of agreeing that there could be something different there. If the EPA forges ahead, I don't foresee any new technologies beyond what they're proposing being developed, because I would argue that the technologies they're proposing haven't been developed.
Well, okay. But I think that's a little, that's a qualitative determination, I think, but I'm wanting to make sure I have an appreciation. Do you advocate, or do you believe that we should assume no cost of abatement incremental to the current 50% capacity factor related to NSPS for the 2 proposed combined cycles 8 years from 2024?
Well, again, what I was trying to answer that question in terms of my view is if the current requirements contained in the NSPS 111 rules, meaning hydrogen blending, combined cycle, carbon capture, 50% limitation, if those are actually put in place, that's the premise that I'm making, then 8 years from now, I don't see what there is to update. I don't see new technologies coming along in that 8-year intervening window. If those are put off, that's what part of our comments are waiting, is wait, you have time to wait within, this is talking to EPA, you have time to wait to see if those additional technologies, which we don't believe are ready now in simple terms, stop using all the legal qualifiers.
All right, so I guess just to be clear, you don't think it can get any worse for a combined cycle than 90% carbon capture? Is that
not in the next 8 years.
That's why I want to make sure that's your response. Effectively, you're saying what 90% blending with hydrogen or 90%. What could be more expensive than, or what can be more strict than that? Is that what you're saying? Effectively, I just want to make sure I understand.
Yes.
Okay. All right. It's 8:04. I appreciate Mr. Beller. I do have some more additional questions for Mr. Beller, not much, but we'll follow up in the morning. I mentioned we'd have a hard stop after 8. I feel like it's diminishing returns. we hit 8 o'clock. Again, I just want to make sure, does anybody have an objection to starting at 8:30 in the morning? Okay. The building opens at 8. We again ask everybody to use the door out front. We will start as sharp as we can at 8:30. We'll pick up Mr. Beller, and your next witness will be Mr. Wilson. Mr. Wilson. Poor Mr. Wilson. So, are there any questions, anything we need to take up the rest of the day?
Just confirmation, you're still planning to do lunch at noon?
Can I just ask real quick, hey, we're not adjourned. Could you all just, for a second, please? Thank you.
You still planning to do lunch around noon?
Yeah, we hard stops at noon and at 5 o'clock for dinner. That way everybody can make definitive plans to ensure that we are able to get out, eat, and come back within the 30-minute and 40-minute time windows. Anything else? Okay. We are in recess until tomorrow at 8:30.
Thank you.